Good morning, everyone. We're gathered this morning, September 18th of the year 2020, to start our City of Fitchburg 2020 Board of Review. Present this morning, we have 5 members. It looks like we're going to be in fine shape. So I'd ask our clerk, Madam Clerk, would you please I'll call the meeting to order. Would you call the roll?
Chair Couillard,
Here.
Erica Ryerson,
Here.
Craig Stevenson,
Here.
Elton Krim is absent with excuse, Matt Pulda,
Here.
Rich Tate as first alternate.
Here.
You have a quorum.
Excellent. Thank you, everyone, for the attendance this morning. I realize this is an unusual year. And as I look around, it's strange to see people with masks on in a meeting, but I guess that's the norm today. The next item on our agenda is the approval of minutes of our October 7th, 2019 meeting, and also the brief meeting we held on June 8th to adjourn till today. They were included in our packet. Has everyone had a chance to review them? I see people shaking their heads. Any comments, questions, or additions that we need to make to those minutes? Okay, hearing none, I'd ask for a motion to approve those minutes of both the October 7th, 2019 meeting and the June 8th, 2020 meeting as presented.
So moved.
We have a motion. Do I have a second?
Second.
Motion and a second. All in favor signify by saying aye.
Aye.
Opposed? Please let the record note this is unanimous approval. Next item on our agenda is confirmation of appropriate board of review and open meeting notices. I guess I'm going to reach out to our assessor on that one and ask her, have those notices been properly prepared and mailed as the timeline requires under Wisconsin Statute Chapter 70?
Yes, they have.
Excellent. Next item on our agenda then is election of a chairperson and a vice chair. I've been serving as chairperson, but in case something would happen and I can't be here, and that's also a possibility because I have had a family issue that I have to be involved with. I guess it would be nice if we had someone who could step in and take over if I can't be here. So I'd open the floor for volunteers.
I would make a motion to elect a chairperson, which would be you, and then a vice chairperson. I'm not making the motion, but I'm saying that's.
Friendly amendment to my comment.
I move that we elect a chairperson and a vice chairperson.
Okay. And who would you nominate for those positions?
I would nominate you for chair and Craig Stevenson for vice chair.
Thank you, Erica. Before we put you on the spot, would think you'll be agreeable to that?
Sure, I'd be honored, and thank you for the nomination.
Okay. So we've had verbal confirmation. Hearing that, I'd ask for a vote. All those in favor of Mike Couillard for chairperson and Craig Stevenson for vice chair, please signify by saying aye.
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 Opposed? Okay, please let the record again note that that's a unanimous vote of approval. Filing of and summary of annual assessment report by the assessor's office. Again, we'll defer to the assessor. Have those reports been filed with the appropriate state agencies as required?
Yes, all of the reports have been filed thus far. We do have the annual assessor's report. I have a copy for me and a copy for the board. Would you like me to bring that up to you? Or leave them on the table there?
I guess I'd like to see the copy up here.
Okay.
We can pass it around if the board members would like to look at it.
And do you want the assessment roll in front of you or on the table here? It's a little different here, so.
I guess on the table is fine. I see 3 volumes sitting there. I don't know if we have a good spot to put them up here. If we need to defer to them, we can certainly get them, since they are available in the room.
So there's Book 1 and Book 2 of the real estate assessment roll, and then the personal property roll. And then the other book that we gave Mike is our annual assessor's report that contains in the first couple sections the amount of work that we've done this year, how many inspections we've gone to. It'll include any income and expense that we requested, sales, all of that type of information. So,
Thank you for the report. Appears to be very thorough, just based on the few sections I've looked at so far.
yeah, it's about twice the size as last year.
2020 revaluation was completed. The valuation models were calibrated to account for current market conditions, and you wound up with a coefficient of dispersion at 5.7%. Is that what your target was, or something in that range?
Yes. And some of the reports, because of just the way it automatically pulls out, may have other notes that specify why things may not be the same in the report.
On August 15th, the Department of Revenue published the estimated equalized value for the city of Fitchburg. For the residential class, did you use that as a basis to help you determine whether or not you're going to make compliance under Wisconsin statutes?
Yes, we are in compliance.
Excellent. I'm sure everybody's aware that the assessor has to maintain the assessments within a level of 10% of the state equalized value once every 5 years. Fitchburg tries to maintain that level annually, so we credit our assessor's office for taking the extra step of trying to maintain that consistency as they work on preparing our assessments for us. Was there any omitted property we need to review?
There, in the back of the book 2, there is one correction of error, and that was a double assessment. It was valued, it was leasehold improvements. The property owner first had a personal property account, and then they purchased the building. It had always been filed with their accountant on personal property, so they filed it that way, but then they also purchased the building, and then it was valued as real estate. So that has been corrected.
Okay, so just one correction of error. Any other changes that we need to think about as far as assessment roll?
We had the original assessment roll printed prior to open book, and then we had a new roll printed, which we picked up on Wednesday morning. And we had one late change that is hand entered in red in the assessment roll, and the final totals have been adjusted for that one late change.
Okay,
And a waiver was signed and submitted, waiving their rights to the 30 days.
excellent.
That is Sean Baxter's property, in case you need to know which one it is.
Okay,
And Sean was on the agenda, I think, as the last residential appointment, and he has withdrawn because of that change.
very good. I did get that message that the 5:30 appointment had been canceled. So we've looked at items 8 and 9 on the agenda. We discussed the corrections and the actions taken by the assessor after the open book changes have been properly entered in the roll. Number 10 is consideration request for waiver, request to testify by telephone and sworn written statement or subpoena. We have one indicated for this, and that's the Hy-Vee property. I'm assuming this is a continuation of the appeal that they provided or submitted last year and took to court.
Yes, this is year 2 that they are appealing. Amy Seibel, our attorney, representing the city for the Hy-Vee case. She is on here via Zoom, and we did get a waiver requesting that get waived to circuit court.
And is that in our packet?
It is not, no. That came on September 16th, after the packet and agenda had been created. Would you like to see a copy?
Yes, please.
They will need to sign the waiver if they agree to it.
Members of the board, can you hear me? This is Amy Seibel. I'm appearing via Zoom. Allow me to provide a little bit of background information. You may recall last year was the first year that Hy-Vee filed an objection, and the board issued a subpoena, and a number of documents were provided pursuant to that subpoena. Subsequent to the Board of Review 2019 case, a complaint was filed in circuit court, and so the matter is now pending in circuit court. And so there is no reason to have another subpoena issued this year or to have a board valuation hearing. And so the assessor's office is joining in the request to have the board waive the matter into circuit court, where we will probably consolidate the 2020 tax year with the pending 2019 tax year.
Not surprisingly, I expected this since it hadn't been resolved. And since the Wisconsin statutes require the property owner to appear at the Board of Review annually or submit a request as this, such as this, it's not a surprise that if the case hasn't been settled, that it's a continuation. Do we have any questions of the members of the board as to what this is about and what we're going to do with it today?
No, that's a helpful explanation. Thank you.
Okay, so it's basically sending this off our table and sending it back to circuit court as a continuation of the 2019 appeal. I guess since this is a fairly straightforward form, and the city's representative, and they're representing the city in the court case, has reviewed it. Is correct, right, Amy? You've reviewed this appeal or this form, the waiver?
Yes, we've reviewed it, and it is it the corrected one? I'm not there in person to, they submitted a form, and then I asked opposing counsel to correct a line item on it, and he did correct it and sent it back via PDF. So I would ask that the corrected form be signed by the board if the board approves the waiver request.
And the one you should have should be the one,
The corrected version?
the corrected version.
Yeah, is it pages 8 through, I think, 11 or 12 in our packet?
The copy I have in front of me is date stamped September 16th of 2020 as being received. And there's a line crossed out, and above it is an in-circuit court, Wisconsin statute 7437, Dane County court case, and it gives the case identifier. Is that the correction?
Could you look underneath that? Also, the dates that the objection was filed, that was what was corrected as well. What does it show right underneath that line for the date the objection was filed for 2020?
9/16/20, the original date was crossed off of 5/7/2019, and now it's 9/16/20. And the objection form was completed as also 9/16/20.
All right, that is the corrected form then. That is the correct one to approve
Okay.
and to sign.
Hearing that we have the corrected form and the right form in front of us, I ask a motion from the board to approve this form as submitted so that this court case will continue with the 2019 case being basically added, 2020 case being added to the 2019 appeal.
So moved.
Second.
I have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Hearing none, let the record indicate that this was a unanimous decision to approve this request as submitted through the assessor with discussion with her attorney. set that here so it doesn't get shuffled off and lost. Thank you, Amy, for your help in that, making sure that we had the right form. Nothing worse than sending an improper form to the court and then having to file an amendment to it. The next thing we have is review notices of intent to file objections and the filed objection forms. Consider any request to accept objections that are filed late. Do we have any objections that were filed late that we need to consider?
Yes, there are.
Yes.
There were two people that I believe, one contacted us late yesterday that said they may appear in the first 2 hours, and one this morning that picked up a form that said they may appear in the first 2 hours.
Okay. They may appear, but they may not get much time with us this morning because we have a full schedule.
Amy, can I ask, did those two people file a notice of intent to file an objection within 48 hours of the first meeting of the board?
No, they did not. That's why they would have to appear in the first 2 hours today to ask the board for special circumstances.
Right, they would have to appear and present special circumstances, good cause for not filing, for filing late, and the board would hear that objection then.
Okay, thank you for that update. We'll look forward to, we'll look for the people as they potentially come into the meeting.
There are also 10 parcels that gave intent to file but have not turned in their, that I know of, have not turned in their forms yet. I put together a complete spreadsheet of everything that I know of. If the board would like this, I made copies for everyone. If you would like to see a paper copy, I don't believe it's in any of your packets. I did this late last night for my purposes, but if it would assist you.
So is this item 12 on our agenda, the objections that have not provided complete objection forms, or is this in addition to item 12?
Well, this is a part of that. It's part of number 11 yet. These are people who could appeal. They filed a notice of intent, but they haven't submitted the objection form, completed objection form for us to put them on the schedule.
So there's kind of 3 categories. Those that gave intent, or actually 4. Those that may walk in today in the first 2 hours that gave no intent or did not contact us. Then there are those that gave intent up to prior to 48 hours before the board would meet. And then there are those that filed their objection forms, but it may have errors or incomplete. And then the 4th would be those that filed and are complete.
If you would be so kind to share that with us, I'd appreciate it.
So I welcome other people's thoughts, but one thing that I'm thinking of is, as it appears that we will need to consider deferring action on several other objections. Anyway, I mean, even if everyone on our agenda has a complete objection form, which they don't, we aren't going to have time in one day to get through all of the objections. So if we're already considering whether or not to defer action, what are our options as far as the walk-ins or people who have filed an intent but have not filed objection forms, to deferring those to said later date if we defer item 12?
Well, these people need to give us a good reason as to why. And so as they give us reasons, it's at our discretion
Sure.
as to whether or not we accept those reasons.
Okay.
We had one person who did that last year, and we accepted his. But we didn't have this kind of a schedule set up in front of us either.
That is correct, yeah.
So, I mean, if they have a strong reason why they couldn't do it in the required time frame, we have the discretion to allow them to be put on the schedule. If we don't believe the reason is strong enough, we have the opportunity to tell them, sorry, you missed your chance.
So are we, I guess I'm curious as to if we're not here on item 11, are we reviewing their intent to file forms?
If they're not here, they're out of business. They're out of
Okay.
luck. They had that 2-hour window to show up. If they don't, that means they've either decided not to or they, for some reason, couldn't make it.
And Mike, on the spreadsheet, that was as of 7:30 last night with the information I have. Some of those came in late at the end. So some items under number 12, actually, we did receive their forms late yesterday. And so those dates are on the objection form status. I put the dates in that we received those also for you.
If I might provide some additional background information as to what the law requires, it might be helpful as the board looks over the chart and considers the different categories of objectors at this point. The law permits a taxpayer to file a notice of intent to object or to verbally provide a notice of intent to object within 48 hours of the first meeting of the Board of Review. So there were a number of people, taxpayers or their representatives, that had provided notice of their intention to file. But as of yesterday, or as of the spreadsheet preparation, they had not actually filed their written objection form. Under the law, if they have provided notice of intent to file, they have until during the first 2 hours of the board meeting, so that would be today from 9 o'clock until 11 o'clock, they can provide a written objection form. And they do not have to appear in person before the board, they just have to submit a written objection form. And so for item number 12 on the agenda, that was when the agenda was prepared, that was the list of taxpayers that had filed the proper notice of intent, but had not yet completed and submitted their written objection form, which they have until 11 o'clock today to do. And with the other categories, some taxpayers did file a written objection form, but the form was incomplete. And so the clerk of the Board of Review was going to reach out to those taxpayers and ask them to complete and provide the missing information from the written objection form. And then there's the last category of taxpayers that had filed an objection form, not a notice of intent, but a written objection form, and the form was complete. And what our recommendation is going to be to the board is for those that have the opportunity to file a written objection form within the first 2 hours of today's meeting, that the board, which will be in session all day today, take a look at, in this afternoon session, take a look at whether or not those filings were completed within the first 2 hours. So it's premature right now to know whether they have filed a written objection form because they still have some time until 11 o'clock. And then as far as the objection forms that were filed but were incomplete, they would also have until, I believe, 11 o'clock this morning to complete their objection forms and to provide any additional information that they had not provided before. As with all of the commercial properties, though, there is an overriding consideration that the assessor, and on her behalf, I, as a representative and the attorney for the city, we're going to ask the board to consider the following action once we know the status of the various different objections that have been filed. For several of the objectors, income and expense information was provided last Friday at 9 a.m. They had not appeared during open book to provide information to the assessor. And so this was the first, in several instances, this was the first information that the assessor had received relative to those properties. The assessor's office needs additional time to consider some of that information, and in some cases, issue subpoenas to get additional information because there have not been any open book discussions and any give and take or exchange of information with the taxpayer. So for the commercial assessments, once the board decides which ones are proper and can move forward, we're going to ask that the board defer any action on them until a later date, and that for those properties that additional information is still needed because there was no exchange of information, that the assessor's office, and I will assist in that effort, will prepare subpoenas, and we would ask the board chairman, if this is approved, to sign the subpoenas. And under the statute, the 70.478D, it provides that if the assessor requests the board to subpoena information, the board is required to issue the information that the assessor requests. And the threshold is very broad. The information that can be subpoenaed may only need to tend to throw light on the value of the property. We're not going to ask for needless or information that won't be important. That's a waste of time for everybody. But we need time to review. And for many of the properties that have filed a notice of intent but have not filed the objection form, and that will be filing objection forms presumably during the first 2 hours, the assessor's office doesn't even know what their opinion of value is, because on the notice of intent, all that has to be done is the taxpayer has to notify the board clerk that they will be objecting to the assessment, but they don't have to provide any information, just notification that they will be filing an objection. So the objection form contains, a lot of information, as the board is aware, and the assessor's office hasn't even seen those objection forms because they're expected to come in between 9 and 11 a.m. So after those forms come in, if they come in, the assessor's office, and I will work with them, will consider the information, we'll look at their opinion of value, and if it's appropriate, we will ask for additional information through board subpoena. And we're hoping to have that process completed by next week, Wednesday or so, to have the subpoenas completed after reviewing the various different objections. So we're bringing it up this morning because there is this timetable between 9 and 11 that affects the validity of objections that are filed. But that will be once it's determined which ones are valid and that can proceed with the board review. We would ask the board to defer action pending the issuance of a subpoena, and then and we would also ask, by the way, that the board defer action on any request for a waiver of the board of review, much like the board did last year with the Hy-Vee. If the taxpayer substantially complies with the subpoena request, then the assessor will join in to a waiver request, after we've looked at everything. But if there isn't substantial compliance, we may not, or there might be some instances where we might want a board of review hearing. But we won't know that until we get additional information through subpoena and get the opportunity to review the objection forms once they come in.
That's a lot to absorb. Brings back bad memories.
So Amy, is this the assessor's office and you as counsel are asking for deferred action on all of item 13, items A through G? Is that what I understand you're discussing?
We are. For those taxpayers that have filed complete objection forms, we are asking for deferred action, but we're also notifying the board that for some of those, and we don't know yet until we, have completed a more in-depth analysis, that we may be subpoenaing additional information. Those subpoenas would be prepared and submitted next week. But the board does not have to meet to review the subpoenas. The board chairman simply needs to sign it because the statute gives the assessor broad authority to subpoena additional information which may throw light on the value of the property.
So the reason I'm asking is it's difficult for us to file a motion that some will be deferred without knowing which you're requesting.
Sure. Yes.
So can we talk
I
about
would say
specific-
that all of the items, all of the objections that have been filed that are complete objections, those should be deferred until a later date. And then this afternoon, I believe, Amy, do you have a time slotted to then review the others that we're waiting for completed objection forms on, where the board can then take action on those once the 11 o'clock time period has expired?
We could do it around 3:30.
I have a question. For those that may bring their forms in the first 2 hours, we would be considering, so they filed a notice of intent within the 48, and then they have up until 11 a.m. this morning to bring in an objection form, and if they've done that, their objection is valid, and this board will need to take it up at some point, correct?
That's correct.
But we would not be taking up the objection today for the same reason we're not taking up the others today, because obviously if it's coming in this morning, no one's had an opportunity to review. There may need to be additional subpoenas. And so even if a valid objection is received by 11 a.m., we would be, if anything, the only action we'll be taking today is a vote to defer and do we have to vote today to grant subpoena power, even though we don't have the subpoena itself before us, or is that something that's just handled by the chair on Wednesday?
The board can have a motion to allow the chair to sign the subpoenas once they're prepared and submitted. So the board can take action on that.
And then wouldn't our motion just be any timely received objections will be deferred? And of course, we have to give them 48 hours advance notice of when that next hearing will be, and give the chair the power to sign subpoenas in connection with those. And then if any don't come in by 11, it's sort of a moot point because we don't have a valid objection before us. And then they would be, I mean, if they come in after 11, I don't know what happens. But I'm just saying, in other words, could we vote now and say, if one comes in by 11 and is timely filed, A, we need to authorize subpoena power in case that's needed, and B, it's going to be deferred, and we'll figure out the appropriate notice, timing, and procedure after the fact, but we're not going to do anything else with it today other than those two things. Is that right?
That's correct. You summarized it correctly, yes.
Okay, so I mean, I'm going to propose a motion here then for consideration is,
Can I say one?
oh yeah, go ahead, Amy, I'm sorry.
Maybe I missed one item in there, but I just want to verify. The only exception would be those that did not give their intent. So any walk-ins today that didn't give their intent, you will still need to determine if you're going to hear them because they didn't give the 48 hours intent.
And I have a question about that. Are there owners of commercial property who we think may appear this morning in the first 2 hours who have not given the 48 hours intent?
I believe there's a gentleman here right now,
Okay,
and I believe there's one other one
okay, so there's two potentially,
that I know of.
okay. So I'm just trying to compartmentalize this so we can have a motion that summarily deals with the broad categories that we know about, and then, but leaves the issue open on any that are walk-ins this morning before 11.
I think I'd recommend, you just state it in a way that anyone has given intent or turned in an objection form, and then you go on with how you stated it before. But you'll need to, anyone who walks in, you will have to I would recommend you make that decision today on anyone who just walks in the first 2 hours. that has not given any intent or turned in a form.
Yeah, I think that sounds like a reasonable,
So we actually need two motions, one on agenda item 12. Consider deferring action on the following objections that have not provided complete objection forms. And a separate one on option or item 13 on our agenda, consider deferring action on the following commercial objections that have filed complete paperwork and the issuance of subpoenas are being requested. Make it as clear as possible that we have two different categories.
well, I feel like we have items 12 and 13, and then we have like item 12A, which is the, well, I guess, are you including everyone who's filed intent that isn't even listed under item 12? We don't know about?
I'm not following, Erica.
Well, that makes two of us.
So-
I'm thinking the potential motion stated by Craig would include in item 12, in addition to those objections listed under item 12, it would also include taxpayers that have indicated that an intent to file but have not yet filed, that might not be listed there. Do I understand that correctly?
Well, as I understand it, the intent, verbal or written, has to be given 48 hours before today's meeting, which would have been 9 a.m. on Wednesday. The way I understand it is a couple of taxpayers have provided either verbal or written intent within the 48 hours, so later than 48 hours. And the only business that we would take up today with respect to those taxpayers is whether we will waive that 48-hour
Correct.
notice of intent requirement. And as counsel for the assessor noted, we would have to make a determination of good cause.
Can we parse these out, though, to like get 12 and wrap as much into that as possible, and then deal with the walk-ins essentially separately?
Well, there may also be, are there walk-ins who filed their notice of intent earlier than 48 hours but have not filed a form? So that, okay.
Sorry, yes. So in the spreadsheet I gave you, the ones that I know of, and Tracy will, need to verify this, but those in yellow, under objection form status that say intent to file only, they had not turned in their forms that I know of by last night, when I left. Those, and then there are two people that aren't on here. One called yesterday afternoon and spoke with the clerk late yesterday afternoon, and one called this morning and had a conversation with the clerk. So I believe one of those two is here in the back of the room, so you could handle that right now and have one off your plate that way and decide one way or the other. And then the others on here, those that gave intent to file and don't turn it in the first 48 hours, or in the first 2 hours, those you could rule that they don't get they can't come before the board.
Yeah, I want to start like making motion, chunk this out and make motions on this so we can get worked through this before we need to start the other objection hearings. So
Okay, so I think
even if it's a series of smaller motions, I think that's fine.
so I guess I'm kind of working from the complete to less complete. So the ones that are complete are under 13. And that action would be, we have timely notice of intent, we have timely forms, but we need more information.
Correct.
So I would make a motion that with respect to those items listed under 13, that we give our chairman the authority to sign a subpoena as requested by the assessor. Do we need separate motions for that and deferral of action? Would that be cleaner for our record, or can we make that we give subpoena power and we defer until a date to be determined?
I would second that motion.
Okay.
Is everybody clear on the motion?
do we need to stipulate when we're deferring it to, or can we just defer it to a future time to be determined? Okay, future time to be determined.
Yeah, my understanding is that the rule on anything we don't act upon today is we have to give the objecting taxpayer owner at least 48 hours notice of the next date. I'm sure we'll give more than that, but that's what the rule is. And so part of my motion would be obviously that the deferred date is properly noticed as well. So we'll defer it to a properly noticed date in the future to be determined, probably in consultation with the board members concerning availability for that next date.
So we have an amended motion. We have a second.
Second for the amended motion.
So does everybody understand? We're looking at item 13 on our agenda. We're talking about the properties. These are commercial properties that have filed completed paperwork, but depending on the timing of that paperwork and the information that's provided to the assessor, there may be a need for subpoenas. And the assessor is asking you to give me the authority to do that so that we can then get the complete information they need to determine whether or not these assessments are fair and equitable. Okay? Okay, we have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Please let the record note that item 13 on our agenda has been taken care of. Now, I hear we have an item 12, going back to the,
Mr. Chairman?
yes.
Let me just add one other point for clarification. The subpoenas that you'll be signing will have a return date as far as when the party receiving the subpoena must supply the documents to the board clerk. The board does not have to be in session that day to receive the documents. And so the documents will go to the board clerk will turn them over to the assessor, and then the assessor will take some time to look at them, and then there will be a hearing date after that where the board then will reconvene and the assessor will report on the status of compliance with the subpoenas. So just so the record's clear, sometimes opposing counsel requires and believes that the law requires the board to be in session to receive the subpoena documents. I don't believe that's the case. And so I just wanted to call that to your attention.
Okay. Thank you for bringing that to our attention. That wasn't the case last year with the case that came to us this way. And I believe that went properly to circuit court with no concerns or issues. So hopefully, since we have more cases this year, we'll have the same result. Since we do have one of the people representing the person or company with a notice of intent, maybe we should get that taken care of and out of the way this morning. This will be one less thing since he is here in the 2-hour requirement of the meeting of the board. Sir, are you here to represent your company, or who are you? Yes. Please come up to the table. Please identify yourself. You have to push a button on that microphone.
Oh, good, okay. I'm Nathan Christoff, owner of Christoff Property LLC.
Would you mind spelling Christoph?
CHRISTOPH.
Mr. Christoff, thank you for coming this morning. You are here to tell the board why, what reason you feel we should consider hearing your appeal since you missed the statutory guidelines as far as submitting the paperwork as required.
Yeah, there was a miscommunication between the wife and I, so with homeschooling starting and all. So I was going over paperwork last night and I realized that I had missed the 48-hour timeline. That's as good as an excuse as I've got.
Well, the law does give the board some discretion in that. Typically, we would look for somebody who was in a car accident and couldn't make it.
Yeah, wasn't
Who had
the
illness
case.
and had some other issue that prevented them from physically or having someone do it
Yep,
for you.
I understand. So that I do not have for you.
Well, thank you for your honesty in telling us your exact reason. I guess it's now up to the board to decide whether or not they feel that's a good enough reason to add your case to our agenda.
Okay, should we ask for an address?
Do we need to ask for an address?
You want an address of the property? Property address is 1901 County Road MM. Parcel number 0609 361 8620-2. Just for the board's information, could you tell us how this property is currently used?
Half is an auto service shop. The other half is a rental home.
So there's two separate buildings?
Yeah, it's a multi-use, yes. So yeah, there's two separate buildings.
Okay, it's up to us now as his consideration. Do we feel that Mr. Christoph's reason for missing the deadline is appropriate to put him on our calendar?
I understand the need for a timely resolution to the city roles of assessment, but I am inclined to grant it given the strange times that we're in. But I'm open to other discussion.
Any other feelings?
Well, if it's allowed, does this get added to one of our future agenda dates, is what I understand, when we would be taking up the other commercial appeals?
That's correct.
Okay. I appreciate your candor in coming in here. I mean, my opinion is that good cause has not been shown, and I say that only because, you know, when I think about good cause, it is along the lines of what Mr. Couillard, our chair, stated. You know, I understand that things happen, but you know, we do have these deadlines in place, and I think if we are too lax in enforcing them, it creates, you know, the potential for, you know, not having just one this morning, but a half dozen or something. And so in my opinion, and, you know, there's always next year, of course, and so it's 1 year that you're, you don't have this opportunity, and you know, there's no reason you couldn't come back a following year. But I do think we have to maintain some integrity with respect to the statutory deadlines. And, you know, we do have a forum to consider that, but I don't think we can just grant them unless there is good cause. That's my opinion to share.
Okay,
May I add one thing for the chair?
certainly.
I did check the AAR book that we've given you, the annual assessor's report, and there is a section in there that asks if we requested income and expense and if it was not returned, and it is on the list of not returning the income and expense form for that property.
Okay, so your original value as established then was based on the best information available, not the exact information provided by the property owner?
I don't know for sure. We could go check if it was based on cost or on income. I'm just letting you know that based on here, I did check and it did not turn in income and expense. So if you'd like me to go check, we can go check that parcel if you'd like that, if that would help the board in their decision.
I don't think that's going to be necessary. Well, I've heard two opposing arguments, and I'll state my opinion in that, again, the law provides specific guidelines for us as a basis to conduct an accurate and complete border review. And I think in this particular instance, the reason that's been provided is not valid enough to take us across the threshold of adding it to our calendar.
Then I would make a motion that we not hear the objection this year. And the basis is that we've heard the objector's explanation, and we do not find that it establishes good cause to waive the 48-hour requirement in the statute.
Okay, we have a motion. Do I have a second?
Second?
All those in favor of the motion as presented signify by saying aye.
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 Opposed? Please let the record note that the motion is carried as presented. And I would just represent to the taxpayer, thank you for doing this, and I would certainly encourage you to work with the assessor's office between now and next year to get them the information that they need so that they can provide you with an accurate and reflective assessment. And I know it takes time to do that, and I can see you
So,
have a busy schedule, but I
very,
think that's a good approach.
so what you need is an income to expense? Is that what I'm hearing?
Income and expense.
And expense?
That's why I said,
Okay.
meet with the assessor's office, they
Okay.
can show you exactly what they need, and hopefully then you can go to your income tax forms, get most of that information and present it to them.
Okay, all right, well, we'll see you guys next year.
Thank you for coming in.
Thank you.
Thank you.
These copies and send them
It's,
to.
Okay, I guess we're going back then to agenda item number 12. Consider deferring action on the following objections that have not provided complete objection forms, but they have provided notice of intent. What's your pleasure on this?
So are all of the items on 12 under the 11 a.m. deadline to do something?
Good question. What is their deadline for filing these forms? Amy, can you help us on that?
Amy Seibel or Amy Mercer?
Amy Seibel, the legal
All right.
counsel.
Sure, sure. If they have only filed a timely notice of intent or given a notice of intent, they have until 11 a.m. this morning to file a written objection form.
Okay,
And I have been in this situation in other communities where, and maybe it's because of the pandemic and, you know, things are off, but I have seen this year, for the first time, actually, that a Federal Express package will come into the clerk's office with the 10 a.m. delivery with the written objection forms. And so my suggestion would be for the board to consider looking at these taxpayers at 3:30 this afternoon if there's an opening. And if they have filed a written objection form, then you take the same action that was taken with the items noted in number 13. That action be deferred, subpoenas issued if appropriate, you know, based on the assessor's determination, and that the board take up the objections at a later date. But you won't know until after 11 a.m.
all right, thank you.
whether there's a valid objection.
I do see that we have an item on the agenda for 3:30. Has that changed?
That agenda item. She is asking to have her hearing
Yeah.
deferred, so,
We have a letter from the
Correct.
objector about an issue involving the hurricane, so that'll probably be a brief consideration of that, and then we'll probably have additional time. Okay, so I just wanted to we have a packed agenda, and I just want to make sure we're factoring in where that window of time is going to be. But in that case, understanding that, does everybody understand that from, this is item 14K on our agenda, which is the 3:30 objection. The objector, in your packet is a letter from the objector. I think it's dated a couple days ago. There was some family crisis that concerned the hurricane in Gulf Shores, and the objector has told us that for that reason they can't be here, and so we would probably just consider deferring action on that. I did read the letter ahead of today, and if we're talking about good cause, that's probably more in the line of good cause. So that would free up potentially a half hour at that stage to consider
So you're suggesting we should defer item 12 and any reviews of any objections filed before 11 a.m. until that time?
Yeah, and I don't think we need a motion to that, it's just an agenda matter, but I think we table that until our window opens at 3:30, and then we see what we've received, and we'll know, it'll be easier to react, I think, at that point.
Yeah.
One other question I have of our Amy Siegel is if they file that form electronically via fax or email, is that considered timely?
It is.
Okay,
They do not have to present it in person.
okay. That was my understanding, I just want to make sure things haven't changed. Okay, so as a matter of our agenda, we are going to defer item number 12 until later this afternoon, after the 11 o'clock deadline has passed, to see how many of these property owners have completed the requirements as is required by statute to have a completed objection form, so for consideration. Everybody okay with that?
Yes.
Okay. Next item on my agenda is item number 14, hear and deliberate and determine the following residential objections. And it's 9:57, according to my watch calculator. So we have, I can't even see the clock with the reflections on it up ahead in the room. So we have 3 minutes. If you need to take a quick break to use the restroom, since we have a full agenda schedule, I guess I would suggest we do that. And if nothing else, just get up and stretch so that we're not sitting in these comfortable chairs. Pardon me?
Are we adjourning for a 3-minute break?
Let's adjourn for a 3-minute break. For Beacon Properties LLC at 1911 Pike Drive, apartment 109, as the owner's address apparently. Parcel number 0306. He doesn't have a complete parcel number here. He's got 09E, northeast, northwest, so I'm not sure what that's supposed to be. But they are here, and so this is the second commercial property that's not on our list to be considered. So we're going to ask them to come in right now, and we'll ask them what their reason is for filing the objection late.
Okay. So,
Please identify yourself, please.
sure, I'm Bill Leitner. I'm the sole member of Beacon Properties, so the owner of the building.
Okay, and where's this property located?
1911 Pike Drive,
Okay, so that is the property address, not your address.
both. I live in the building,
Okay.
yeah, so.
The reason we ask you here this morning in a certain time window is for your review, for your property to be reviewed by the board, you have to give us just cause or good cause as to why you missed the deadline. In the past, we've looked at things like illness in the family, a death, car accident, reasons that we feel would be sustainable for just cause, and then we could make a determination as to whether or not we take your case under appeal. So what is your reason for submitting your form late?
Yeah, I'm not sure if I have a significant reason. As there's no death, nothing major tragedy. I just lost track of the time. Yeah, that's the gist of it. I didn't realize I was supposed to have done something in the earlier. First time I've contested a appraisal or assessment. And I didn't notice it was an earlier time, and I thought the 18th was the day, 2 days before, and I lost track of the date. So, remembered last night and realized I was really late, so that was all. But
Well, for the review of the board, thank you very much for your honesty as to why this happened. We appreciate that. It's up to members of the board as to whether or not we are going to take this on as appeal for consideration for this year. Based on the information that the was presented by the taxpayer. What is the feeling of the board this morning?
We need to be consistent.
We need to be consistent. I think that's a very good approach. And just so you're aware, we had one person come in earlier, and we denied their right. We denied their access to appeal because they also were honest with us and told us that their reason was not significant in our opinion. Not that, you know, things aren't crazy this year and things can change, but I guess I would then, if we're going to be consistent, ask for a motion so that the property owner knows what our position is on his appeal.
Yeah, I would move to deny it. And sir, I appreciate you coming in here this morning, and I do understand that the rules are complicated and, you know, they require some study and attention. But as Mr. Tate noted, we do have to be consistent in finding good cause. And as our chair alluded, that's usually something that quite literally prevents or prohibits the taxpayer from compliance. Not understanding the rules or the deadlines is not necessarily good cause under those circumstances. And I don't want you to think that we're not sympathetic, and we understand it is complex. And I would also note, as Mr. Couillard did for the last gentleman that appeared, that, communicate with the assessor's office, and they can help you understand the dates and the deadlines and also what the expectations are. And it's year to year, so you'll have another opportunity. It's not final and forever, but I do think, as Mr. Tate indicated, to be consistent in the application of that standard, we should deny the request to waive the 48-hour rule to bring the objection before the board.
Seconded. And also, Amy, did you have something that you wanted to say?
I also just wanted to make sure you knew we did value it on an income approach and requested income and expense the end of December. We did not receive that. We also sent another letter out, explaining the commercial reval and explaining that it needs to be received within 7 days prior to open book, or prior to board of review, and we haven't received the income and the expense, all of the information that the assessor's office requested.
So, Mr. Whitener, that's...
Yeah, I guess it doesn't matter at this point anyways, but I heard.
Oh, no, I was going to say, that's another prompt that, to make sure that your assessment is complete and accurate for next year, that you should work with the assessor's office to provide that documentation, and that might change the valuation.
Right, I understand. So, all right, well.
Thank you.
I did second.
Okay, so we have a motion and a second. All those in favor signify by saying aye.
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 Let the record show that the motion was approved unanimously. And is our first residential property owner here? We'll be moving on to agenda item number 14. Listed alphabetically, we have A through O, and we've been told that O has withdrawn, so now it's A through N. And we have a break at 3:30 because the Jacobs appeal has been, request for change has been approved, I guess, or we may have to approve it, I'm not sure, as we go through this. And so we're looking at Espinoza Manola, 4609 Unity Lane, parcel 609-052-6457-2. One matter of housekeeping that I want to make sure we have on the record is, Madam Assessor, has the assessment rule affidavit been signed as required by statutes?
Yes, it has been signed, and it is attached to the back of the roll also.
And when was that document signed?
It was signed yesterday.
Okay, thank you. We're going to ask that the clerk swear in the assessor's staff. Since we
I'm not sure, Perry stepped out for a moment, so. And I assume you're going to swear us all in at one time, correct?
That's correct.
Okay.
And this year, we're going to swear you in once, and we're going to state on the record for each appeal that the assessor staff has been previously sworn.
For the record, our first property objection was filed on August 12th, and they were notified of their time slot for today via email on September 14th. Raise your right hand and repeat after me. Do you solemnly, sincerely, and truly declare and affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury?
I do. My name's Amy Mercer, the city assessor.
Nick Hare, the residential appraiser.
Dwight Crane, property appraiser.
Harry Nell, commercial assessor.
Thank you very much. One detail taken care of for the day. And is it my understanding that the first appeal, party under appeal is not here?
They are not here.
Okay. Any chance that anybody is here yet?
Not yet.
Not yet. Well,
Should we go ahead and take up that other business that we had deferred till 3:30? And the reason I'm suggesting that is we may find ourselves in a tight schedule where we need some of that time anyways. So if we don't, or should we wait a little bit?
I think we have to wait till 11 o'clock.
11 o'clock.
Oh, that's right. I'm sorry. How quickly I forget the rules.
I'd like to get it off the table too, but I guess if they have a 2-hour window, we have to at least give them that 2 hours.
That's right.
Since we have a little break, I'm going to share with you this morning a little bit of how I see us proceeding, since it's going to be different than it has been in the past when we've had a fair amount of time with very few appeals. So I have prepared a summary that I'm going to use this morning as we go through the materials, and I'm going to read to the taxpayer that they must be sworn, they must present their and we'll review their objection forms. I'm not sure if you have it. It's in the packet, but I asked Tracy to give me a written copy of each objection form to make sure that we have an understanding of what's on it. I'm then going to read to them that Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor has erred in determining the total value of your property. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us in considering your appeal. Those standards are: best evidence of value is a recent arm's-length sale of subject property. Next, sales of reasonably comparable property, then all other approaches to value, such as the income approach on income-producing properties and the cost approach on special purpose or unique properties where there is not an active market. This does not include comparison of your neighbor's property unless it recently sold in an arm's length transaction. At this time, please share your exhibits, any exhibits that you will be reading into the record. If you have an appraisal of the property under review, the appraiser must be here to present sworn oral testimony for the board to consider the appraisal. Okay, then I'm going to ask them, has there been a recent sale of this property? And did you attend the open book and review the property record card? When they've asked them those questions and they've responded, I'm going to ask them, since we have a full agenda today to hear, I will give you a 2-minute warning when your presentation time will be ending. Please introduce yourself and begin presenting your testimony. And I'm going to have them on a timer, and they're going to have 7 minutes. And at 5 minutes, I will give them a warning that they have 2 minutes left. And I'm going to do the same for the assessor's office so that they know that they have We want to have a good record, but we also have to get through these in a reasonable time. And I felt, as I looked at our agenda, that if we didn't have some kind of control like that, that we'd never get through all of our appeals in a 30-minute window today. Because my goal is that we complete the objection and determination before the property owner leaves. So we discuss it, so that we needed some time to discuss our opinions of what the value is. So that basically gives 10, 10, 10. Sound okay to everybody? I guess right now we have 30, because the first property owner hasn't shown up. So I guess I'd ask, how long are we going to wait?
I was thinking that if the second property owner was here, we could start with the 10:30, but they're not.
Well, I'm looking at this sort of like, you're not late, you're late for class in school, you're more than a certain number of minutes late, might as well, the door's locked, you're not coming in.
So we do have a written objection. In the absence of a objector here to add to that presentation, do we act simply on the written record that is before us, or how, do we just say we look at the form, and if the four corners of the form don't convince us, which I don't see how it could, or do we, in the absence of evidence, which the form is not, or testimony, the presumption carries in the absence of any presentation of evidence whatsoever.
I guess I would defer to the assessor and ask them to present their information, as we should probably have done already, so that they have a good record indicating how they develop the value. And if the property owner's not here to rebut it, then that's not our problem, it's theirs. So I'm going to call a case.
Well, I need to look, I think I need to check the statutes on that, because I believe they need to appear in person or by phone. And if they're not here to present sworn oral testimony, then I don't believe they get a hearing at all.
Okay?
That would be my understanding as well.
So it goes back to the point of how long we're going to wait before we take them off the calendar. Is 15 minutes reasonable? I think it's reasonable. It's now 10:20. The property owner has not appeared. So I'd entertain a motion to strike this case from our agenda and sustain the value of the assessor as presented in the assessment roll.
Yes, in the absence of an appearance or any evidence, I would move to sustain the assessor's valuation of the property as to agenda item 14A.
Current value on the property is listed at $232,200. Property address is 4609 Unity Lane, and the objection form does not have the parcel number on it.
Zero 52 -2.
We have a motion of non-show to dismiss.
I'll second.
We have a motion and a second. All those in favor signify by saying aye.
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 Please let the record note the motion carried unanimously. My clock shows it's 10:22. And at this point, since we do not have our second appeal party here,
Can I just ask a question? I don't know if it would be for the clerk or the assessor, but when people were assigned these slots, were they told that this is when you will come, or were they told there was a chance that if we move along faster, that they might move up earlier?
No, they were given their time to appear as 10 a.m.
Okay,
or 10:30.
okay, so.
But if they come in earlier, staff has been notified to bring them down.
Okay,
Yep.
okay. So if we like run ahead of schedule, though, we can't or shouldn't?
That would be only if they appear, if they come earlier.
Okay,
And that was due to COVID. We didn't want backing up or people waiting and,
okay.
so.
Safe distancing. Okay, our 1030 parcel, property owner's name is Ra, R-A-I, 4605 Unity Lane. Parcel number 60090526479-2. Indicated value on the assessment, rejection form, assessed value is $224,900. Indicated value is $190,000. A bit of dead time. As I have looked at the objections that we have received and the time it's going to take to go through the commercial appeals, I'm going to be asking you to look at your calendars, and that this is the most appeals we've had in as long as I can remember since I've been on the board. And it's going to take some time to go through them and sort out the detail of each case and the amount of time it's going to take. So I've asked the clerk and the assessor to look at that carefully for us so that we make sure we have a reasonable amount of time on our calendars for each case as they are brought to the table. But we have to look at our calendars as to when we can get together so that sort of lost this, in my mind, the statutes and the state deadlines to get the clerk's statement of assessments in. It's still first part of November.
Have to be careful. I've got an election November 3rd.
So we're going to have to be working to get this done as soon as we can before that statement of assessments needs to be in, because without that, they can't calculate the tax rate. Just a heads up, as you can, please look at your calendars, and we'll see if we can't find time to make sure that everybody has a reasonable window of time we can give to the appeals.
Well, I'm happy to look at my calendar, but I think we first need that counsel on when the statement of assessment is due. So,
Yeah, just a heads up at this point that we're going to have a few more days than we've had in the past.
yeah, just a few. Actually, I was on the board before you joined. I know you had prior experience too, but yeah, this is the most objections I've, by far. I remember there was one year that we basically sat to use up the time that people had to walk in because we had so few to hear that we had some downtime. So to that end, I guess I have a question for the assessor's office. It's my understanding that that this year Fitchburg did a revaluation of land value. Is that correct?
So this year, sorry, there are various types of revaluation, and this year it was like a full revaluation. So we revalued all of the land. We updated all of the cost tables. So the prior cost tables were set at 2001 costs with modifiers applied to those. Each year they'd apply another modifier and then another neighborhood modifier. So as time goes on, things start to lose equity. So the state had updated their cost tables in 2018. So when you do that, you have to look at it both ways. So when we do that, we updated those cost tables, And when you do that, you would remove all of those market adjustments, all of those neighborhood adjustments, and you're basically starting fresh and looking at things through a new lens. And when you do that, you find things. So part of these changes, certain classes had much greater changes. We found that, which I didn't even know until this year, many of the other classes of property, forest, swamp, egg site values, many of those had not changed since 2005, which, I'm not sure why, but they had not changed since 2005. And that's, many of those properties' values significantly changed because 15 years, there's a lot of change in sales over 15 years. The commercial was similar. A lot of those were not equitable or consistent. And so we have tried very hard to make things equitable, consistent, like with apartment buildings, commercial class. We stratified those into different neighborhoods. So like 4 to 15 unit apartments went into one neighborhood, so we could look at market segments of each classification, within each classification also. Along with a lot of the rural properties, so over half the city, approximately half the city is rural. That's where you have that forest, you have some swamp. We've also had issues with some water issues over the last few years, so we try to consider that in certain areas where you might have, we had a lot more classification changes between that because an area may have only been, let's say, 3 acres of swamp before, might not be 6 acres of swamp now. So we had a lot of different classification changes, and we set up all of the land tables so that everything was consistent. So forest throughout the city is 9,400 per acre, and then if it's ag forest, it's 50% of that. And so that everything is, we tried to make things as equitable and as consistent as we could. And when property owners brought additional info in to us that we may not know about, then we can, know that about that. But, so it was a different type of evaluation, and we just keep circling around and circling around and circling around to try and refine those numbers. You may find that 2-story within a neighborhood sells different than 1-story. So when we find that, you put the original modifier on, and then you circle back around and say, hey, wait, the 2 stories are different. We'll add another modifier if it's based on that. So we just keep circling around those values and trying to refine and refine those values.
Thank you for the update, Amy. I'm sure most of our board members knew that when they opened their notice of change, as I was in the same boat. It's now 10:31. Is our 10:30 appointment here?
Not as of yet. I'll go check the hall.
Madam Clerk, any sign of them?
Nope, our 10:30 appointment was, their objection form was turned in on August 12th? and they were noticed to appear for 10:30 this morning on September 14th. And they are not here as of yet.
I don't know what to say. Like's been mentioned with the COVID-19 and issues with children in school, sometimes schedules are hard to predict. And looking at our list of appeals for today, our 1 o'clock appeal, letter F, the Halfords. I'm going to recuse myself from that appeal. And that they are longtime friends and neighbors. Halford, letter F, 1 o'clock. So at that point, I would ask the vice chair to conduct that appeal for us, or the review. I certainly don't want to have, or appear as if there's any type of conflict of interest, since I know the family personally. Do we have any other questions for the assessor, since we have our undivided attention? You put together a very nice report to submit. Is there a summaries page that we can look at, or how much the values changed in the city of Fitchburg from 2019 to 2020?
Yeah, the book is growing and growing every year. So in the very first section, it gives, a table of contents, so I'm not sure on page 2 if there's anything specific that, you'd like to talk about or not. And then on the next page, it talks about the addendum, which includes all of the type of work that we've done. So if it helps you when we're in a hearing, you can go to these, like, we would have a summary of the reasons for change, statement of real estate assessments, that's in the addendum 4.07. So if you look at that, at the statement of assessments, and that's suppressing the manufacturing, that's not including the manufacturing values. The residential classification, we have 205,393,100 in the residential class. That's how much we've had. But you actually go to those reasons for change. I think that helps explain things better, and that's in the next addendum. So we had quite a bit of change in residential. We went from 2.04 million to 2.205 million. Approximately 30% of the total change for the city was due to new construction. So, and that was at the start of open book. I didn't do the math yet for after open book with all of the changes. But we had a lot of new construction this year throughout the city, and that's part of the reason that each class, and that 30% was both in residential and commercial, approximately 30% of new construction throughout the city. The commercial properties, those values changed from 941, 258, 900 to 141, 830, 800. So, you know, there was a significant change in the value for the commercial properties.
Is this available online or
The-
other than these two books in the room?
Probably won't be available online until after the assessment goal is completed.
Yeah.
That would make sense.
And I can post things. We've added a lot of different things this year to our assessor's page.
Yeah, I've been looking at it.
So we have a list, we have both the 2018 and the 2019 improved residential sales. So we have those books out there that will assist you. Like if you want to look up a comp during the session, we could always look it up that way and see if it's a valid sale or not. And the data on that, if we don't include it and an appellant includes that, there's another way to look that up. We also included for the public to understand how your new assessment would be reflective with your tax bill. So Misty Dodge, our finance director, created that video and posted that on our website for us. We've added quite a few other links on the website, the guide to property owners, the appeal guide, the agricultural assessment guide. That one would be, I think, would be good for the board to know and to understand and property owners to understand, because even though it's an agricultural property, they're going to have other classifications on there. And that guide has specific examples that are really awesome to understand how you would break out each classification. We're trying to do our work based on the requirements of the Wisconsin Property Assessment Manual and state statutes. So, you know, we go back and we reference these resources, and if we have questions, then we'll contact the Department of Revenue and say, hey, you know, would you go with swamp on this, or would you go on forest with this? Because it's a
swampy forest.
Yep, exactly. There is seasonal water that comes through this. It's a ravine. And there's low-lying water, but according to the classification, it would be forest. And I don't know if a lot of property owners understand those type of things, and we try to explain it to them. But this year, because things had not been kept up to date for 15 years, it's a huge change to them, and we understand that, but we still have to, when we discover something, we have to do it at full value. You know, other than anything undeveloped that it specifically states at 50% of fair market value. So that agricultural guide is extremely helpful for the other classes besides residential and commercial. The Wisconsin Property Assessment Manual, you can find that online on the Department of Revenue's website. An item that many property owners, private appraisers, real estate agents, so many people do not understand that you can find sales on the Department of Revenue site. So when you go to the Department of Revenue's website, we'll often walk them through and say, you know, you can find all these sales right here on the public search under the sales. So we're trying to we're trying to be as transparent as we can. We'll provide our information, but we're also trying to encourage them to, you know, give them the resources to go and verify these other items themselves. And that, so, did I answer your question?
It did kind of, but like, I don't want to just be sitting here chicken scratching down a bunch of notes when this is really interesting information. So maybe at some point we can just make a copy of those pages. But I do agree that it's probably makes sense to wait to post this online until it's actually
Finalized,
Yeah.
yeah. And when the Department of Revenue, because all of our sales, we report to the Department of Revenue. They're due in February typically, and then, and we code those. We code them either arm's length or not arm's length. And when we do that, then on the Department of Revenue side, they'll also review those sales, and they call them D&U, do not use. So if it's something as an outlier, they may pull that out. We're still, if it's arm's length, we are still to include it and report it to them. If it's still arm's length, but it's like, this doesn't make sense. And then they will pull that out of their stratification because they don't want that to affect their equalized values.
Sure.
And that, so, what else? We created a little video as to where you can find different things on those links, so residents can search out the sales or the GIS. We really want to get an assessor layer added to our GIS, our city GIS layer.
Yes,
And
that would be helpful, because a number of the evidence is provided maps, and you try to zoom into one of those printed maps, and it's like, well, I can't tell where this property is in relation to anything else. So
yes, and so if we could do that, then I can actually I can actually upload all the sales by the parcel boundaries. So a property owner could open it up and say, there's a sale, a block away from me, or there's no sales like me, but I know this is a house that's similar to mine. So we want to get that layer on there. We want to add the neighborhood boundaries so you can see where your boundaries are, things like that. So we're trying to get that, but we only have so many resources. And
it sounds like you guys had a big lift this past year. Anyway.
we did. It was a very, very busy year. And we always encourage property owners to participate. Not just participate when we have appointments, but, you should be looking at your assessment notice each year. And I don't find it personally wrong if someone questions it. I think it's a good thing because I want you to look at it and I want you to be the second set of eyes. You know your properties, and if you bring something to our attention, then we know that is happening. We may not know that your backyard is flooding out. We may not know that you tore your basement finish out. You don't pull a permit to tear out your basement finish. So, we want property owners to verify their data each year, and you can see that on assessor data, so we have that all out there now. We've put all of the commercial properties into the CAMA system, so if you go to one of the commercial properties in assessor data, you can see the building sketch, you can see the attributes of that property. And that will continually help us have better and better data if property owners look at that data. You can bring it to our attention that, oh no, we don't have baseboard heat, and then we can keep correcting and keep improving our assessment role. That's what we strive to do, is have the best information available is how we will value these properties. And if a property owner can bring us more information, that's even better.
Well, thank you, Amy. It's interesting to know what the assessor's office has been doing and the updates you've added to the computer system and online for people to use. It's a good step in the right direction. It's now well past our 10:30 appointment for the property owner. There's still no show. So at this point, I'd like to take care of this particular case and get it off our agenda, just as we did with the last one. Do I have a motion?
So moved.
What's the motion?
That we move on to the next. Oh, I'm sorry. I thought we were moving on to the next item. No? Okay.
I need a motion to dismiss the case.
Well, and I just wonder if the motion should be framed like the last one in terms of sustaining the assessor's value in the
Correct.
absence of evidence presented at today's hearing. So As noted, the hearing was properly noticed. The objector was notified on September 14th of the opportunity to appear today at 10:30. It's now 10:45. Having no appearance, we've received no evidence. Given the presumption that the assessor's valuation is accurate, and in the absence of any evidence to the contrary, I would make a motion to sustain the assessor's valuation as set forth in the assessment roll.
Very good, thank you. We have a motion, do we have a second?
Second.
All in favor signify by saying aye.
Aye.
Opposed? Let the record note that the motion carried unanimously. Thank you. We now have approximately 10 minutes before our 11 o'clock deadline has arrived. So I'm going to adjourn the board for 10 minutes, which would be the start of our next appeal. Again, so we can get ourselves out of these seats for a few minutes and stretch. Everyone's back from our little recess. It's now my understanding that our next appellant is here. That would be Christine Rogers, is that correct?
Yes,
Welcome.
thank you.
So the Board of Review is back in session. I found on my chair a document. Is this a document you prepared, Ms. Rogers?
Yes,
Okay, I'd like the clerk to recognize this as Taxpayers Exhibit 1. Just to get this started, your property is located at 61 Arbor Ridge, is that Arbor Ridge?
Arbor Edge.
Arbor Edge, excuse me. Way in Fitchburg. And I don't see the property identifier on here. Parcel number is 609-051-07309-2. This is a residential property. And its current value by assessment, its current assessment is $500,100. The property owner's opinion of value is $467,080. $467,080. The way this is going to work, Ms. Rogers, is I'm going to ask you, after reading this statement, to present your evidence to the board. You're going to have a time in which to do it. As that time is expiring, I'll give you a 2-minute warning if you need it, to make sure that you're aware that your time is running out. So here's what we're going to do. We're going to swear you in. Would you look to the clerk as we swear you in to present evidence?
Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Christine Rogers.
Ms. Rogers, Chapter 70 of the Wisconsin statutes give the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. The standards are: the best evidence of value is a recent arm's-length sale of the subject property. Next would be sales of reasonably comparable property. And lastly, on all other approaches to value, like the income approach on income-producing properties and the cost approach on special purpose or unique properties where there is not an active market. Just so you're aware, this does not include comparison of your neighbor's property assessed value unless it's sold recently in an arm's-length transaction. At this time, please share any exhibits, which you've already done. If you have an appraisal of your property under review, the appraiser must be here to present sworn oral testimony for the board to consider the appraisal. Question I have for you: has there been a recent sale of this property?
No.
Did you attend the open book and review the property record card with the assessor and the assessor staff?
Yes.
Okay. Since we have a full agenda to hear today, I will give you a 2-minute warning when your present time is ending. Please introduce yourself and begin your testimony.
My name is Christine Rogers. I live at 61 Arbor Edge Way. It's in the Harlan Hills neighborhood. I live in a duplex condo, and I think that's important to keep in mind. So I'm appealing a lot of the houses in the neighborhood, the assessments went up dramatically. Mine happened to be second in line at 21.5%. So I took the information that Nick had shared with me via multiple emails that we had. I took some of his comps that he was showing me. I didn't take every one of them. So I used the Glen Arbor condominiums, which are right over here, and then I used duplex condos from my own neighborhood, 2 of which have sold in the past couple of years. So, and you will see the MLS listings are attached to what's on the top page.
Just so you're aware, it has to be sworn oral testimony, and if you are going to introduce this information, it's not just an exhibit, but as evidence for us to consider, you need to read it into the record.
Okay,
Okay.
that'd be much easier.
Read it into the record for us.
Okay. I am appealing my recent 2020 assessment of $500,100 of my duplex condominium at 61 Arbor Edge Way, Fitchburg, Wisconsin, 53711, area W19, based on the following comparables and related information. I've had numerous email conversations with Assessor Nick Hare and have used his recommended comparables for my appeal. My evidence is very concrete and straightforward. I also see the importance of comparing duplex condos to mine versus single-family condominiums. I have taken 3 comparables from the Arbor Glen neighborhood, 2 of which were sold with 2 bedrooms and 2.5 baths, and share with me by Mr. Hare, and the third is a recent duplex condo listed in the neighborhood. The reason I took the third one is it's 2 stories. I looked at the 2020 assessment of that newly listed condo, which was $461,900, and it is significantly lower than my assessment and has 3,201 finished square feet. I took the same target information and priced that house per square foot on list price. My duplex is 2,933 square feet. If I averaged those 3 duplex condos, the price per square foot would be $152.74. That would make my 2020 assessed value at $447,986. Secondly, I took 2 duplex condos from my neighborhood, which I know is an important comparable. Both of these comps were also sent to me by Mr. Hare. These 2 duplex condos have an additional bedroom, and one has an additional bath, and the other an extra half bath. One sold in 2018 and one in 2019. When Mr. Hare came to my home, I asked him who my best comp might be, and he stated 5806, so I'm going to add Dolly, because it was just sold. I am using the other duplex because it has second floor square footage as mine does. If I average the 2 comps, 5806 at $157.55 square feet, and 5808 at $160.94 square feet, it comes out at 159.25 square feet, which would make my assessment $467,080. Thirdly, one of the criteria as to why my condo was assessed higher, according to Mr. Hare, is that I have an upstairs. Taking this information seriously, I looked at the 2 duplex condos I have listed that have a second floor. This also takes into consideration the age difference between the two. 5808, that should be Dolly Drive, sorry, and 17 Glen Arbor Way. If I average these 2 duplex condos, the price per square feet is $159.06. This would make my assessment, here's my square footage, $463,590. Because I'm aware the neighborhood comp carries more weight, the fairer amount is the one listed in the previous paragraph. Mr. Hare will also point out that my lower level square footage was finished a little later than the home completion, and that I was not assessed for that square footage. I went back into assessment information for the duplex I am connected to, which is the 5808 Dolly, and did the same square footage comparison, but including 2015 to 2018 assessment data. My lower level finish date was 4/22/2015. I did not take 2019 assessment due to 5808 being sold that year, and therefore 5808 assessment went up to sold price.
2 minutes, please.
This would be an unfair comparison because I have not sold my house. That information is on the very last page about the assessments going back. So if you look at my assessments and you look at 5808 Dolly's assessments and you compare them with finished square feet, mine appear to be very fair, in fact, higher than what they potentially could be compared to 5808. Are there any questions on that last page?
I think you prepared a very nice little summary. Thank you for doing that. And at this point, I'll ask the assessor and her staff member to present their information as to how they established your value at the $500,000 point.
Thank you. Amy will be distributing the written information summarizing the basis for completing the 2020 assessment for this subject property. I will briefly summarize the written documents with oral testimony. On the first page, once she gets this handed out, is a summary of my qualifications to complete the appraisal and assessment of this property. I'm Nick Hare, and I am employed with the City of Fitchburg Assessing Office as the residential appraiser. I have an Assessor 2 certification, which expires 2/28/21. I have worked in real estate for over 14 years, in the assessment industry for over 4 years. I've worked with the City of Fitchburg since March of 2019, and I previously worked at the Department of Revenue's Equalization Bureau for 3 years. I have a bachelor's in finance and real estate from the University of Northern Iowa and a master's of business administration from Drake University in Des Moines, Iowa. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as the market value of the property as of January 1st, 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines that the property shall be valued in accord with the Wisconsin Property Assessment Manual at the full value which could ordinarily be obtained, therefore, at a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining the market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. that the purpose of mass appraisal is equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full market value assessment role, the estimated level of assessment is 100%. On the next page, you'll find a location map illustrating the subject property's location. The next few pages are the property record card that contain specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. The first page shows that the property is a residential condo, and it is located in the Harlan Hills Condos neighborhood on the city's northwest side. The second page will show the building permit history, which shows there are no recent building permits for this property, and the sales history that shows the last valid sale date was November 19th of 2014 at $366,563. In the notes section, it shows that the property was last inspected in November of 2019. The purpose of this inspection was that we noticed that the assessments in the Harlan Hills condo neighborhood were previously inconsistent and inequitable, so we put it into our 2019 workload to do a walkthrough of all the properties in Harlan Hills condo neighborhood, and we got into 29 out of the 43 condos in that neighborhood. I completed all of the walkthroughs as we wanted all of the properties viewed with the same eyes to make sure that they were being valued consistently. There was a 2020 open book appointment through email correspondence. The land information for the property, given that there are different types of condos in this neighborhood, we applied different adjustments to the land. So given that this property does lie on Arbor Edge Way, or right on Dolly, we applied a -5% adjustment for fronting traffic and also a -15% adjustment given that it's attached condo instead of a detached condo. On the third page of the record card, I will highlight that it is a custom style property that is 2 stories in height. It contains a total of 2,933 square feet of living space. During the inspection that was completed, we did capture the basement finish, which was previously not valued in last year's assessment. The property was built in 2014, and the construction and quality grade is an A. Its overall condition, desirability, and utility is rated as average, and that is shown with the equipment, the ratings for the equipment, kitchen, bath, interior, and exterior. It is a 2-bedroom, 2-bath house and has 2 gas fireplaces and 2 additional fixtures, which are usually additional plumbing fixtures, so if a house has an additional sink or a laundry tub. The fourth page shows a sketch of the property that shows the layout, and on the second floor it shows that it is open to the floor below that one section, and that open section is not counted in the square footage of the second floor. The next page is the market valuation detail, and this summarizes the assessment calculations as completed by our automatic valuation model. The model is based on Volume 2 of WAPM and the Wisconsin Property Assessment Manual and 2019 arm's length sales. As I noted earlier, the basement finish was not valued in last year's assessment, and this shows that approximately $46,000 of the increase in this year's assessment comes from that basement finish. The next page of the document is a map that locates the subject and recently reasonable comparable arm's length sales. And the next page is the sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. The addresses of the sale properties are 5808 Dolly Drive, which is the other side of Christine's attached duplex condo. 5806 Dolly Drive, which is right next door, and 54 Arbor Edge Way, which is a detached condo. The style and the sales dates of these, 5808 Dolly was June of 2018, 5806 Dolly was June of 2019, and 54 Arbor Edge Way was May of 2019. And the styles are 0 lot line condos. One is a 2-story, one is a 2-story custom attached condo, one is a 1-story ranch attached condo, and one is a 1-story custom detached condo. The subject and sales gross living areas, including basement finish, range between 2,761 and 3,666 square feet. The effective year built ranges from 2006 to 2014. The data is listed demonstrating that the sale properties are reasonably comparable to the subject property. And as I stated earlier, there are, on the detached condo, there is an adjustment to the land value given that that is a detached structure instead of a attached structure. The report adjusts the sales prices for differences such as the lot, building attributes, age and condition, market location, and detached structures, if any. The adjusted sale prices are, respectively, are $559,700, $511,700, and $538,000, respectively. The adjusted sale prices of reasonable comparable properties indicate the assessed value of $500,100 is a fair estimate of the market value of the subject property as of January 1st, 2020. In summary, there is not a recent arm's length sale of the subject property, and consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for differences between them and the subject property. Thank you. That concludes my presentation.
Thank you very much. Both of you did a very nice job. Questions for the taxpayer or the assessor from the board?
I have a question for the assessor. Based on the testimony of the taxpayer, it appears from her statements that the basis for comparison is on a price per square foot valuation and then taking the price per square foot of the comparable sales, multiplying it by the square feet of her property, and then she's arriving at a figure of either 467, 463,000, something like that. Can you explain why your calculation using these comparables is coming up with a different and higher value than the price per square footage valuation that's taken from the taxpayer statement?
So it appears from her presentation and the price per square foot that she is given is total square footage of the entire property that includes first floor, second floor, and basement finish. If you take a look at the market valuation detail sheet provided in the packet, there are different values for each level of finish. The first floor square footage actually includes the cost for the entire structure, including an unfinished basement, the roof line, and everything. So that is why the first floor square footage is valued so much higher. But then the second floor square footage is valued a little lower than first floor, and then the basement finish area is valued at the lowest rate. So the value that she provided is based on the total square footage divided by the number, but there's actually, based on where the square footage lies in the property, there are different values for that square footage.
Can I speak to that?
We're on the point where we're asking board questions.
Okay.
The other question I have is on comparison number 1 from your presentation, which is the adjacent property.
Yes.
There are 2 questions on that. I note that that one, even though it's adjacent, it is a 3-bedroom with 3 full and 1 half baths, and the subject property is a 2-bedroom with 2 full and 1 half baths. Can you explain or discuss how the value adjustment is done to compare those 2 properties, given that difference in the bedrooms and baths, which would seem to have an impact on the value?
Okay, so in regards to bedrooms, there usually isn't a value adjustment for bedroom count. It's mostly based on the square footage. In regards to bathrooms, there are adjustments. Bathrooms are valued based on plumbing fixtures. A standard bathroom is 3 plumbing fixtures, a sink, shower, and a toilet. And so as listed on this, there is an adjustment of negative 6,800 from that comp to adjust for that additional full bathroom.
And then, so just to clarify, the adjustments to the bedroom isn't in the bedroom category, but in the category just above that on the chart where it takes into account some significant adjustments with respect to square footage?
Yeah, do you have any comments regarding the bedrooms?
Yeah. I'm Amy Mercer, the city assessor. So in Fitchburg, in some communities, your bedroom counts will have a factor on them. In Fitchburg, we have such a diverse housing stock and a diverse community that we do not see the bedroom counts actually playing a factor in the value change in that market. So there is no modifier applied for bedroom counts here because we have a diverse housing stock and a diverse population, property owners.
Okay. Any other questions from the board? If not, then Ms. Rogers, you had a point?
So Nick, I'd like to address what you're saying. So we're taking 5808 Dolly as the clearest comp because it's my neighbor and roofmate. It was built the same year, same products were used inside. It's a much larger duplex. It has 666 plus more square feet than mine. And it also, in the lower level, it has a full kitchen. So when you talked about the square footage, I just took the highest number of square feet, the $160.94. I didn't give more for first floor, less for the second floor and less for the basement. I just took the highest number when I compared it to my square footage. And that's where I came up with that figure of $467,080. So if you're comparing apples with apples, I think my assessment's unfair.
Okay, thank you very much.
May I add to maybe clarify that with the property owner?
Okay.
On our sales comparison sheet, next to each item, like some of the items she's spoken about, let's say on the back side, where the first floor of the subject is 1,366 square feet, but the neighboring property is 1,660. That is adjusting downward because the neighbor's property is larger on first floor. It is adjusting that sale price down $34,700. Then the second floor, hers is $592, and the first sale comp is $769. So that's also adjusting downward. That's $16,400. So each item that is different, we will have an adjustment to or from. And then we take that sale price, and those adjustments are added or subtracted, depending on which way they go, to that sale price to come up with that adjusted sale price. So every difference between the property is being adjusted for that valuation difference.
So, in looking at the sales comparison then, it looks like the sister property, the roommate, as you mentioned, you're considering the comparable value not to be the $590,000 that it sold for in June of 2018, but $559,700 to make it, like, if you shrank it to the comparable property, to the subject property, that's what the value would be.
Correct. So we take the sale price and we adjust whatever difference it is downward, and then that comparable value is that adjusted sale price to try and make apples to apples then. You know, you had, a large apple and you have a smaller apple, so you still have two apples, and you need to make an adjustment for that additional size of that apple.
So it looks like then, to continue that logic, the three comps that are presented here, given that modifier to make the property comparable to the subject property of $559,700, $511,700, and $556,600, that the assessment of the subject property is actually less than all three of those comparables once the modifier is applied.
Correct. So if you look at the top of the sales summary sheet, it'll actually give her assessment, which is next to the estimated fair market value, and then the comparable market value of $536,700. So that's showing you the three comps and kind of that average between those. We do mass appraisals, so we will provide you with a sales comparable sheet, but this is kind of hard to explain. These comparable sheet isn't how the value is actually generated.
Sure.
This is just showing you support that our value is reasonable and fair. So we're taking actual sales and adjusting them. We do mass appraisals. So when we do that, we create models, like we talked about with the cost model in the land, to find the most average value. So even these sales may not be at their assessment may not be at their exact sale price, because we're looking at for that like average value for the city, because it's due to ad valorem tax purposes is the reason we assess. It's not private appraisal.
Okay. Anything else?
Can I just say one more thing, or not?
I guess you may.
I'm not quite understanding what Amy's saying, so,
Well, I can tell you that assessment is mass appraisal, not individual appraisal. And as they go through the process, they develop, using the Wisconsin Department of Revenue Manual, Volume 2, an estimate of the cost of replacement minus depreciation. And then they apply what they call adjustments for market. And that's a standard approach that they apply to all properties, so there's uniformity. As they put together this comparison for a review, what they have supports what they did, but it's not the way they derived the number, is what she's saying. So this is a basis of review that supports what they did, but it's not the exact method, which was the cost approach minus depreciation, to come up with your $500,000. So they're trying to help you distinguish the difference between mass appraisal, individual appraisal. When you have an individual appraisal, they're trying to determine exactly by looking at your property and three highly comparable properties, and they use that specifically to develop a value. They're using a hybrid approach, cost approach, then they look at the market and use that market on the cost approach to make adjustments.
but Mr. Colliard, why would you use a freestanding condo as a good comp to a duplex condo? Which one of those three is?
Because in a perfect world, you'd have all kinds of duplex condo sales. We're not living in a perfect world where the sales can occur.
But if you take the duplex condos from Glen Arbor with the new 2020 assessment and the same amount more square footage and a second story, it's still at 461.9.
I can,
Well,
when
I mean,
we,
if you're using the same dynamics to come up with an assessment.
we have an actual sales comp model also. So a lot of our stuff, because it's mass appraisal, we have a sales comparison model. And we'll go out to like 30 sales when we run that. In this case, these were the first 3 sales that come up. So they give the highest comparability rating and the least amount of gross adjustments. So that's how we pick those. We don't go out and handpick like a private appraiser would. We're doing mass appraisal, so our concept is we want to look at that. We will add in, when we look at these, in some cases, we might give you additional sales. We just are giving you these 3 sales to use, to support that value. We could have gone out to sale number 10 and given another duplex, but it would have been a further away neighborhood, or maybe a lower grade. So those comparability ratings would actually be lower. It would actually be considered a lower, not as good of a comp, because you have much more adjustments. They're still comparables and it's still adjusting. It's just, we're just giving you 3 comps to show that it's supporting that value.
And why do you have to average 3? Why can't we just take 5808 Dolly, because it's so completely the same, other than she has more upgrades and more square footage?
Well, even if we use just the one that is right next to you, that comp, when it's adjusted, comes in at $559,700. So if it adjusts it exactly to yours, that still is higher than your assessment. So that comp is still supporting your value of $500,100.
No, it would be 472.37.
It's not, they're not calculated on a square footage
Oh.
basis, on a cost per square foot.
okay, I think we've tried to get everybody's questions answered. It's time then for the board to deliberate as to what we feel is the best resolution to the appeal before us. I open it to the board for discussion.
I think it's a complex matter, but I think from all of the testimony and evidence that's been provided that the assessor's office followed the assessment guidelines as set forth by the state of Wisconsin. And I don't support sending it forward for re-review.
Okay? Any other comments?
Yeah, the assessor's answer to my question has satisfied me. The evidence and testimony provided by the homeowner, while thorough, did rely primarily on a cost per square foot basis, and the assessor has explained how that doesn't quite model the value, and further explained how the comparables that are presented today in connection with the testimony do model and support the value of the assessment. And I believe the assessor's presumption should stand, and it hasn't been overcome by the presentation today.
Anything else? If not, then I'd ascertain a motion. Sustain the assessment as presented at $500,000 for the 2020 assessment season.
So moved, $500,100.
100, excuse me.
Seconded.
We have a motion and a second. All those in favor signify by saying aye.
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 Let the record note that the motion carried unanimously. And thank both parties. I think you prepared very good reviews for us to consider. Thank you both for your due diligence in doing this morning. Now, just so you're aware, Ms. Rogers, if you're unhappy with the board's determination, there are continued appeal rights, which will be on the back of the notice that you are given, showing our determination.
Thank you.
Mr. McCarthy, if you're ready, we can have you come up to the table.
Mr. McCarthy, before we start, we'll have you sworn in.
You could raise your right hand and repeat after me. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please state your name and address for the record.
My name is Harold McCarthy, and the address is 2656 Micah Road, Fitchburg.
The objection form you completed, sir, indicates that the assessed value on your property, parcel number 0609152079-2, is $378,000. You feel the assessed value should be adjusted to $347,000. And as I did with the prior person, I'm going to read to you his basic statement. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled to overcome that presumption, you need to present sworn oral testimony providing that the assessor is proving that the assessor has erred in the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us in considering your appeal. The standards are: the best evidence is of value is a recent arm's length sale of the subject property. Next would be sales of reasonably comparable property. And lastly, all other approaches to value, such as the income approach on income-producing properties and the cost approach on special purpose or unique properties where there's not an active market. This time, please share any exhibits that you will be reading into the record. Do you have exhibits you'll be sharing?
I just have a statement.
Okay. Do you have multiple copies or just one?
I have two.
Please give one to the clerk. And as I did in the past, I'll ask you this question. Has there been a recent sale of the property?
No.
Did you attend the open book and review of the property record card with the assessor or the assessor staff?
Have I?
Did you review the book? Did you go to the open book and review your property record card with the assessor or the assessor staff?
I did it over the phone.
Over the phone, okay. The reason I ask that is if there's issues with what the assessor's record indicates, hopefully they've been corrected by going to the open book. You know, if they had the square footage wrong, or if they had it listed with a fireplace and you don't have one, that's the time to find those kind of physical variations. Sounds like you talked to them over the phone. That's an acceptable option. This time, Mr. McCarthy, please read your information into the record because our decisions are based on sworn oral testimony.
Okay. The assessed value of the property in 2019 was $322,200, and in 2020 it's $378,200, with an increase of $56,000. Zillow estimates the increase at 4.4% for my area, which would raise the value to $336,400. That's an increase of $14,200. And it's my understanding that the assessments must be based on fair market value, and the fair market value must be based upon property sales prior to January 1, 2020. The assessor sent me 3 comparable properties, which had an average sales price of $317,666. I sent 7 properties, which had an average sales price of $332,700. That's $15,000 more. And Zillow estimates the value of the neighborhood property at $330,953. I question, they constantly talk about 2,800 square feet. and 1,900 is on the first floor, and 900 is on the basement. I'm questioning whether they get assessed at the same value. One other thing is there's a piece of property at 5448 Quarry Hill, which is assessed at $331,800. This house was built in 2002 by the same builder who built my house and with the same floor plan. The difference in the assessed value for 2019 was $9,300, but the difference for 2020 is $46,400. That seems very excessive for similar houses. So that's my statement.
Okay. Your information says you've sent 7 sales to the assessor. Do you have any of that information for us to consider today?
I have copies here. Would you like those, or?
In the packet? Okay, if we have it in the packet, that's fine, we have copies. Anything else, sir?
No, that's my statement.
Okay, well, then we'll turn it over to the assessor. Please let the record note that the assessor and staff have been previously sworn.
Thank you. Amy is currently distributing the written information summarizing the basis for completing the 2020 assessment of the subject property. I will briefly summarize the written documents with oral testimony. On the first page of Section 1 is a summary of my qualifications to complete the assessment. My name is Nick Hare, and I'm employed with the City of Fitchburg Assessing Office as a residential appraiser. I have an Assessor 2 certification, which expires February of 28th of 2021. I've worked in real estate over 14 years and in the assessment industry for over 4 years. I work for the City of Fitchburg Assessing Office since March 2019, and I worked for the Department of Revenue's Equalization Department as a property assessment specialist for 3 years prior to that. I have a bachelor's degree in finance and real estate from the University of Northern Iowa and a master's of business administration from Drake University. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value referred to as the market value of a property as of January 1st, 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines that property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained therefore at a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used to determine the market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It identifies mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment rule, the estimated level of assessment is 100%. On the next page, you will find a location map illustrating the subject property's location. The next few pages of the property record card that contains the specific data on quantitative and qualitative physical characteristics of the land and improvement for the subject site. The first page shows that the property is a residential house that is located in the Quarry Hill neighborhood on the city in kind of the center of Fitchburg. The building permit history shows no recent permits on the property. The sales history, which shows the last valid sale date of April 21st of 2003 at $247,500. In the notes section, you will see the property was last inspected in January of 2010, and there was a 2020 open book appointment via phone. The land information shows it is one lot that is 10,439 square feet. On the third page, you will see that the house is a ranch, one-story residence. It contains a total area of 2,901 square feet of living space. It was built in 2003 and is a quality grade of construction of B- with overall condition desirability and utility rating of average. The fourth page shows a sketch of the property. The next page of the document is the market valuation detail that shows the breakdown of the costs of the property based on all the information. And it shows the replacement cost new of $333,264. Shows the depreciation of 24.19%. And then there is a market adjustment for the Quarry Hill neighborhood of 3%, which gives a total improvement value for the property of $260,200. And the model is based on Volume 2 of the Wisconsin Property Assessor's Manual on 2019 arm's length sales. The next page of the document is a map that shows the subject property and recent comparable sales. The next page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. We normally only include 3 comparables, but we added 3 additional from the owner's comparison list. And the owner also put on his comparison list that he sent to me 5216 Stoneman and 5215 Snapdragon. And we did not include those as they were 2020 sales, and those will not be reviewed or validated until looking at them for the 2021 assessment. So the properties we did use is 2644 Micah Road, which sold in September of 2019 at $349,900. 2645 Castle Rock Drive, which sold in April of 2019 for $350,000. 5475 Quarry Hill Drive, which sold in June of 2019 at $318,000. 5491 Quarry Hill Drive, which sold in February of 2019 at $285,000. December of 2019, 2864 Winter Hazel Lane, which sold in December of 2019 for $383,000. And 2869 Larkspur Lane, which sold in December of 2019 for $320,000. So the styles of these properties are split level, tri-level, and ranch. The property is the subject and sales gross living area, including the basement finishes, range between 1,970 and 3,009 square feet. The effective year built ranges from 2001 to 2007. And one thing I do want to point out on these comparable lists is the square footage of the first floor of this property is much larger for the subject property at 2656 Micah, the square feet of the first floor is 1,932 square feet, which is much larger than all of the comparable properties. And again, referencing the market valuation detail sheet, the first floor square footage includes the roof and unfinished basement, so there is a lot more cost to that additional square footage from the first floor. So when you adjust the sale prices for these comparable properties, the values are $389,400, $385,200, $390,700, $370,100, $387,500, and $361,100 respectively. The adjusted sale prices are of reasonable comparable properties indicate that the assessed value of $378,200 is a fair estimate of the market value of the subject property as of January 1st, 2020. In summary, there is not a recent arm's length sale of the subject property, and consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using the evaluation model based on volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties adjusted for the differences between them and the subject property. Thank you, and that concludes my presentation.
Thank you. Questions from the board? This point, I just have one question, and it's a point of comparison. The taxpayer has made the point that 5448 Quarry Hill is basically the same house. Do you concur?
I do not, since that was not one of the sales comparables, I do not have that information in front of me as to that being a similar property. I do not know the square footage of the first floor or the basement finish. I don't have that information in front of me as to the comparability of that property.
His statement is that it's basically the same footprint, and it's assessed considerably lower for the 2020 assessment season than his.
And
If that's the case, I'd like to know why. Can we get that information?
Would you like me to go look at that?
What was the address again?
5448 Quarry Hill.
You can get the market valuation detail.
card and the MVP?
So while that piece of information is being gathered from the assessor's records, do we have any other questions for the?
I do have a quick question just on the testimony. As I was reviewing the packet and we were going through the, this is the page that's labeled 2020 market valuation detail. It starts with the land and the lot value, and then it goes through the cost breakdown, replacement cost new, physical depreciation, and arrives at a value of $306,600. As you're giving your testimony, the numbers didn't track with what was in front of me. I think the number that you ended up at was something like $260,000. And this one, the one I have says 2656 Micah. Did you?
Oh, yes, I had I apologize. I was looking at a different sheet. I was reading, I apologize for that. So, yeah.
So if you could just confirm, I mean, so.
Yep, so for 2656 Micah Road, the subject property, so it is, the replacement cost new is $384,098, 22.5% of depreciation, the neighborhood adjustment of 3%, which gives a total improvement value of $306,600.
And now I think we have a record that concurs with the written information, so thank you.
Thank you for catching that. Any other questions?
That's one of the, oh, yeah. Oh, actually,
Is that the one that questioned?
Oh, yeah, I apologize. I guess that's what I was reading off. I do have the information for 5448 Quarry Hill. I apologize for that. I didn't realize that I had put this in the file. So he had stated the square footage was similar. So I show for the subject property,
Go
the,
through each line.
yep. So the subject property, the finished basement living area is 969 square feet. The property that he noted, 5448 Quarry Hill Drive, the finished basement living area is 450 square feet. For the first floor square footage, the subject property is 1,932 square feet, and the property at 5448 Quarry Hill is 1,801 square feet.
And there are other variables. His property has 10 fixtures, the other property has 7 additional plumbing fixtures. He has 2 fireplaces, the other property has 1 fireplace. His has an open porch of 136 square feet, a deck of 162, and a garage of 484. The other property has the exact same size garage, a deck that's smaller, 144, and a smaller porch at 55. The other property, his was built in 2003, and the other property is 2001. So there'd be more depreciation pulled off. So, a lot of times property owners will say it's just like mine, but they're not. So there's a lot of differences in those square footages, and that results in a different value.
Do you have an indication of the level of finish of 5448 Quarry Hill?
We have the exact same grade on both. Both are a B- grade. So the quality of construction is consistent with that. And so his property replacement cost new was $384,098, whereas the other property was $333,264 because it has lower square footages, et cetera. And then the depreciation again is different. That's based on the base value and that age. So his property has that depreciation of $86,422, and the other property has less depreciation of $86,113. Even though it's older, it's age 19, age.
Would you like to see property record cards and market valuation detail?
No, I just wanted to make sure that if there were identical properties, that apparently the taxpayer didn't have the complete information on that neighboring property.
And the land value is the same. It's $71,600.
So you can see, Mr. McCarthy, that neighboring property is not identical to yours. It's considerably smaller as far as the basement finish, and the first level is also smaller.
Okay, thank you.
Anything else? At this point then, I'd ascertain a motion as to what we should do. Discussion from the board.
I would move to sustain the assessed value based on the testimony of the parties today. It is apparent that the objector and owner did some legwork to pull together comparisons, and it's also apparent that the assessor took those into account and developed a comparison report, making the industry standard adjustments of those comparisons. So taking some of the information provided by the homeowner, but using the assessor's tools to adjust the configurations of the homes. The report and the testimony before us from the assessor shows that the value, estimated fair comparable market value on those is $381,700. The assessed value is $378,200, so those appear to be in alignment. And with respect to the other property, I do appreciate the assessor pulling that information and explaining to the board and the taxpayer present how those are different. I think it's important to understand how what may appear to be a very similar property is maybe not as similar as perceived. although I would also note that other assessments are not evidence that we can really weigh. We have to weigh subject sale or comparable sales, but I think it's good to have that information brought into the proceeding, although I don't think it's necessarily evidence that we can consider in reaching our conclusion, but I think it serves an important function, so I appreciate that. So with that information before the board, I would move to sustain the assessment of $378,200 for this property.
I'll second.
We have a motion and we have a second. All those in favor signify by saying aye.
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 Please let the record note that the assessed value will be sustained at the amount of $378,200. And Mr. McCarthy, as I told Mr. Rogers, on the back of the notice that you'll be given, if you're not happy with our determination, there is a continuation of appeal rights or information on the continuation of your rights of appeal on the back of that form, okay?
All right, thank you.
Mr. McCarthy, I just want to, this is Erica Ryerson over here, just want to let you know something, I don't know if you can hear me. So I think you made a good point in your materials about the increase in home values from 2019 to 2020, you know, being a specific percentage. And I just wanted to point out some testimony that we heard earlier this morning before you arrived, that part of what happened with the revaluation with Fitchburg properties this year is that Fitchburg property assessments had been based on cost tables from 2001 with modifiers applied. So it might seem like this year was a big jump, but really it's that in the past, the property assessments were not tracking with the changes in values over time necessarily. So this is kind of a correction year. So while it seems like things are out of step from 2019 to 2020, that might be because 2019 may have been overly suppressed. I don't know if that's helpful information or not.
All right, and looking at our agenda, we do have a 12 o'clock break for lunch. And my timepiece says it's 12:07. So I'm going to adjourn this meeting for lunch. We'll reconvene at approximately 12:30. We're back in session. As we start the second part of our day, I understand that we have the information on the, my computer, there we go, on the Hy-Vee and the other items that we were deferred till later in the day. The 11 o'clock deadline has passed, and we now have a comprehensive summary of those who have submitted their objection forms and those that haven't, to meet the statutory deadline of the 48 hours. And I thought we'd look at them individually to make sure we don't miss somebody. I'm going to ask the clerk to help me with this as we go through to make sure that all of the proper appeals and the owners are indicated, and we have the resolution as to what we need to do. Jonathan Jackson Jr., 2917 Fish Hatchery Road. Has that been received?
No, those are the ones that you have already approved. They are the
Okay.
ones that already filled in their paperwork or filed their complete paperwork. You want to read off the list of item number 12.
Okay, but you said on the summary page that the ones in red or yellow were pending? This page? One's highlighted in yellow?
Last night.
Well, I'll defer to the clerk. She has the official list that we'll go through.
So, Jeff?
Jackson's in number 13. I misspoke. We're looking at number 12.
So the ones on the agenda under item number 13, just for clarification, these are people that have turned in their completed paperwork, their completed objection forms. Property owners on item number 12, some of them have not completed their paperwork in its entirety and/or turned in their paperwork. So that's why they're separate. They were given till 11 o'clock today to do so.
So would you mind telling us which ones did of the list
Yeah,
under number 12?
yeah. So did you want to go through them individually and make a motion on them individually?
Yes.
Okay, so item 12A, his paperwork was turned in a timely fashion.
Please.
That paperwork was submitted on 9/16.
Okay.
And just to clarify that this agenda needed to be posted prior to the meeting, so these came in after the fact that after the agenda was created and posted. And just not pulled off from the agenda.
Okay, so item A, agenda item 12, has met the criteria. Do I have a motion to accept their appeal?
I move to accept their appeal.
Do I have a second?
Second?
Motion and second. All those in favor signify by saying aye.
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 Opposed? Motion carries.
Do we also need a motion, as with the items under 13, to empower you to sign a subpoena and defer hearing the appeal to a later date?
Can we hold off on making that motion until we determine which ones are accepted and then make one motion for all accepted?
Okay, understood. Yep.
UW Credit Union, item B, agenda item 12B.
12B UW Credit Union has not turned in the proper paperwork in a timely fashion.
Okay, so they have not submitted their paperwork in timely fashion. So therefore, I would ascertain a motion to deny their appeal.
So moved.
Seconded.
Moved and second. All those in favor signify by saying aye.
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 Motion carried. Let the record note unanimously. Agenda item 12C, Fred Elon LLC. Is that the same as Fred Fitchburg Retail? Or are those two separate?
Those are two separate.
Okay. So just item C, Fred Elon LLC, did they turn in their necessary files?
That paperwork was turned in this morning before 11 a.m.
Okay, so they have completed the form in a timely fashion. So we need a motion to accept their appeal as filed.
So move.
Seconded.
I have a motion and a second. All those in favor?
Aye.
Aye.
Opposed? Let the record note it was a unanimous decision. Fred Fitchburg Retail LLC. Did they submit their form on time?
Their paperwork was turned in this morning before 11 a.m.
Okay. So their paperwork has been, our objection form has been completed and submitted in timely fashion. So we need a motion to accept their appeal.
So moved.
Second?
Moved and seconded. All those in favor?
Aye.
Aye.
Let the record note unanimously. Carried. Agenda item 12E, Fahey Fields Apartments LLC. Has their objection form been completed and filed in a timely fashion?
It has, yes.
Okay. So we need a motion to accept their appeal.
So moved.
Second?
Motion and seconded. All those in favor signify by saying aye.
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 Let the record note, the motion carried unanimously. Hatchery Hills 3 LLC, have they filed their objection form in a timely fashion?
Yes, they have.
Please let the record note then that we need a motion to accept Hatchery Hill 3 LLC objection form as submitted.
So moved.
Second.
Moved and seconded. All those in favor signify by saying aye.
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 Opposed? Again, let the record note unanimous carried. Franklin Square Condominiums LLC, did they submit their form in a timely fashion?
Yes, they have.
Okay, so I need a motion to accept Franklin Square Condominiums.
Second.
Moved and seconded. I'm going to shortcut it a little bit. Thank you. Getting sick of hearing my voice. So Franklin Square Condominiums, motion and second. All those in favor signify by saying aye.
Aye.
Opposed? Let the record note, motion carried unanimously. Bowman Farms. This is agenda item H. Bowman Farms, Inc. Did they submit their forms in a timely fashion?
For that parcel number, that paperwork was turned in.
Okay. So Bowman Farms on their schedule, or agenda item 12H for parcel 609-031-1222-3. With objection forms filed timely, need a motion to accept it as filed.
I move.
Second.
Accept.
All in favor signify by saying aye.
Aye.
Again, let the record note, motion carried. Bowman Farms, agenda item 12I, parcel number 609-031-70603. Was their objection form filed in a timely manner?
That paperwork was turned in, yes.
Okay. So again, I need a motion to accept.
I move to accept.
Second.
Motion accept and second. All those in favor signify by saying aye.
Aye.
Opposed? Let the record note, unanimous decision. Bowman Farms, Inc. and Bowman Plaza Suite 222. That's agenda item 12J. Was their appeal form turned in on time?
So these parcels are all separate objection forms that needed to be turned in. So Bowman Farms parcel number 0609-031-5112-8 was turned in this morning prior to the 11 o'clock deadline.
And the rest of them?
Tracy, did they revise that form? Because the assessment on that form, that parcel is assessed with parcel 0609-031-52136, and the assessment included both parcels. The form didn't include both parcels, and the additional information they provided only appeared to be for one parcel. So I didn't know if they revised that to you.
So I did email them that they needed to provide a separate objection form for parcel 0609-031-5213-6, which they did provide electronically before the 11 o'clock deadline. Their assessment value is listed as 0 and opinion of 0. Would you like to view it?
So of this list of 9 or 10 parcels, 2 of them have submitted objection forms?
So if you look on Amy's spreadsheet where she's got the first red highlighted Bowman Farms, you'll see there's 2 parcel numbers. So the original objection form was only turned in for that first parcel number.
Okay,
The one below is the one that they needed a separate objection form turned in for, which they turned in prior to 11 o'clock.
Okay.
But there is $0 value in the assessment notice and a $0 value in the opinion of assessed value.
So it was not completed correctly, is the implication. Unless the assessed value was $0.
is it assessed with the other parcel?
It's, the 2 are assessed together. And so the total assessment they have listed on one parcel is not, and I guess we can hear it. I would, if you can, I would recommend you hear them both together. you know, that it would be acted upon as one economic unit, and that you hear both, and that both would be consolidated into one information packet.
So these are contiguous parcels?
Yes, yes, and the buildings overlap the two parcels.
Okay,
It's the old like milking parlor next to the old juice plant on Fish Hatchery Road.
okay, so an economic unit is one unit
Yes,
on two separate parcels.
yes.
So I move that we combine property ending, or parcel ending 5112-8 and 5213-6, that we combine the objections to accept those two objections as one objection together for consideration.
Okay, we have a motion, and both those forms have been filed, even though one's not currently the way we thought it should be. I have a second.
Yes, second.
Motion and second. All those in favor signify by saying aye.
Aye.
Opposed? Let the record note, the motion carries. So that should take care of all of the items through agenda item 12.
No, we still have the remaining parcels that they did not complete forms timely for those remaining parcels, correct?
No, those forms have been turned in.
Oh, all of them.
With respect to all of them? Mm-hmm. Any? Okay.
Yep, the 0609-0318815-2 was turned in this morning,
Okay?
and the other parcel numbers were turned in electronically last evening.
Oh. Okay, so I guess we have more parcels from
Right.
Bowman Farms.
Can I just clarify that you have these parcels listed?
Mm-hmm.
0609, 031, 50110. Do you have a form for that?
Yes.
And then 0609, 031, 74103.
Please repeat that.
0609, 031, 74103.
Yes.
Then 0609, 034, 85009.
Yes.
0609, 034, 86508.
Please repeat that one.
0609, 034, 86508.
I would think so.
No, strike the last three.
They were here.
The 5001-0, the 7410-3 and 8500-9. I am not showing forms for them. My apologies. We may want to do Bowman, the Bowman Farms at 3:30.
Okay. Keep things moving. Let's table this and come back to it at 3:30. We can make sure we have all those parcels of Bowman Farms properly rectified and identified in the record. Our next appeal was at 12:30. This is agenda item 14E. Jameson and Schilksbreyer, are they here?
Nope, our 12:30, it did not appear.
Okay.
Their objection form was turned in on September 8th, and they were notified of their time to appear on September 14th.
Okay, so they've been properly noticed, and they have not made the scheduled time. So I need a motion to sustain the assessment based
So
on
moved.
non-appearance.
Second?
I have a motion and a second. All those in favor signify by saying aye.
Aye.
Opposed? Please let the record note unanimous decision to sustain the assessment as presented by the assessment staff. We are now moving to our next appeal, which is agenda item 14F, which is the Halford appeal, parcel at 2621 Tarpleywick Drive, parcel 0609-142-9560-4. I see the property owners are here, and at this point, I'd ask them to be sworn in.
Mike, is this the one you were going to recluse yourself at?
Yes, Craig's going to basically carry the load on this one. Tracy?
Get organized here, sorry. Could you raise your right hand and repeat after me? Do you solemnly swear to, not repeat after me, but do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Please let the record note that the assessor and staff have been sworn in previously. Because the Halfords are friends and neighbors, I'm going to turn the coordination of their review over to
Yeah.
So, thank you, Mike. As Mike has done with the other objections proceeding here today, I'm going to read a few comments and some instructions for today's proceedings. We do have limited amounts of time to hear each objection and appeal. And so following that lead, I'm going to read this and give you some idea of the time that you have to make your presentation. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness And the Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the total value that's under appeal. The Wisconsin Supreme Court has given the BOR, the Board of Review standards of evidence to guide us as we consider your appeal. The standards are, first is the best evidence of value is a recent arm's length sale of the property. And next, we would consider sales of reasonably comparable property as evidence of value. Following that would be consideration of any other approaches to value, including the income approach and cost approach on special purpose and unique properties where there are not an active market or comparable sales available. This does not include a comparison to your neighbor's property or its assessment unless it recently sold in an arm's length transaction. At this time, and I note that before we got started, you did hand around a packet. Did everybody on the board get a copy of the packet and the assessor as well? Okay. And if you have an appraisal of the property for us to consider, the appraiser must be here to present sworn oral testimony for us to consider the appraisal as evidence. And the amount of time that we're going to allot is 7 minutes. And when you have 2 minutes left of your 7 minutes, I will give you a warning if you haven't concluded your remarks. I'm also going to, before I let you go ahead with your presentation, the first question to ask is, has there been a recent sale of the property, the subject property, in the last year?
No.
Okay. And did you attend, either in person or by telephone, the open book and review a copy of the property record card?
Didn't attend, used online information and talked to Amy Mercer.
Okay, so you had
And Dwight Frame.
You had a telephone call with the assessor, Amy Mercer?
And emails back and forth.
Okay. If you'd like, you can go ahead and start your oral presentation, and I'll let you know when you have 2 minutes left to conclude that.
Okay, we think our assessment of $629,000 is too high. It's based on errors that we think the assessing department made. Our estimate is, we put in our estimate is $533,000. It's slightly different because of an error I gave you as a correction. And we also reduced that amount by $25,000 to reflect zoning restrictions on our property, well code 11 protection area zoning and environmental sensitive area zoning for our property. Error 1, or as of 1/1/20, the assessing department changed our assessment to group from rural residential to unplatted urban service area. Then for determination of our 2020 assessment, the assessing department proceeded to compare our property to 4 rural residential properties. They're listed. Error 1, the assessing department made an error when it used the 4 residential properties for comparison. If our property is in the urban service area, the assessing department should have properties in the urban service area that were similar to our property to get an accurate change in value for assessment as of 1/1/20. We present a comparison of 20 properties in the urban service area in Schedule 2. Each of these properties is similar to our property. They each have a sale in 2019 and a sale in the prior year. So you can determine the appreciation of those sales over that period of time. In Schedule 1, we applied the average each year of the appreciation. If you look on Schedule 2, I'll show you, or Schedule 1, I'll show you. The assessing department information is the start year assessment, the start year average assessment ratio, the start year estimated fair market value of our property. We applied from Schedule 2 the appreciation or changes in value that took place over each of these years where the sales took place. On the far right column, you see 20 properties, and each of the respective years, the number of properties sold. We applied the appreciation or the change in value to the estimated fair market value by the assessing department to come to a fair market value estimate as of 1/1/20. We added up all those years' estimates that came to, and then averaged them, that came to $555,013 It was 557,790 on the initial sheet that we put in, that was the error. But the estimate is 555,000. So that comparison process takes urban service area, 20 properties, compares it to our property. The average assessment of those 20 properties was $509,600. Our assessment in 2019 was $506,900, $2,700 difference. The average assessment for those properties in 2020 was $544,870. Our assessment went up to $629,000. The average sale price of all those 20 property sales in 2019 was $532,638. The Zillow estimate for our property is $532,000, I forget what it was, but it's similar to the average sale price of those 20 properties. The zoning restrictions. We're in well 11 protection area. We don't have city water and sewer. We have our own systems. They're 24 years old. 5 other residents in Tarpalowick Hills have the same designation. Their septic systems and water systems are older than ours. If any of those fail, that whole neighborhood will have to go on sewer and water, city water and sewer. I estimated our cost for that at $25,000. Reduced our estimate of assessment by that $25,000. We also have environmental sensitive area designation for, I estimate, about 1.474 acres of our property. That means only 1.4 acres of our property is developable.
You have 2 minutes left.
The assessor made the second error in our opinion, by not giving any consideration whatsoever to those zoning restrictions. They valued the whole property as if it were developable, no zoning restrictions. So as I didn't take anything off for the environmental system, a sensitive area, because it's hard to come to a designation. So I used the $25,000 lump to take into consideration those two. The way it reads to us is the only value of that property is if a developer buys it from us and he uses that 1.474 acres as a payment in lieu of park fees. To value that at $70,000 an acre is, in our opinion, unacceptable. So we've got a comparable sales study of 20 properties, all sales in 2019, all had sales in prior years, so you can compare the appreciation. You had an average sales price of those 20 properties of $532,000. You had an average assessment that was very close to ours in 2019, and the 2020 assessment is at a level of $544,000 on average for them, the 20 properties, and $629,000 for us. Finally, the Zillow estimate presented in your packet is $532,874 for our property. So we're asking for a reduction of the $629,000 with the revised changes, $555,000 from the comparable sales estimate, less $25,000 for the zoning restrictions, coming down to $530,000.
Thank you. And at this point, I'll let the assessor make their presentation in support of the assessed valuation.
Thank you.
While they're handing out the packets, a quick question. This particular property is owned by the Fountainhead Jubilee Trust?
Yes, it's a living trust.
And the two of you are the sole trustees?
We're the trustees.
Got it. Okay, thank you.
All right, thank you. Nick is distributing written information summarizing the basis for completing the 2020 assessment of the subject property. I'll briefly summarize the written documents with oral testimony. On the first page, section 1, is a summary of my qualifications to complete the assessment. I'm Amy Mercer. I'm the city assessor for the city of Fitchburg. I hold an Assessor 2 certification. I've worked in the assessment industry for over 20 years. I worked with the Department of Revenue for 2.5 years in equalization, worked with City of Janesville for 8.5. Also have my degree in landscape architecture from the UW-Madison, and I've attended various courses throughout over the years. Section 2 states the purpose of assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of a property as of January 1 of 2020. Part A outlines the standards for establishing the value. State Statute 7032 outlines that property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore a private sale, when such sale conforms to the definition of recent arm's length sales. Part B contains a definition of the market value, including criteria that a sale must satisfy if it is used in determining the market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as the systematic appraisal of groups of properties as of a given date, using standardized procedures and statistical testing. As the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment role, the estimated level of assessment is 100%. On the next page, you'll find a location map illustrating the subject property location. The next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements of the subject site. To note some of the most significant data, the first page will show that we do have it in the neighborhood of unplatted urban service area. The zoning is rural residential, and we do have it as well in septic. The next page the second page shows the building permit history, which shows a permit for air conditioning, which was pulled out in 2017. There is not any recent sale of the subject property. The notes section discusses that we did have an open book appointment. The owner called and spoke with Dwight Frame, and then sent multiple emails, we explained the assessment process and reviewed the data. We emailed comparables and property record cards. The owner focused on a loft area next to construction site and neighborhood change. He also discussed the construction site. I discussed the construction site hours, which is adjacent to his property, with our department head at our department head meeting. That was one of his concerns, and they're only allowed to work during standard business hours and starting at 7 a.m. Data on the house all appeared accurate, and then the land value on acre-based large lot. The comps all supported the value, and the open book change was denied. The land is 2.874 acres is what we have it assessed at. On the third page of the record card, I will discuss, that contains the property data. So we have it listed as 2 stories because it has a second floor, a custom style home with aluminum or vinyl siding. It has the air conditioning. I've listed 3 bedrooms, 1 family room, 5 other rooms, 3.5 bathrooms, all average ratings for their equipment, kitchen, bath, interior and exterior. We have 2 gas fireplaces, 5 additional plumbing fixtures, The basement square footage is 3,085 square feet. Of that, 1,613 is finished off with finished basement living area. First floor is 3,085, and the second floor is a small loft area of 168 square feet. We have it as a B- grade and 100% complete. It also has some attachments, a screen porch, a garage, a couple open porches, and a patio. And that's on page 4. Page 5 of the record card is a sketch of the property. So you can see the configuration of the second floor, the basement area, and the first floor, the garages in those locations. Okay. The next few pages of the document are the market valuation detail. So on this page, you can see that the land record, we have it as 2.874 acres. The value next to that is that average acre for the total value. But when we value the unplatted, the rural residential, and we divided the rural residential unplatted into 3 neighborhoods this year. So we have the those that fall in the urban service area, those that are rural residential 1984 to present, and 1984 to past, older than that. So this neighborhood, the first 0 to 1.5 acres is valued at $70,000 per acre. And then 1.5 acres to 3 acres is set up as $35,000 per acre. So then all of the data on the main record card pulls into those base prices. And so the replacement cost new is $601,514, less the depreciation of $168,845. And then there is the market adjustment of $43,267 for the neighborhood, for the total of the 2-story improvement portion of $975,900, plus the land of $153,100 arrives at $629. The next page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. So comparable 1, we have 6 comps that we included in this. To kind of just show an array of properties throughout the city that fall in these type of properties. So the sale price of comp 1 is June of 19 of $998,700. When adjusted, that sale price comes to $763,300. The comp number 2 is 2689 McGaw Road. It sold in September of 19 for $400,000. Adjusted to the comp, it comes in at $659,300. Comp number 3, 2822 County Highway MM, that sold in September of 19 for $312,500. And adjusted, it comes in at $634,900. Comp number 4 was April of 19. It sold for $757,150. And when adjusted, it comes in at $667,050. Comp 5 is 2177 Kane Road. April of 2019 was the sale price at $610,000. Adjusted, it comes in at $662,700. Comp 6 was 2364 County Highway MM. It sold in October of 2019 for $450,000. When it's adjusted, it comes in at $623,400. So the estimated fair market value of the subject was $629,000. The average for the coming in as including these 6 properties with $671,100 would be the comparable market value, looking at these 6 properties. Each of these properties were adjusted for the differences. So you can see that the land value is being adjusted for the additional acres for each property, and the different types for each property. Comp number 2, I believe, is, if I remember right, that has an additional parcel, and that's why there's 2 adjustment lines on that. So each of the comps, the square footage is adjusted, the land value is adjusted, so any differences between these properties has an adjustment for each and every difference in them. So, in summary then, there is not a recent arm's length sale of the subject property. Consistent with the property assessment manual, we prepare a mass appraisal assessment of the property using a valuation model based on volume 2 of the manual and 2019 arm's length sales. That mass appraisal of assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties adjusted for differences between them and the subject property. Thank you.
Questions from the board? I don't see anybody's mic lit up, so I'll ask one that I have. I actually have 2. The first is the statement of the objector refers to the, I guess what I'll call the environmental restrictions on approximately 1.5 acres of the property. And I'm just wondering, is there a way that the assessor takes into account those types of restrictions when valuing the real estate?
We did not take that into consideration. He did not bring that to our attention or discuss that, so I have not looked into any of that. This is the first I've been brought to my attention of that. Those are throughout the city, and it isn't something that we make an adjustment for or an influence factor. If we know something like that exists, then we could look and find, specifically look for other sales like that. But we did not take that into consideration because it wasn't brought up to us.
And so just on the land, the property card says it's residential land, 2.874 total acres. The value of the land in the unplatted urban service area is the neighborhood, although that's obviously not a neighborhood. And the value per acre is $53,000 and change to arrive at a value of $153,100. Tell me how the assessor's office comes up with those figures to value on the per acre value of the land.
So we look at the sales that happen on vacant land sales, so we look at that. That's how we arrived at land values to begin with. And then we look at improved sales. And so when we have improved sales, we will take, we have the new cost tables. So we'll use a method called abstraction. And you take this improved sale price less the improvement price, the cost of the improvements, and that will leave you the residual for the land value. So then we looked at it that way. And then we'll often look into, this wouldn't be the case in this, but then we might look at a land to building ratio. So for traditional, like a platted lot area, we often will look at a land to building ratio that typically comes into 1:4 or 1:5 land to building ratio. But because of the size of this lot, that doesn't play a factor in that property.
So, I'm sorry, so you mentioned that acres 0 through 1.5 were valued at $70,000 per acre.
Correct.
And then acres 1.5 through close to 3 or up to 2.8.
Up to 3 acres.
Yeah, were valued at 35,000 an acre. And so that 53 to 60, that's just what happened after those two amounts were factored in.
So, yeah.
So is that part of the typical assessment, that anything over 1.5 acres then is assessed at that lower
Yes,
rate?
so that's in the actual land model for the urban platted service area.
Okay.
And then it's above that also, you know.
Sure.
But I only stated those. That's the same land model as the urban service area, or the rural residential neighborhood also that he referred to.
Oh,
So it's the same land model
okay.
being used in the two. What we call the neighborhood, the urban service area neighborhood, the two rural residential and the urban service, they were all in one neighborhood in the past, having the exact same land values. Because in those properties that are in the, what do I call, the new rural residential neighborhood, you know, they're not in the urban service area, so they don't have the same potential as those in the urban service area.
So if being in the unplatted urban service area didn't change the land valuation at all from being rural residential to being in the...
No.
So then, did it change anything about the assessment value at all? Did it change the assessed cost of improvements?
No. It's just a matter of, we kind of divided those out so that in future years, we can watch the trends.
Okay.
So we can see if these properties have the ability to hook up to sewer and water, will they sell differently? So it really isn't changing anything right now. It's a matter of when we watch sales come through in the future, these are anticipated what might occur. So it really isn't. It's more of, we were trying to look at those aspects, the year built, kind of those restrictions on certain areas, things like that, when we separated those out.
So if being in the unplatted urban service area didn't change the land valuation or the valuation of improvements, and if you weren't aware of I forget how they were phrased, the restrictions as far as needing to join up to Fitchburg water and sewer at some potential future date, would that information impact a future assessment perhaps? Or would that be something that would need to be considered in the future? Or is that not something that's typically factored into an assessment?
We would watch for anything like that. So typically when we watch for things, or when we see things, we let the sales talk to us, let's say that. So if all of a sudden we see that certain properties, there's a difference each year when we look at market adjustments. So this year was different, using the costs and the land and setting things up. But in future years, if we see that a neighborhood has distinct separations, like where you see a different strata, basically. So some sales might be at distinctly only going up 5%, and other sales are going up 10%. And we don't see that blend between the 5 and 10, then we're like, what's going on here? And then we would say, oh, you know, this is what's happening. And that. If we don't have information to point us to put an influence factor on, we don't have sales that say, oh, we got to take this. Otherwise, you're just pulling numbers out of a hat. So we have to analyze what the sales are doing and telling us. So nothing has like shown us that or is showing us any impact that has an impact right now on these sales.
Okay.
Our sales within here all are variable. You know, the rural properties in Fitchburg, because it was a township, is very unique. We have older homes in the urban service area, and then we have older homes in the rural, and we have brand-new homes in the rural. So it's a challenge to value those, and especially with the land values, the land within the city.
So, Mike, don't know if...
Just one other question. I looked at the the list of comparable sales, and none of them overlap with the comparable sales that are in your presentation. And in looking at their list and comparing it with your list, it appears that everything on their list is in a neighborhood. Lacey Heights, Seminole Hills, Harlan Hills, Seminole Hills, Harlan Hills, Seminole Village, Highlands of Seminole, et cetera. And then the comparables in yours all reference either unplatted urban service area or rural residential. So can you just speak to, you know, again, they're suggesting that their list of comparables from these, what I would call in-neighborhood homes, should be considered in looking at the assessed value. Can you explain why you didn't include any of those houses in your?
See, and again, this is the first I'm seeing this stuff, so, okay. So like, I believe Tree Lane, Edenberry, Winsona, those are like actual residential neighborhoods. They'd be hooked up to sewer and water. They're in different neighborhoods. And each of those many of these that I see, it's Highlands of Seminole, Oak Meadow. Yeah, so these are all other neighborhoods. And when we value properties, we classify them based on a neighborhood. We first look at those sales within each neighborhood, and then we'll put them into neighborhood groups. From what I can see on here, and without looking at the computer or anything, based on just knowing the city, none of these would even be in their neighborhood group. So they're not, to me, comparable sales for his property. The acres, the size of the land would be significantly different. You know, most of these neighborhoods that I see on here, they would be valued typically on a lot basis. And the lot basis on those is significantly higher than what his is being valued at. So.
You mean in terms of the per acre price?
Yeah, those are actually, they'd be coming in at typically, most of the residential properties come in, other than like Terravesa, they're somewhere in the range of like 0.2 acres to maybe half an acre are most of the lots. So like some of these like Seminole Hills and that, I believe Harlan Hills, those are usually around like 0.35 to a half acre lot. So I believe like Seminole Hills, and I'd have to look, the AAR would actually list what each neighborhood comes in at. But like a typical residential lot, like in Wildwood, those are anywhere ranging from about $70,000 to $80,000 for a lot, which is only like around a quarter of an acre. So the rural neighborhoods and the neighborhood he is actually in, that land value is significantly lower than many of these other neighborhoods that he has listed here for the land value, if that's making sense.
I think the objector had.
I just have a question, and then I'll let you make the comment too. So I'm reading the sort of conclusion paragraph, and your conclusion is that based on comparable sales analysis, you estimate it should be 558. And then you say a further reduction of 25,000 to reflect the negative impact of the zoning restrictions in place due to being in the well protection area, which I understand the point about if you use the well and septic and enough of those fail or one of them fails significantly, then you're going to be forced to attach to the city infrastructure, and that has a cost to it. I understand that point. And then it says, and to having 1.74 acres and our home designated in an environmentally sensitive area. So you attach a value to the comparable sales analysis, and you attach a further discount of 25,000 to the well protection area. But in a little bit more concrete terms, what do you say that this environmental sensitive area, what impact does that have specifically on the value and explain why.
I think the impact of if I were to put a value on it, I would, one, refer to what's the standard payment for payment in lieu of designating or giving the city the land in payment instead of paying park fees. In lieu of that, I don't know what that is. I didn't have a chance to track that down. I look at Promega as an example. They have some forest in the urban service area that's, I think forest is valued at $4,700 an acre. I've seen swamp values assessed at $1,000 an acre. We're environmentally sensitive. Our understanding of it is we can't do anything with it. We don't want to do anything with it from our own standpoint, but from the standpoint of marketing to somebody else, if we decide to sell the property, we got two people we can sell, or two entities we can sell it to. Somebody who's perfectly satisfied like we are, the way it is, will take the environmentally sensitive area, or we sell it to Gold Leaf Development, the developer developing 400 apartments next to us, because he's the only one that really can use the land and get a benefit from the payment in lieu of park fees. So if I were to put a value on it, I'd put 1.474 times $4,700, or 1.474 times $1,000, because that's the valuation I see in terms of what we can do with that land.
But the 1.474 acres, that part of it, your house is constructed on that?
That's correct.
Okay, so the existing.
Statement, we could not build our house under the environmentally sensitive area rules now. Those rules were put in place in 2007. We built a house in 1996.
I know with,
I'm sorry, I did want to just give you did have your hand up before, and I think you wanted.
Yeah, one of the things I'd point out just on the well protection area, if you look at that map that's part of your packet, we are the only neighborhood that's really impacted by that well protection area anymore. McGaw Road area already has sewer and water. Lacey Road already has sewer and water. So we are the only one where each year goes by, the probability that we're going to be hooked up is going to go up. So that $25,000 expense is probably, we think it's legitimate.
the,
And the other thing in terms of how we looked at this process, we were supposed to look at a total property process. We looked at it and said, okay, we got somebody that's got $500,000 plus or minus to pay for a property. We looked at similar properties, mainly similar to our house. That's what you buy when you're buying usually a property. People don't spend a lot of time, I think, on the land portion of the property. They look at the house. The land values, we looked at the land values of those particular properties, or we looked at the properties because they were similar to ours, they were similar in price, and they had similar assessments on an average basis, so we thought that they reflected a reasonable comparison to our property.
so can I?
Yep, go ahead, Amy.
All right, so you can see his subject property, if you look at the map, he is adjacent to Tarpleywick, the neighborhood right next door. So to get to his property, you have to go through that neighborhood to get into his property. Tarpleywick, we just looked in our land valuation model, which is included in the annual assessor's report. That neighborhood, average lot is at $72,000 per lot, which is less than, can I see here, does it give the average?
No, it doesn't.
Okay, all right, so sorry, I was hoping it would have the average size in here per lot, but it doesn't. But I know those lots are not an acre lot, and they are also well and septic. So if anything goes, they'd have to re-put in a well and septic or a mound system into those properties also. So, and I know there's, I think there's a couple properties in there. One property owner owns 3 lots. And so in that case, we have a similar process. The first lot is at the full value, the second lot, we do 50%, and the third lot, we do 25%, because those other lots are being used as his mound system, and it's what do you want to call it, tertiary land. It's land that they need for those, you know, for their mound system and things, but I don't believe his land is excessive in any way at all for that lot.
May I respond to the person who owns three lots?
Yep, then we have to wrap it up.
The person who owns 3 lots doesn't have any of that land classified as environmentally sensitive area.
Okay,
May I make a comment?
briefly.
I would just say that our lot is also just one lot. It was approved for just one residence. It's not like we could subdivide and build other residences. It is one lot, the same as the lots in Tarpleywick Hills are one lot. So the fact that it's larger is because that was the way that the lot was parceled off when it was initially created. It needs the additional space partially for the mound system that we have on it.
Okay.
Just one last comment. If somebody has roughly $500,000 to pay for a property, they can buy our property, which has its restrictions and has 2.87 acres in our house, and they have a choice among a bunch of neighborhoods in Fitchburg. Those were the comparisons we used. And they were very close to our assessment process and very close to our valuations. Zillow is very close to our valuation.
Okay, we'll conclude it there. Comments and deliberation from the board members. Discussion.
And I think a lot of work went into the objection, and I think that it is a complicated case, being a unique property with restrictions, but also advantages. It sounds like, you know, it could be valued the same as land in a more traditional neighborhood, because then the assessment would be far, far higher on a per acre cost for just the land. And so I think it's appropriate that the land was assessed the way it was. Whether the improvements on the land were assessed correctly or not, I guess, or whether all the modifications took place, I guess I'd like to discuss that.
Other comments? My review of the assessor's testimony and the information, the written information or exhibits they provided, it appears to me that their focus was on other rural residential comparables as opposed to those found in neighborhoods. And I understand why they selected those properties as comparables versus what was shown in the information circulated by the objecting property owner. And I understand the speculative impact of the well system issue, but it is a factor that's present for potentially other rural properties as well. And I note that a number of the other rural properties listed in the comparables are well and septic, though not every single one of them is. They all appear to have well and septic as well. And one would think that in purchasing those comparable properties, prospective buyers looked at the issues that come along with property in rural setting, including
well and septic system, both maintenance, age, replacement, and similar items. So I'm satisfied that the comparables are accurate. The one issue that, we don't have a lot of information on is the impact of the environmental assessment. I do note that the existing home is situated on the land that's apparently impacted by that environmental restriction. So it couldn't be torn down and rebuilt, but the existing home, to the extent it's saleable, is already there and grandfathered in apparently with those restrictions in place, so it has saleable value. So at this point, I think it's a closer one in that respect. But, as I noted at the outset, the assessor's valuation is presumed correct, and I find that the mass appraisal is supported by the comparable sales, and we might be lacking a little bit of specific information on the environmental impact or environmental assessment impact, but I don't feel that there's enough here to
Send it back.
to overturn the assessor, given the presumption that the assessment is correct and the other information that's been presented in support, including, again, comparables, sales from rural neighborhood areas that have similar characteristics as those described by the property owner. So those are my thoughts, and I welcome other comments and discussion. Anything further? Does somebody want to make a motion on this particular property?
I move to support the assessor's assessment.
We have a motion to sustain the assessor's valuation of the property. Do we have a second?
Second?
We have a second. I'll call a roll call vote. Please signify your vote in favor of the motion by saying aye.
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 Any opposition to the motion? Hearing none, the motion carries with a unanimous vote, and the property value by the assessor is sustained at $629,000. Thank you to the parties for presenting information, and that concludes this hearing agenda item.
Thank you for your time and consideration.
Thank you for coming.
Mr. Halford, please don't leave yet. I've got to give you some forms.
Pardon me?
Don't leave yet. I have to give you some forms, okay?
Okay.
Well, and it should be noted that on the back of your forms is instructions on how to appeal this decision by the board, if you should wish to do so.
Thank you.
40 minutes behind. Thanks.
Does anyone else want to file a motion to raise the temperature in here by like?
I'm burning up.
Do we both sign? You can both sign, absolutely. Okay. assessment.
Should we?
Well, as I can.
All right, thank you so much. Stay well.
Thank you.
Yeah.
Crazy times. Oh, yeah, well, always happy when the folks are doing that at the grocery store.
Well, helps everybody.
I'm going to, Chair, Chair, Mike, I'm going to recuse myself, being an old friend of Tony's. I'm going to recuse myself, being an old friend.
Yep, so this is Carolyn Har and Henrik Hartman, address 5680 Wayland Road, parcel number 0609-212-9860-6. And I will hand it over to the chair. For the record, Richard Tate has recused himself.
More paper than we've ever had to deal with. This is more paper than we've ever had to deal with before at the Board of Review, so it's both electronically and in paper form. It gets a little challenging sometimes. So we are listening, or preparing to hear Carolyn Hauer and Henrik Hartman.
Yeah,
Next one
actually,
up.
sure. For those of you who don't know, most people call me Tony, but
Okay.
Henrik is the legal name, and I guess this is the,
All right, a little bit before we start, we need to have you sworn in. I'll ask the clerk to give you the oath.
Raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Tony.
Thanks, guys. Should I fire away?
Nope, I have something to read to you first.
Okay, sure.
Just reviewing your objection form to make sure we had the information completed on the form. And then I'll read this and turn it over to you. You're trying to keep things on a schedule, so we're going to ask you to read completely into the record what you want, because it's based on sworn oral testimony. Chapter 70 of the Wisconsin statutes give the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us in considering your appeal. The standards are: best evidence of value is a recent arm's length sale of the subject property. Next, sales of reasonably comparable property. And lastly, then all other approaches to value, including the income approach on income producing properties and the cost approach on special purpose or unique properties where there's not an active market. At this time, we'd ask you to share any exhibits. I guess, did you have any exhibits?
Just the one I just gave Tracy.
Okay. Remember, the testimony is going to be what you put in the record. That's what would be reviewed by the circuit court if it did go that far. If you have an appraisal, you would have to have the appraiser here. He must be present so he or she can present sworn oral testimony before the board can consider the appraisal. A couple questions for you. Has there been any recent sale of this property under appeal?
No,
Did you attend the open book and review the property record card with the assessor?
no, it didn't come in person.
Okay, but you did speak with them during
Yeah.
the open book period,
Correct.
and you're satisfied the information they have is reasonable and correct?
I guess you could say yes. I mean, the reason I'm here is because I don't agree that it's correct, but,
Not the value, I'm talking about the description of the property.
oh, okay, sorry, yes, absolutely.
Okay, we don't want to have physical differences when you're talking about one thing and they're talking about another, so that's why.
Totally get it.
Checking those records, if you're in agreement with what they've had, then we don't have to worry about physical differences. Okay, then at this time, I'm going to ask you to present your evidence in approximately 7 minutes. And in that 7-minute window, I'll give you a warning at 2 minutes so that you know that you have just 2 minutes left to complete it, okay? Please begin. Please begin by identifying yourself for the record.
Sure, so I'm Henrik, also known as Tony Hartman, and my wife Carolyn Hare is working today, but she said she put her faith in me and I should come. We do live at 5680 Wayland Road, which is the top of the hill. If you're an Iron Man, you've been out of breath up there several times, out on Wayland Road. And I want to start by just thanking everybody for their volunteer time, because I've been where you are as an alder here from 2015 to 19, in fact, sitting where Rich is. And I guess I understand the responsibilities and the challenges, so thank you. That said, I'll try to respect your time, get to the point. Our request for review of the new land assessments based on fairness. I think it was Ms. Halford's point, I'm sure I'm not the first one to come to you and talk about land value in this round. I guess we understand that this is a year that they're trying to reboot, the assessor's trying to reboot on land valuation. But after, opening up our mail and the shock of a nearly doubled land value, I called, of course, and I got a call back from Nick here. He explained that, about the new way of assessing land was based on an effort, I think, to reconcile existing valuations with recent sales. There were a couple of 2 to 3 acre lots at the opposite end of our street, at the east end of Wayland Road, down where Gary Gorman lives and several other folks with some high value properties. So it's a far less trafficked part of Wayland Road, so I feel like it's maybe in some ways not a really good comparable. Other busy roads like County MM and stuff seem to me a little bit more like what we're on, or Schneider Road, but at any rate, lots of higher value homes down there. As we stated in our letter, I guess we believe these couple of sales, there aren't that many, they're fairly rare, actually are splits. They are, an attempt to help older farm families, capture a certain amount of development value from their, otherwise agricultural properties. Besides being rare, their sales, tend to inflate the value of everyone else's land, and I think that's what I'm hearing, but you guys have been hearing it all day, so I won't belabor that. I guess I think the assessor's attempt to be fair and reevaluate has actually created sort of a 2 to 10 acre purgatory, if you will. I mean, if I understood Nick correctly, they're stepping down from full value after 1.5 acres. Now, this is on G1 properties, so residential properties, to something like 75% on the next 1.5 acres. And then I believe it was 50% of full value on beyond 3 acres. I don't know if I have that correct. That was from memory. But it seemed logical on the surface until, you see what happened to our neighbors. And my son, who's 23 and was showing off his Excel skills, quickly went to the county's website and just, put together this analysis, which I'll get to in a second, but I wanted to just point out that the folks, I guess the graph on the back is kind of telling the folks that are in that 2 to 10 acre purgatory have, the nearly 100% increase in land value, while folks with, a smaller, 0 to 1 acre parcel have little or no increase. Same thing with folks in the 40 acres, or 35 to 40 acre range. And he just went right down the road. He just took the nearest land neighbors, and he was able to create this graphic, and that's represented on the other side here. I'm sorry that doesn't have our name attached to it, and hopefully you guys can scratch that on there, but
Can I just interrupt you?
Yeah,
I'm
sure.
not hearing anything about sales information or documented concrete information that the assessment's incorrect. So you're comparing land value, or you want your land value, it's the total value that's under appeal, not just land value. So
Right.
we need evidence to consider that relates to the total value of your property and sales information or market information that supports your conclusion or opinion.
so you're only looking for sales?
We're looking for the best evidence of information, which is typically sales of reasonably comparable property if there's no sale of the subject.
So if I'm interested in talking to you about the way these parcels, which are somewhat unique, they're almost all one-off, are valued, I'm in the wrong place?
Nope, you should be presenting sales, specific sales of 2 to 10 acre parcels, showing what those parcels are selling for per acre and how it compares to your property.
Well, I guess, and I'm giving you this spontaneously, but my opinion is they're very, very few. And so, like the stock market or anything else, if there's very few number of comparable sales, they're probably not very accurate. It's like any research. You would have as much information as you could. So instead, I'm trying to look at similar properties and say,
That doesn't work. That
Okay.
doesn't work at the Board of Review.
okay,
That's not our criteria, and I can understand what you're trying to do, but that doesn't apply to what we need to consider.
so you do only want to hear about sales?
We want to hear about sales, and the reason your property is, in your opinion, incorrectly assessed, supported by sales, as compared to what the assessor has done, because their work is supported by sales.
Okay, so if I'm interested in seeing my designation possibly change from strictly G1 to, say, G1 and undeveloped land, or G1 and ag forest, or something else, how do I go about doing that?
It's not at the Board of Review. So I don't know how you go about it, but it's not at the Board of Review.
Okay. Well, I guess the point I heard here at the end is, we can't develop our land. There's one house on it. We can't even put an outbuilding on our 4 acres. There are people with 2 acres less of trees, and their valuation in my neighborhood is half of what mine is for land. I'm just talking about land now. And in my mind, that's not fair. I think their attempt to adjust is maybe in the right spirit, but the way it's worked out is not at all fair. So there aren't a lot of sales, so I don't know what to tell you about that. I was, prepared to, I guess, go through the logic, I think, of what I'm saying and what I'm asking for, which is a 50% increase in my land value rather than a 100% increase.
But you see, you're trying to appeal the land. At the Board of Review, you appeal the total value, not just the land value. We cannot just appeal one part, it's the total. And that total includes any improvements on the property for which you presented no information at all.
I'm not arguing about the improved value.
That doesn't matter. That's what we have to consider at the board, is the total value of the property. It's in the statutes. Not one part A, not part B, the total. Why is it separated on the assessment rule? The only reason is because the assessor by statute has to do it. If you look at the tax roll, it's one number. Your taxes are based on that total. That's what you're appealing, the total. Not the land part, not the improvement part separately, the total.
Well, I'd like the total to be $45,000 less, so I'll go on record as saying that. It's half of the increase in the land value, which you say is, not really how you want to examine this. I get it. You guys do it the way you do it, but I'm looking for a $45,000 reduction in the new assessed value, which happens to be $45,000 more than what it was, so.
Okay.
Well, and yeah, I looked at the statute on this too. I'm content to let the hearing proceed and let the assessor present, but I don't think we even have a proper objection before us for consideration, because in reviewing the written submission and now hearing the testimony, the entire focus is on the land, and 7477A says we can't split it up that way, and that no person can object to only the land valuation. So again, I'm happy to have a full hearing and hear from the appraiser, but I also note, as the chair did, that I don't think we have in a sense, a proper objection to the assessment because it 100% focuses on the land, and we don't have any evidence of comparable sales in any respect. So that's my thought on that, and I'll let the chair decide where to go.
Well, I concur in that. As I was looking at the objection form, I told you there's too much paper. We should have never taken your appeal because the objection form's not fully completed.
Did you get the one, because Tracy actually asked me to put a figure on it.
I do have one with a figure
okay.
on it, but
And it's just one page, and then a second page, which is one paragraph. So I'm not sure for sure what you're looking at, but I thought I was giving you less to look at, not more.
it's the form that you submitted. I'm not sure when. It's
The
sort of
objection form dated September 17th was the revised objection form.
whatever. But anyhow, based on what you've told us and what I've seen, I don't see any reason to continue this appeal because we cannot, by statute, separate and try to adjust a land value exclusively when we're looking at the total value of the property under appeal.
So I would like to continue with the hearing in part because I know for other objections, both today and at other times, we've heard objections that have centered on, whether their house is really, whether the improvements are really as valuable as asserted. And while they haven't specifically mentioned land, they've mentioned the total assessed value and wanted to dispute that, but their basis for dispute was on the improvements. So I would like to go ahead and hear the reasoning.
I will strongly disagree because we have to follow the statutes. And the statutes give us specific guidance that we cannot and should not hear an appeal when it's strictly on one element of the total.
Okay.
So we're going to follow the Wisconsin statutes in this case, has been noted, and we're going to adjourn. We're going to reject this appeal because it doesn't follow the correct guidelines of the Wisconsin statutes.
Mike, do you need to vote on that?
Sure. We don't need to, but we can, just to make sure everybody's in agreement with what the statute says.
I would make a motion to reject or deny the objection as not being properly before us because it impermissibly seeks is an objection to the land only when and let me confirm, this is land and improvements, the parcel is?
Yes.
It's land, okay, so we have a parcel that is land and improvements, and the only objection before us is to the valuation of the land, and that is not permitted under Wisconsin statute 747 7A. And so for that reason, I would make a motion to deny a further hearing on the appeal.
We have a motion, do I have a second?
Second?
A motion and a second. All those in favor signify by saying aye.
Aye.
Aye. Opposed?
Opposed.
Let the record note, there was one no vote. Majority carries. Appeal is dismissed. Thank you, Mr. Hartman. I'm sorry that your understanding of what we could do was not correct, but we have to do what the statutes guide us to do.
Well, again, thanks for your time. I appreciate you guys volunteering. Spending your day here.
Two o'clock is rough. RUFF. I don't know if it's.
So we have Bill and Vicky Ruff, 2826 Richardson Street, parcel number 0609-092-7155-0.
Welcome. At this point, I'm going to ask the clerk to swear you in.
Nope, just raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Thank you for coming this afternoon. Before we start, I'd just like to go over a few things with you. This is a property assessment appeal, and I'm looking at your indication of value on your objection form. Indicates that your property, I'm not sure, it says there's two, one at 331,400 and one at 308,800. So are there two parcels or two properties, or what is this?
We complained about the first one, and then they cut down the second one. They reassessed the second one.
So the current assessment is 308,800?
Yes, as far as I understand, yes.
Is that correct? So that open book, they adjusted it. So we're looking at an assessment today at 308,800, and the indicated value you feel it should be is 293,400.
Yes.
Okay. Everybody clear on that? Objection form? Okay, Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to be sworn, to present sworn oral testimony proving that the assessor has erred and determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. The standards are, first, the best evidence of value is a recent arm's length sale of the subject property. Second, would be evidence of reasonably comparable arm's length sales. And lastly, would be all other approaches to value, which would be for income-producing property, the income approach, or for unique individual properties like where there's, not an active market, where we would then look at other approaches to value. At this time, do you have any exhibits that you would like to share with the board?
All I can say is that I provided a list of exhibits in a 4-page, if you will call letter or note, and I presume everyone has one of those.
Should be in your electronic packet materials.
Okay.
And
Nothing additional for that besides the materials already presented?
well, I might have,
Okay,
and I'm not sure. It all depends on how things go.
all right. Since we have a full agenda, we're going to give you approximately 7 minutes to present your evidence. Make sure you get everything in the record you want. And at 2 minutes, I'll give you a warning so that you make sure you know that I'm not going to cut you off in the middle of something. A couple questions before we start. Has there been a recent sale of the property under appeal?
No,
Did you attend the open book based on a review and review the property record card with the assessor?
well, we talked to them, of course, they didn't have any open book, but we talked to them.
Okay, so you have reviewed the property record card and talked with the assessor recently.
Right, well, yes.
All right? At this time then, please start presenting your evidence.
Okay, I just have one question. Did each of you read our 4-page note here on what it is? And also, I want to ask if any board member has discussed our property with any of the two assessors here at all before this meeting?
I have not.
Okay. As you note in the situation here, our house is at 2826 Richardson Street. It's a Midland home built in 1995. It's a ranch home with approximately 1,776 livable square feet. The basement is not finished, and there have been no additions to the property in 26 years. We purchased the properties in 2003 and are the second owners. We believe, as we say, the assessment should be around $36,000 or a 14% increase to $293,000. We originally received assessment at $331,000 or $74,000, which is beyond our reason why. And then it was knocked down to, like I say here, it was knocked down to, well, whatever it is. We actually had an increase of $2,000 after we asked Nick to come over and look at the property, and we were told because of a sink that was always the original, and they had $2,000 to it. All we're looking for from your group is that we be assessed at a fair and reasonable price. That's all we're looking for. We looked at the neighborhoods. We have on sheet 1, Exhibit 7, we looked at all properties in the neighborhood, and they show that the average increase in the assessment is $31,000. The average percentage increase is 10.9. Our second one came out to $51,400 or 20% increase, which, and if you look at that exhibit, the square feet, you will notice that we have the smallest, the square footage. The only one that's close to us is a 2-story, and they were able to cut down their assessment to a 9.7% or 25,000 or 283. There was another couple of properties on Lancaster that is a half block away from us. They're beautiful houses. They're a lot bigger than ours, and yet their assessments were 4.4 and 9.1% increase. If our house went up to sale and everyone went up to sale, their houses would sell 30 to 40,000 more than ours because they are on Lancaster, they're on Richardson. There's another house on Lancaster that's a Midland home just like ours. They were able to get an 8.2% increase under $300,000. So that is the first thing. When you look at the neighborhood, ours seem to be the highest, and we don't know why. We could never get a real answer from either Nick or Amy.
Okay, just to make sure you're on track, we're looking for sales information that supports your opinion of value, not just neighborhood comparison.
Right, and that's what I'm going to next. Sheet 2, or Exhibit 8, is Sheet 2. As you can see, these were the sales comparison that we were given to us by Nick. These are the sales of properties in 2019, and it shows clearly that they averaged, let's get it right here. Okay, those properties, average sale price was $362,000, which is $104,600 more than our 219 assessment. They also, the livable square feet was 2679, which is 903 square feet over our house. We felt the proper way, and I think the way they've always done the assessment, is they took the sale price and they looked at the assessment of these properties in 219 and looked at how much was the increase of the sale price over the assessment. And that's what I did on 6 of these properties. If you look on Exhibit 8, it shows you that the increase average was $34,884 or a 14.4% increase. When I talked to Amy, she gave us other comparables she sent that were not quite as high, and they came out doing the same type of situation where I looked at the sale price increase over their assessment. And with that, it came out that the average increase on those properties was $24,941, or an increase of 10.8%. Now, why are we looking for just a 14% increase? As I noted, now I gotta find it, on one of my, somebody was told by, I think it's somebody in the assessor's office, that the average increase in Fitchburg was 14%. One of our neighbors also talked to somebody, and they were told the same thing, that the average increase was, excuse me, 14%. We felt, therefore, that looking at the sale prices and at the 14.4% and 10.8%, that to be fair and reasonable, we realize we're going to have to, there's going to be an increase. We can't, you know, and we're going to have to accept that the increase might be higher than we have in the past. And so, therefore, we looked at and we felt that a 14% then at the average increase was appropriate. In our case, we felt that our price of our home would be around the $290,000 range, and therefore a 14% increase at $36,000 to $293,000 would be fair and reasonable to our property. We also, you know, I don't know what else to tell you. Do you have anything to say?
Okay. Pretty close on time, thank you. Just so I understand, you're saying that you would like the assessment to be at the 293 because it was last year's times 14%, which was the average in the city of Fitchburg.
Right.
Okay. We'll then go to the assessor for their presentation.
Thank you. Amy will be distributing the written information summarizing the basis for completing the 2020 assessment of the subject property.
Just to make sure it's in the record so that everybody knows, the assessor and staff have been previously sworn in. So, excuse me for interrupting, please continue.
Oh, no problem. I will briefly summarize the written documents with oral testimony. On the first page, section 1 is a summary of my qualifications to complete the assessment. I'm Nick Hare, and I'm employed with the City of Fitchburg Assessing Office as a residential appraiser. I have an Assessor 2 certification, which expires 2/28 of 2021. I've worked in real estate for over 14 years and in the assessment industry for over 4 years. I have worked for the City of Fitchburg Assessing Office since March of 2019, and I previously worked at the Department of Revenue's Equalization Department for 3 years. I have a bachelor's in finance and real estate from the University of Northern Iowa and a master's of business administration from Drake University. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as the market value, of a property as of January 1st, 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines that property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value of which could ordinarily be obtained, therefore, at a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining market value. Part C is the information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment roll, the estimated level of assessment is at 100%. On the next page, you will find a location map illustrating the subject's property's location. On the next few pages are the property record card that contains specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. On the first page, it shows that this is located in the Sterling Meadows neighborhood, and it's a residential house, and we have the traffic listed as heavy. On the next page, you will see that the building permit history, and there are no recent building permits for the property. The last valid sale for the property was 12/26 of 2003 for $210,000. There was an open book appointment completed where we discussed on the phone, and we also, along with the open book, I did do a complete walkthrough of the property. The land, we show there is one lot for the property at 0.281 acres. On the next page shows the information regarding the property. It is a ranch story home that's one story. It contains a total of 1,776 square feet on the first floor. There is no finished basement. It is 3 bedrooms, 3 baths. There is one gas fireplace. As he noted earlier, there is one additional plumbing fixture that we didn't have last year. There was a laundry tub in the basement. And the attachments, there is a deck, garage, and an enclosed porch. And the grade of the property is rated at a C+. And during the open book, it was previously graded a B-, and the change that we made during the open book that brought the value down to the $308,000 was we reduced the grade from a B- to a C+. So the next pages of the document are the market valuation detail. We do have lot value for the neighborhood in Sterling Meadows is $91,800, and we do have a negative 5% adjustment on that land because it faces more medium traffic on Richardson. The replacement cost new of the improvements is $288,165. There is 28.79% of depreciation given the age of the property. The neighborhood Sterling Meadows has a modifier of 8% based on the sales in the neighborhood, giving a total market value for the improvements of $221,600. So the next page is a document map that shows the location of the subject and recently reasonable comparable arm's length sales. And the following page is a sales comparison report that validates the mass appraisal assessment, and the report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. The first comparison at 2926 Richardson Street, which is just about 3 blocks north of the subject property. It sold in March of 2019 for $370,000, and after the adjustments made for the differences between the property, it gives a comparable value of $351,800. The second comparable at 2787 Raritan Road, which is about 4 blocks west of the subject property, sold in November of 2019 for $370,000, and after adjustments, that gives a comparable value of $308,400. The third comparable at 5805 Pembroke Drive, which is about block west and 2 blocks south of the subject property. It sold in January of 2019 for $305,000, and after adjustments, it gives a comparable value of $323,700. So the report, then the adjusted sales prices of reasonably comparable properties indicate that the assessed value of $308,800 is a fair estimate of the market value of the subject property as of January 1st, 2020. In summary, there is not a recent arm's length sale of the subject property, and consistent with the Wisconsin Property Assessors Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual and 2019 arm's length sales. I do also want to note that in our conversation over the phone, I did recommend one site that we like to sometimes use to double check our value is firstweber.com. It's a third-party valuation service that provides values from 3 different locations that kind of gives an estimated market value of your property address. If you'd like, I can have Amy hand these to you, but the 3 values that this third-party site gave for the subject property was $375,000, $309,451, and $376,000. So based on the mass appraisal assessment that we completed, it is supported and validated utilizing recent arm's length sales of reasonably comparable properties adjusted for differences between them and the subject property. Thank you, and that concludes my presentation.
You did not rely on those in setting the value.
No, those were not relied on for setting the value. That is just a kind of third-party site that we like to just double-check to make sure that our assessment is fair and equitable compared to a third party's valuation.
As long as it was not used in establishing the assessment, we are not interested in seeing it.
Okay.
No, they weren't used. It's just when property owners will dispute, sometimes they'll say, well, you know, you can go out to First Weber's website and see what they come up with. So we actually use it not for us, but as to suggest a property owner can use that as a tool to get an idea if our assessment is what another outside source says.
It's a good suggestion to the public, so I just wanted to make sure we understood what was going on with the value, establishing the value. Questions from the board?
Do I have a chance to respond? He mentioned the Weber thing. I have a Redfin here that I just ran off this week. They're saying if you're thinking it's our property, if you're thinking of selling, they say the estimated value is $252,000 to $279,000. We're asking for a $293,000.
Just like theirs, that's, I'll call it speculation.
Yep.
It doesn't have
just like
detail.
theirs.
So you can go to Zillow, you can go to True Value, you can go to 16 different sites and you come up with all kinds of different information.
Also, I'd like to point out that on he mentioned this Richardson one, is it 2865? Their square footage is 2296, which is about 400 square foot more than ours. So obviously their price would be, you know, they're going to be selling, their sale price is going to be higher than ours in that regards. They're assessed at, I'd have to look up, we have that information in here someplace.
I do have a question.
Go ahead.
For the appraiser, or excuse me, the assessor. I just saw that in looking at the 3 comparison properties used in the 2020 sales comparison presented, the comp ratings were a little bit lower than I'm used to seeing. I just wondered if you could talk about what you found when trying to look for comps. I know in an earlier hearing you described using the computer model and looking at sort of the top 3, but these scores do look a little bit lower than what we see. What can you tell me about the quality of the comparisons you were able to find for the subject property?
So one of the things that affects the quality rating is the neighborhood that they're in. And these are in different neighborhoods. They're surrounding neighborhoods, but the reason we use these comps and the not comps in the neighborhood is because the only sales comparables in Sterling Meadows were two-story homes. And we find comparing two-story to one-story, they sell differently. So we wanted to use comps as close as possible, but we wanted to use ranch-style homes given the similarity to the house itself and how the house itself sells versus, like a ranch style in a neighboring neighborhood will sell more closely to another ranch house than a two-story house in the same neighborhood.
And that answers my question. Thank you.
Can I ask a question of the assessor? I'm looking at the 2020 market value detail, and I go down to the, under item described, replacement cost, new enclosed porch frame blower, 36 square feet at $84 a square foot. And you come up with $3,028. I don't have a calculator, but that doesn't seem right in my head, because if it was...
That's an outside porch too. It's just a little entryway. It's nothing, it's not
It's
part of the...
jury-rigged is what it is, with
It's
plastic window.
definitely not part of the livable square feet. It's just a little bit an outside one that helps us in the wintertime not to get...
And I do have a calculator in the math.
Okay, so I may have done it wrong.
That's okay. Yeah, it's 4 cents shy of the number on the page.
Okay. My mistake.
But
That's
it's really
It
not.
just seems, for the area, it seems a little high.
And by the way, just, I mean, this has been explained a couple times today, but the market valuation detail that you're looking at there is a mathematical formula to arrive at the value. And then they use the comparison approach to kind of double check or verify that where they arrived with that page's valuation squares with what's in the market. So even though that is the number, the formula that gets you the number on your assessment, it's backed up by the presentation today of the comparable sales. And again, I think as the assessor noted, you know, they looked carefully at what kind of homes they were using and what kind of sales they were comparing to arrive at the value.
So I have a question. During open book, for the assessor, during open book, you reduced the valuation from, was it 331 to 308? Yeah, 331.4 to 308.8. Can you say what the basis was of that revaluation?
Yeah, that was, I had mentioned in the presentation, the grade of the property is a construction quality, and we had previously had it listed at a grade B-.
Okay.
And after reviewing the information we have and looking at the building plans, we realized that we may have had it graded a half a grade too high, and we adjusted it to a C+ instead of a B- grade.
So that swing of 331 to 308 was just because of the grade?
Yep.
There were no other features that were different?
Oh, and there, I guess, as he mentioned, we did add a plumbing fixture because we hadn't captured the laundry tub in the basement, so.
The laundry tub in the laundry tub in the basement was built in when the house was built. It's always been assessed every year. So how you can add $2,000 for a laundry tub that's always been there is...
It wasn't there, so he's just making sure the record's complete.
But it was part of the house when it was built, like anything else.
Whoever listed it originally missed it.
Yeah.
You know, happens. Any other questions? Okay, I'd like to thank all the parties for their presentation today. At this point, we'll go into deliberation. The question I have is the difference between 293 and 308, a reasonable variation to be considered. The rules of evidence don't really give us guidelines as to what dollar amount we should consider any longer. The assessor has a strong basis on the market. The property owner has and would like to have the market adjustment average from all properties in the city. And we've seen just in the few hearings we've held today that areas of the city changed at different rates. So I think to try and apply an overall average of 14% to one particular property is sort of not a good idea, and I'm sure the assessor would agree, that the city in different neighborhoods changes at different rates. Their job is to reflect those changes, and I think they've done a pretty good job in doing that today. And I think the fact that they did listen to the property owner, they did review it personally and physically, they adjusted based on the grading factor, which is subjective. I give them credit for taking the time to do that. I think in review, they put the home in the general range of value that all properties that are being reviewed by the assessor would fall in if this was a standard review process. So that's my 2 cents worth. And I'll open it up for others to present their feelings.
Yeah, I agree. I'd like to commend the property owners for bringing to us a lot of sales information, which sometimes we don't see. We did have the sales information, and in looking through the sales, and then in looking at the assessor's report, I did have that question about, you know, I see that some of the sales you presented us with are closer geographically, and the assessor has come to us with some houses that are a little further removed, but I'm satisfied with the explanation regarding the need to compare single-story or ranch design to ranch design homes, and valuing that over just precise close proximity to the subject property. But I do appreciate the time that you obviously took to bring this information to us. And what the assessor has when they're looking at comparables is a computer system and a lot of tools that allows them, you know, like your comment said, this house sold for more, but it obviously had more square footage. And what the assessor is able to do is use their mathematical tools to adjust the valuations in that way, and give a presentation that squares some of those differences and how they get to the value. So I think I'm satisfied that they've done that, but I did want to tell you that we appreciated the information that you submitted.
How come you got a 5% increase on your assessment and we get 20%? We know you got a 5%.
Everybody yeah, but they're all over the board here too. So
They got a,
And Mr. Tate down there got a 2% increase.
Mr. Herr, if he got a 5%.
Is it who you know?
I
Is
got a
that what it is?
24% increase.
Well, I don't know, but our house is a small house. It's the smallest on the neighborhood.
It's not.
And everyone else was assessed lower than ours.
Well, I'm sorry, we're not going to allow to apply an average when you're looking at specifics.
And then he uses these high-priced houses that are 100,000 more than sold than ours. 100,000 more, 900 square feet more. And you use those as comparables? Come on. You gotta be smarter than that to read what a comparable is by size and.
All right, the testimony's done. We're at the point of deliberations. I'd ascertain a motion.
I'll make a motion to sustain the assessor's valuation for the reasons stated during deliberations.
I have a motion. Do I have a second?
Second.
I have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Let the record note the motion carried unanimously. We thank you for your review today and the diligence you provided with the information. And I'll also let you know that if you're not satisfied with our determination, on the back of the form that Kirk is going to give you, there's additional appeal options that you can consider. Thank you for coming in today. 406,000, 406? $1,400.
And this is item number 14I on the agenda. This is Mike and Sheila Lean.
Correct.
At 5647 Sherrill Drive, parcel number 0609-094-2494-8.
Good afternoon.
Hello, thank you. Good afternoon.
First thing we're going to do is ask the city clerk to swear you in.
Okay.
The Board of Review accepts sworn oral testimony, so we're going to ask that be done. I'd let the record note that the city assessor and her staff have been previously sworn.
Okay. You can raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, I'm looking at your objection form.
Yes.
It indicates that the assessment currently on your home is $400,600, and you want it reduced to $399,200.
That's correct.
$1,400. That's a pretty small amount to ask for an adjustment.
Yeah.
You have evidence to support an adjustment of $1,400?
Yes. Was the full submission provided to everybody here?
Correct. They have the packet electronically. Do you have anything additional that you would like to submit?
The only thing I have is my first page now shows our shed as well. I don't know whether you guys need to see that or not, but I could go ahead and just say that, our objection is probably different than a lot of those that you've heard. It's really just around a fairness issue of our shed being added to our assessment this year for the first time. We've been in the home just 2 years. I don't know how old it is. It's obviously been there quite a while.
Okay, before you start then, I'm going to have to read the information so that everybody hears the same thing. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony, that's why you're here, proving that the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. Those standards are: best evidence of value is a recent arm's length sale of the subject property. Next would be sales of reasonably comparable properties. And lastly, then sales of information about other approaches to value, which would include the income approach on income-producing properties and the cost approach on special purpose or unique properties where there's not an active market. At this time, please share any exhibits. It sounds like you've already presented them. If you have an appraisal on the property, the appraiser must be here to present sworn oral testimony. Question I have for you then, has there been a recent sale of this property?
Have they been sworn in yet?
Yes.
Oh, okay.
Has there been a recent sale of this property?
Yeah, per my submission, we purchased it on June 21st of 2018.
Okay, that's not a recent sale, but it's a fairly recent sale.
Okay?
Did you attend the open book and review the property record card with the assessor staff?
Yes, I did.
Okay. Please continue then with your information.
Okay. There were during the open book discussion, it was highlighted to me that there were two significant changes to the assessment. One was adding a deck, which was reasonable, and the other was adding a shed. That is the item in question now, is adding the shed. I decided to look around at other properties within a 2-block radius. I took photographs, and those were submitted, of 11 other sheds, some larger, some smaller, within a 2-block radius. I then took those property addresses and compared them with the assessor data website to confirm which sites or which of those properties had the shed noted on them. Out of those 11 additional sheds observed, not a single one is on their assessment, the 2020 assessment on assessor data, where ours is. So ours is listed as a separate structure. The net value is $1,400 after the assessor gauged it at 10 years old, whichever method was used. So the net of that after depreciation was $1,400. So the evidence as submitted was those 11 shed photographs along with the 11 assessor data web pages right next to each photograph, each one highlighted showing 0 additional structures.
So let me understand. The shed is on your property,
Yep,
and it's your shed to use?
absolutely.
How big is it?
10 by 12?
10 by 12, so it's a garden storage
Yeah,
type shed?
garden shed, yep.
Okay.
Yeah,
It's accessible. If it wasn't on your assessment, it's the assessor's responsibility to add it. So you want to argue the $1,400 value of that shed? Is that what you're saying?
what I'm saying is the fairness aspect of it, of one of the notes made during the open book from the assessor was that sheds have not been assessed consistently previously, and that will be one of the hopeful priorities for the assessor department for next year.
Okay, well, that's something that the Board of Review does not have jurisdiction on.
Who does?
You have to present sworn oral testimony proving that the total value of your property is $399,200, not that your shed is assessed and your neighbor's isn't. There's nothing we can do about that.
What about what I'm actually asking is the fairness, equitable nature.
I'm not saying
that.
right, I'm just saying we can't do anything about it. I have a shed on my property and it's assessed.
What we're asking is why are we singled out over the other 11 right around us?
Because apparently that's been an omission by the review staff that has completed the documentation of the record cards, and they've missed them in certain neighborhoods, or didn't add them because of the size. I don't know. I don't know what past assessors did and why, but I'm telling you that's not really something the Board of Review can consider today, because we don't have any justification for looking at, you have a shed and it's assessed, and your neighbor has one and it's not.
Yeah, I don't understand,
Yeah.
I guess.
It makes absolutely no sense.
I'm not saying it makes sense. I'm telling you we have certain statutory responsibilities at the Board of Review, and that's not one of them. Is to, if I had a responsibility, it would be to tell the assessor, get the information from you and go out and value those other 11 sheds and get those people in here. Because if they're there, they're taxable and they should be assessed.
Typically, what brings it to the assessor's attention is they should be pulling permits for those sheds, and that's how we know that a new shed has been added since someone last went to the property. And if property owners are adding sheds without building permits, that happens often. And so we capture those sheds just like this when we go out to view a property or something like that. We have added those into our workload for next year to verify that they are there, to verify that those sheds will be valued. And at that time, we'll look at that issue because it's a recent discovery. It's not something we knew about. When we go to a property, we will list whatever is there on that property at that time. And that's why you do periodic reviews or periodic neighborhoods to verify that when someone adds something without building permits or something like that, that we can capture those items.
So you understand what we're telling you? That the board has no jurisdiction on the issue that you've brought to the board today?
So who who do we need to take this to resolve the issue?
Person sitting right there, city assessor.
Well, I would just add that it looks to me like you're telling us there were 11 other mistakes made, but that there wasn't a mistake made with respect to your property. And so taking the shed off of your assessment would just make it 12 mistakes. It's up to the assessor to try, as they can go through properties, to update those assessments and correct those mistakes. But the hearing today is, has there been a mistake made with respect to your property assessment? And everything I've heard is no, the mistakes were made on the surrounding property. And what the chairman is telling you is, when you come before us, we look at your assessment, and the question we're asked is, were mistakes made at assessing your property? And I think even you are telling us, no, our issue is there were 11 other mistakes made, and clearly that's been brought to the assessor's attention. And the issue is that there's thousands of properties in this city, and they're doing their best to catch up and bring current the assessments, and it doesn't always happen, they don't always happen at the same time. So we understand the point that you're making, but we don't address the 11 mistakes by making a 12th mistake. We leave, and you're not telling us that there's a mistake on your assessment, and that's what he says. We don't have any, our responsibility is to you and your assessment. If you're saying this is right, but the others are wrong, we don't have anything to do today. And we know that the assessor knows about the issue now, and I'm sure it'll get looked at as they make their rounds, but we don't have anything to do about it today because you're the only homeowners before us, and we're not told that there's anything wrong with us. And I get it doesn't,
Wrong,
yeah, I
yes.
understand that, but, and he'll talk about evidence and procedure, and he's right. Fairness isn't really evidence. We're looking for evidence. Is this right or wrong? It sounds like it's right. We understand the fairness aspect, and we have to let the assessor do their job to try to address that, as they go through properties. So that's just the comment I would make.
And can I just add something, just for an explanation? If we had known at open book, and I believe Nick said we didn't find out that these sheds were at these locations until you submitted your packet. If we had known during the open book period, we could have added those sheds during open book to those properties and then noticed those property owners. So we often do find that in a neighborhood. If there's something consistent in a neighborhood that we have to address, we will address it during the open book period because that's when we can still make changes to those properties.
I mean, I guess I thought I understood from talking with Nick was that that you could only help me with my assessment, and that even though mentioning other sheds, because I said 3 of them, the first 3 in the pictures are, literally 30 feet from our shed,
And that's, yeah, I know that you had mentioned in our conversation that some neighbors had them, but without the addresses, and usually, like without the addresses, we didn't know at that time which specific properties had them.
Yeah. No, but, obviously you didn't ask for those at the time, so, okay.
The other thing is, when we moved in there, I had an assessor knock on the door the day that I closed on that property and came through that house and assessed it. So that was in 2018 when we bought it. The people that lived directly behind us bought their house this last spring and have never had an assessor go through there. I was told an assessor goes through a house every time one is sold in Fitchburg.
Yep, if there's a sale, we send a letter first and request those these are our newest procedures, is we mail a letter to each property owner for every sale, unless it's like Amy Mercer to Amy Mercer Trust. Then we don't have to because it's the same person. But every sale that we need to validate, we do mail a letter out to them. And then we wait for those property owners to respond. Typically, it's about 43% that call back to schedule an appointment. And then if we don't hear back, then we go out and tag those properties. We do a cold call to it and knock and ask them. And it states that in the letter that we send, that we will come out in a couple weeks to do a walkthrough. And if no one's home, we leave a tag, and we try to get in. So we try to get in, we get into about 70% of all the properties that we request to view. And then the other 30% we have to estimate. And a property owner has that right to always deny access. And some property owners might say we can do a walk around the outside, but they don't want us coming in. It all depends on each property owner. They have that is their personal decision. You know, we can't force that, you know, and that wouldn't be right to force that issue. So, but we do send letters to everyone.
Okay, well, based on what we've discussed and the conversations we've had, we do have appeal we have to bring to resolution. I'd like to have a motion as to what we should do with this appeal.
I would make a motion that the appeal or objection be denied as the objector did not provide evidence that we can consider to challenge the property as assessed. As noted during the discussion here, it really had to do with differences in other assessments, which isn't proper evidence. And from the objector's testimony, it doesn't sound like there's really any dispute or statement of fact or any evidence presented that something is wrong with the subject property's assessment. And so for that reason, I think the assessor's valuation should be sustained as the homeowner has not carried their burden to change that presumption.
And I'll second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Opposed? Please let the record note the motion carried unanimously. Is it in looking at your information, there's an actual sale listed of $425,000? Your assessment is less than your sale. If we continued, we'd be raising your assessment to $425,000. Okay? I'm not trying to push you out of this. I'm just telling you the rules we would be following. What did I say when I started? Sale of subject property. There's your sale of subject property, and your assessment's less than your current sale price.
Yeah, okay. Thank you.
That's where we'd had to go if we continued.
Okay. Thank you for your time, everybody.
Thank you.
Okay, and this is item number 14J on your agenda. This is Miyoko Suzuki at 5554 Longford Terrace, parcel number 0609-044-1509-2. Okay, if you could raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Yeah.
Good afternoon. I have some opening remarks to present. Thank you for coming today. We are looking at the appeal of a property at 5554 Longford Terrace, is that correct?
Yes.
Okay. Wisconsin Statutes, Chapter 70, gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony that proves the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us as we consider your appeal. The standards are, first, best evidence of value is a recent arm's length sale of the property. Next would be sales of reasonably comparable property. And last, then all other approaches to value, which would include the income approach to value for income-producing properties and the cost approach on special purpose or unique properties where there is not an active market. At this time, do you have any other exhibits that you wish to share and read into the record?
Do I have to explain the reason now, or?
Do you have any exhibits that you want us to all have copies of so we can see?
Yeah, I already shared. So simply to say this, I summarized everything. Yeah.
Okay, so you submitted the exhibits before?
Yep, they should be in your packet
They're in
electronically.
your packet, but we have to consider oral testimony. So if you want to submit this as an exhibit, you need to read it into the evidence.
So this you need to. Okay. So simply to say this,
Not quite done yet.
Okay.
If you have an appraisal of the property under review, the appraiser must be present to present sworn oral testimony for the Board of Review to consider. Has there been a recent sale of the subject property?
No.
Okay. Did you attend the open book and review the property record card with the assessor and the assessor staff?
Sorry, what do you mean? Could you explain one more time?
The open book where you come in before the hearing?
Oh, yeah. Yes, I did that
Okay.
discussions.
And it's a matter to keep things on time. We ask everybody to try and keep their presentation within 7 minutes. I'll warn you about 2 minutes before, so please start your presentation.
Okay, so thank you very much. The first, thank you very much for the board member to have a opportunity to have an appeal. And then our properties, so originally this last year, 2019, valued as 219 and then 100 dollars. And then this year, this increase assessment in 2020 is the 310, and then also the $100 is the point. And then so far, I had a conversation with the assessors, and then also having this phone all out, and then also the written. But the point is our feeling, or we conclude the assessment is a bit higher than what we expected. So as I listed in the additional files, the reasons are couples. And then first one is I did search several things. Generally, the increase, the assessment is the 7%. And then honestly, I'm not sure the 77% is the commons in these cities, but compared to the other surrounding cities, the ratio is slightly high. So unfortunately, I didn't have any specific information from the assessors and then also the cities why this numbers has been settled. And then the second one is if we focus on only the improvement,
So the increase in the rate is the 16.3%. It's quite high. And then on the other hand, we understand this is probably coming from the adjustment of the market values. But even though we didn't have any improvement for the house itself, and then anything that we haven't touched, but the increase rate is quite high. And the third one is of course, I understand this including the cities, and then also our residential subdivisions, the Highland of Seminoles. So the many houses are on market quite often, but of course those activities would influence significantly to the property assessment. But our houses, that type of factors may not be simply applied to our house. So one is we haven't done any sales, and then also put on the market, and then also we don't have any plans. And then our house is just the edge of the side, the last house in the subdivisions, most east end. And then from the next, neighbors, the east neighbors, that already has the different the street names. And then our house facing is several apartment or the townhouse and so on. And then additional note is our house has been, so before we purchased as a new house in 2003, the house was hold almost 2 years or 1.5 years on market without not sales. And then of course, the number 4 is the general factors. Of course, the school rate or other environment has not been changed. So that's the point. And then number 5 is this is a kind of the personal impressions or general impressions, but again, I had a conversation with the assessors and then also the cities, but several of the explanation or justification clarifications are not specific or vague. I was also explained that the 70% is within the range between the 5 to 8 or something, but I don't have any justifications to why the 7% has been applied or something. So simply to say this, we need a better justification or clarifications at this moment. And then lastly, this is also what the assessor did when I had the phone call. So quickly check this like a market value using the website or something. But I don't want to say this, all the website is the higher or like as like I said, but not always in all the website show this reasonable price or fair price compared to the assessor's values. So I listed the one website is found, and then the Redfin website, for instance, they have the quite lower the amount or assessment here still remain, and then the estimated sales price is within the range is the different or the lower than actually the 2019's assessment amount. So in conclusions, the recent assessment is not simply acceptable without the appropriate justifications, and then so seems to be a bit overestimated. So, and then based on the reason above, I propose stay or no change the assessment since the 2019. That was my experience. Thank you very much.
Thank you, Mr. Suzuki. Do you have any specific sales that you want us to consider?
No, I don't have any.
Okay. Then we'll turn to the assessor for the presentation of how they developed and support their assessment.
Okay, thank you. Nick will be distributing written information summarizing the basis for completing the 2020 assessment of the subject property. I will briefly summarize the written documents with oral testimony. On the first page, section 1, is a summary of my qualifications to complete the assessment. I'm Amy Mercer. I'm employed with the City of Fitchburg Assessing Office as the city assessor. I have an Assessor 2 certification. I've worked in the industry for over 20 years. I've worked with the Department of Revenue. I've worked with the City of Janesville and the City of Fitchburg. I also worked with the City of Madison. I have a degree in landscape architecture from the UW-Madison. And I have attended various classes over the years for my continuing education credits and continue my, my journey through this field. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of a property as of January 1, 2020. Part A outlines the standards for establishing value. State Statute 70.32 outlines that property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore at private sale, when such sales conform to the definition of a recent arm's length sale. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment role, the estimated level of assessment is 100%. On the next page, you'll find a location map illustrating the subject property's location. And I just want to point out his neighborhood is at the end of one neighborhood, and it's right next to like the Whispering Pines and Leopold, next to some commercial areas. The next few pages are the property record card that contains a specific data on quantitative and qualitative physical characteristics of the land and improvements for the subject site. To note some of the more significant data. The first page shows you that it's in the neighborhood of Highlands of Seminole. School district is Madison, shows the assessments. The second page, it would list any building permits if we've had any, and we don't have anything listed. The last valid sale was February of 2004 for $269,000. On 8/13 of 2020, I had a phone meeting during the open book appointments. I explained how the value was arrived at. We reviewed the data. The property owner didn't provide any supporting documentation, so there was no open book change. And the adjustment to real estate assessment denial letter was sent out on 8/17 of 2020. And then the land is below that. It is a residential lot. It's valued on the lot basis. That area, we gave a -10% for heavy traffic due to the commercial on that Longford Terrace there. The next page describes the physical data about the house, the property. It is a colonial style 2-story home, aluminum vinyl sided with air conditioning. It has 4 bedrooms, a family room, 2 other rooms, 2.5 bathrooms. The ratings we have is all average. Those are the equipment, kitchen, bath, interior, and exterior. It has 1 gas fireplace, 2 additional plumbing fixtures. The first floor is 1,034 square feet, and the second floor is 1,048 square feet. So it has a little bit of an overhang, and it has a full basement. The basement is the same size as the first floor. It has a large attached garage, 3-car deck, and an open porch. The back side of that page, or the page 4, has a sketch of the property. So the next page in your packet is the market valuation detail. As you can see, that it's valued on the lot basis, and then it has that minus 10% for the heavy traffic, which pulls in the value at $72,000 for the land. All of the attributes I talked about on the building pull in times the base values. So the replacement cost new is $324,094. The physical depreciation, it was built in 2002. And the depreciation is $75,674. It has a negative market adjustment for that location. And then, so the adjusted property value for that is $238,500. On the back side, then the land is $72,238,500 for improvements for a total of $310,500. So the following page is a map that shows the subject property and 3 reasonably comparable properties. You can see that there is comp 2 is not very far from the subject property, and they're all within that neighborhood. So the following page is a sales comparison report. So comp 1 is 5633 Kinsdale Street. The sale price was $365,000. When adjusted to the subject, it comes in at $338,300. Comp 2 is 5586 Longford Terrace. That was sold in April of 19 for $363,150. When adjusted, it comes in at $339,050. Third comp is 5623 Longford Terrace. April of 2019 is the sale price. It sold for $370,000. And when adjusted, it comes in at $326,300. You can see the comparability rating on all of them is 99%, so these appear to be very good comps for this property. You can see all of the lot values for Longford Terrace. There's no adjustments for those, so they're all getting that traffic discount, whereas the Kinsdale would not have that. The square footages are all similar in size for first floor, above square footage and below. The age of the subject is 2002. The comparables range from 2001 to 2005, so all within the same range of age. And other attributes that are the same are similar garage sizes, porches, decks, etc. The estimated fair market value of the subject is $310,500. The comparable market value based on these 3 comps would support a value of $334,600, which supports the current assessed value of $310,500. In summary, then, there is not a recent arm's length sale of the subject property. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual and a 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for differences between them and the subject property. Thank you. That concludes my presentation.
Thank you, Amy. I'm curious as to what increase other properties in this neighborhood received, what percentage increase?
This year, because it was a full revaluation, there weren't a standard percent increase within a neighborhood because of all the, making sure things were equitable and removing all those various overrides. So this year, we're not able to say, oh, everything went up 7%. The typical for the city, the average increase based on market for residential, and that's citywide, was about 6.5% increase. The overall change in assessment, but that also includes new construction, was approximately 14% at the start of open book. So, and that's a factor between all of the classes, so.
Based on the sales you presented and the map you provided, it appears as if these homes, at least several of them, border apartment buildings.
Yes, his property is adjacent to the Whispering Pines. The back of his property is next to the Whispering Pines condos.
Okay.
Which the majority are used as apartments. They're rented and not owned. But Comp 2 is also adjacent to that condominium complex. So, Comp 2 is right there also with the apartments. The apartments would be just around the corner heading north then from his property. The other Comp 3 and Comp 1, Comp 3 would be more around residential, and Comp 1 would also be just around residential. Well, you're near apartments also on Chapel Valley and Triverton Park. So actually all of these are close to those apartment buildings also. Comp 3 is, so they all have that influence of those apartment buildings on them.
Okay. So
Can I have the comment, or should I wait? Can I have the comment? Just a couple things.
Certainly, please, go ahead.
Okay, so first one is our house doesn't finish the basement, so there's nothing. We haven't done anything, the finishings for the basement first. And I know the comparison to 5586. This one is frequently the sold, as far as I know. But of course, I don't have any official record at this moment. But as a personal, the recognition is that this house is several times sold on the market. So I think that is also the one factor. This price is relatively high.
Yeah, Comp, I think what you're asking or stating is comparable 2 and comparable 3. If you look at the comparable sheet, those two properties have finished basement living area. Comp 2 has 490 square feet, and Comp 3 has 697 square feet. But there is a negative adjustment for each of those, adjusting that price downward for adjusting the comp to the subject property, taking that portion of the value away from the sale price to adjust for that.
Very good.
I have a quick question on the property record card. And the net market modifier is a downward adjustment of 4% or $9,937. And I'm just curious how that figure gets calculated and what factors into that. My understanding is that is a market modifier based on the location as the property owner described. It's on the edge of a neighborhood that borders another neighborhood that has multifamily, some commercial, things like that. And so is that the modifier that it is, or how is that reflected?
No, on this, because when we look at the sales within each neighborhood, like I said, we'll stratify, and if we see things are different within a neighborhood, we can apply, based on whatever that difference is, we can apply different modifiers. In this case, that was placed on the style of the home. So we found that the colonial, the 2 stories, were actually selling lower than other styles. So if you look on there, next to the style under the market adjustments, That's where that 96% is coming from. Oh, are you looking at the
Yes, I am.
market valuation detail? That's what I thought. And so we have various different market adjustments that we can apply, and in that case, we found that the sales were different, and we needed to apply a different modifier based on that style of that property.
So how, if at all, is the subject's location addressed in either the sales comparison or the features of the property?
That would be like, we're looking at the whole neighborhood, and because like Mike had asked, if you look at the comps that are within here, many of these properties have, are located near the apartments and that. So we would have looked at, when we stratify, we look at all of those things. I don't have everything in front of me, so like the ones around Rose Common, I know those actually had a positive influence factor on those because of the parkland next to them. So various properties, depending on where they were located, even within a neighborhood, we can apply different influence factors of positive or negative. So on his, we applied that minus 10% to the land value for the heavy traffic there, and that's the portion that was adjusted on this property for that way.
Okay, thank you. Any other questions by the members of the board? Conclusions? What's your feelings, Matt?
Actually, I do have a question. Why was the heavy traffic considered as part of the land valuation but not as part of either the overall assessment or also applied to the structure improvement?
Again, we look at and analyze those sales within each neighborhood. And so when we're looking at those modifiers in the sales to see if we need to apply any type of modifiers, that's when we look for those patterns. And we look at a lot, so I can't say, but our typical process is to look at that and try and stratify or look for any type of patterns that we can see. Do we find that those on the land, and then we'll apply that minus 10. And that's typical for heavy traffic, is to apply minus 10. Medium traffic, we typically apply minus 5%. Next to parks, it's usually either a plus 5 or a plus 10. So we try to do things as consistently as we can, but also we need to let the sales talk to us and tell us what it really needs. In some instances where we might think, oh, this is next to parkland, when we combine that total improvement value and the land value, it comes right in, so then there's no need to apply it. So it all depends on what the situation is. I don't have a map, or I can't, I don't have all the data. I don't know if all of these other properties are 2 stories. And if that's part of that influence factor, that I'd have to go back in and reanalyze everything to know. But we let the sales talk to us, I guess, is what we do to try and get those as close as we can in a mass appraisal aspect.
Thank you.
Well, I guess based on what I've heard, the city-wide has had varying amounts of positive increases, ranging from small numbers to substantial numbers. This property and specifically got a 7% increase, which is close to the median average that city residential properties received. The property owner did not provide very specific information on recent sales. The assessor has. And their sales that are just down the street and down around the blocks of the property. Those properties also exhibit similar characteristics of neighborhood that the subject property is subject to. And the market's showing that even though there are multi-tenant family buildings around them, that the properties are still selling, supporting the assessed value. And so hearing that, I would make a motion that we sustain the assessment at the assessed value for 2020 of $310,500 as presented by the assessor.
Second.
We have a second. All those in favor signify by saying aye.
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 Opposed? Please let the record note that we are unanimous agreement to sustain the 2020 assessed value of this parcel at $310,500. Thank you, Mr. Suzuki, for coming in. Just so you're aware, if you're not happy with our determination, the clerk is going to give you a statement with that determination. On the back of that is additional appeal avenues if you so wish to follow.
Thank you very much.
Thank you. Back on the record. Our next appeal would be,
Okay, for the record, we are on agenda item number 14K Jacobs. She had requested to have her objection postponed, and she has not turned in her objection form as of 11 o'clock this morning. So we do not have an objection form for her. We just have a letter from her asking her to postpone to a later date. And she is not here.
so we have no form, we have no basis of appeal. And she did not meet the deadline to file the form this morning. So at this point, I think it's a no appeal, but we need to have it since it's on our docket. A motion dismissing any action for the property because of the non-filing of the objection form.
I have in my packet a letter. Are we going to consider the letter?
No. If she had submitted the objection form, we consider the letter as for just cause. Without the objection form, we have no basis of an appeal.
Did she give notice of intent to file an objection?
She did give notice of intent, and she was told that she need to have that objection form turned in no later than 11 a.m. this morning.
Okay, so we have a proper 48-hour notice of intent. We just don't have an appearance or an objection form this morning.
Correct.
So what could give us the power to consider I'm just curious if we have any basis to adjourn this to a later date. That's the question I have.
I believe, doesn't she have to turn in her form within the first 2 hours because you need a value? And there's no reported her opinion of value on that, on a form.
Yeah, I'm reading the statute here about how we can waive that. It says, upon showing of good cause and the submission of a written objection, the board shall waive that requirement.
Unfortunately, we do not have an objection form.
Okay, I just want to make sure I understood that. Okay, so in the absence of the objection form, I do think I think you're right, we don't have a choice according to the statute because we don't have the proper items before us that would allow us to proceed with any action on this other than dismissal.
Correct.
Okay.
So I'd ascertain a motion to dismiss this case for non-completing the statutory requirements of filing the objection form for the board.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Please let the record note it's a unanimous decision, and let her know that we are very sorry that she had to deal with a tragic issue with her family, but we do have statutory requirements we have to meet as well, and hopefully she can deal with the assessor and maybe get some better idea as to how the assessor's established the value on her property that's in question. So we have a little break since that appeal was our 3:30. So let's go back to Bowman Farms.
Okay, we are taking back up agenda item 12J, which is the Bowman Farms objection forms. I did go through their intent list, and I compared it to the electronic versions that were submitted on the 17th and the original copies that were sent via FedEx this morning prior to 11 a.m. On the list here, the forms that I have received are parcel number 0609-031-5112-8, and that was asked to be combined with 0609-031-5213-6. I also have an objection form for 0609-031-88-15-2. The rest of the items on this list, if you'd like, I can read them off, but I do not have objection forms for them.
So on the list, there are 2 with forms filed, plus 5213-6, which is not on our current list. Oh, I'm sorry, it is on the list. It's on the bottom here. I missed it. So 3 of those forms have been filed. The other 10 have no forms. Is that correct?
That's correct.
Question, what about letters H and I, the 2 Bowman Farms Inc. parcels above the list of?
Those you had motioned to defer.
Okay.
Did have the forms for them, yep.
Okay.
So it was the J that was postponed till now,
Understood, okay.
so I could coordinate.
It's been hours.
I know.
So we're back to consideration to defer action on the following objections. They have met the criteria of submitting their objection form timely based on their notice of intent. Questions?
I move that we defer action on objections with last numbers of 5112-8 that was combined with 5213-6 and parcel number 8815-2 until a later date to be determined based on the assessor and board schedule.
We have a motion. Do I have a second?
A second.
We have a motion and a second. All those in favor of deferring these to a later date, please signify by saying aye.
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 Opposed? Please.
May I interject one item before you? On parcel 0609-031-88152, I don't know if that should be considered now or not, or a later date, but we did value that on an income approach, and they did not provide the income information on that property. Am I correct?
Well, I guess,
So we did not receive the income and expense 7 days prior to the board of review.
that's an important factor, but you do have the right to subpoena it, don't you?
I believe that is a hard rule that they have to provide it if the assessor requested it 7 days prior to the board of review. I'll just read through this. So 70.47, paren 7AF, no person may appear before the board of review, testify to the board by telephone, or object to a valuation if that valuation was made by the assessor or the objector using the income method, unless no later than 7 days before the first meeting of the board of review, the person supplies to the assessor all of the information about income and expenses as specified in the manual under 73.03, paren 2A, that the assessor requests. The municipality or county shall provide by ordinance for the confidentiality of information about income and expense that is provided to the assessor under this paragraph, and shall provide exceptions for persons using the information on the discharge of duties imposed by law or of the duties of their office or by the court. The information that is provided under this paragraph is not subject to the right of inspection and copying unless the court determines before the first meeting of the board of review that the information is inaccurate. So I thought it was a hard rule that if they did not provide that, we can subpoena additional information, but I thought it was a hard rule that if we did not receive it 7 days prior, that they could not even appear before the board.
Yeah, I'm following along reading the statute, and I think that's right, that it says no person may appear unless not later than 7 days before the first meeting, which is today. The person supplies the assessor. And my understanding is that other income approach properties submitted their information before 9 a.m. last Friday, which would have been that 7-day deadline. And I think the statute, to me, is pretty clear that we can't have them before us testifying because they didn't meet that. It doesn't give us the ability to deliberate or consider or waive. It just says they can't appear if they didn't do that. That's how I read that as well.
And there is one other property like that, and that parcel is, and Perry, you correct me if I'm wrong, but 0609-103-30224. That's another one in the red. That's another item that was valued on the income approach, and we did not receive the income and expense 7 days prior.
That would be item 13F on your agenda, Research Park Properties.
My question is, they want this combined with 51128. Is that also an income-producing property, or how can we combine two parcels?
Which one?
For Bowman Farms, we're doing 5213.6 with 51128.
Not that property. The property that did not turn in their income and expense is 031-88152.
It's Research Park.
That's one part.
It's in the red it's the third one down.
And then also the 103-30-22-4.
This one here. So the top one, they did not request the income and expense. That's the one that they had an issue where they wanted to combine.
Okay.
The second one, they requested it. That's the 8815, and they did not provide it. And that's item 12 on your agenda. This one here, they requested it for Research Park Properties, and they did not provide it, and that's down on item number 13F. So we might need to amend our motions on this one and this one based on if you're going to go with the statutes of them not providing income and expense requested by the assessor's office.
Yes, we definitely need to, if that is the case. After additional discussion, it seems clear that there are two specific instances where information was requested and not furnished in a timely fashion. So as such, we're looking at denying their appeal on those parcels. and one of them is for Bowman Farms. And if I'm understanding this correctly, it's 609-031-8815. Is that correct?
That's correct.
And the other one would be in agenda item 13F, research properties, and 609-103-30224,
That's correct.
which we'll consider separately because it's in a separate agenda item. So we need to amend our motion to remove parcel 609-031-8815 and to readdress that as a non-complying parcel and deny the right to continue appeal.
So I'll take a shot at stating the amended motion so that we can vote on that. The amended motion would be to defer and give appropriate at least 48 hours notice of the date to be heard to Bowman Farms, Inc. to hear their objections on the following parcel numbers: 0609-031-51128 and 0609-031-5213-6. Madam Clerk, have I stated that correctly?
That's correct.
Okay, so that's the motion.
Okay, I have a motion. Do I have a second?
I second. Oh, it's on. I second it.
Thank you. We have a motion and a second for the amended motion. All those in favor signify by saying aye.
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 Opposed? Again, please let the record note it's a unanimous decision. And we'll also put in our memory banks that we need to do the same thing with agenda item 13F for research properties. And maybe we should do that right now so we don't miss it. In looking at item 13 on our agenda, item F, research park properties, was asked to provide income and expense information, and they have not done it in a timely fashion. So we're talking about parcel 0609-103-3022-4, 5520 Research Park Drive. Knowing that they have not provided the information as required, I would ascertain a motion to not defer this assessment, but to deny their right of appeal.
I move to amend our earlier motion on item 13, that we would defer all of those actions except for the Research Park properties at 5520 Research Park Drive, that item 13F, we would not defer action on that and not accept the objection.
Well stated, thank you. We have a motion, do I have a second?
Yeah, I second that.
We have a motion and a second to reverse our earlier decision on research park properties, item F, item agenda 13. All those in favor signify by saying aye.
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 Opposed? Please let the record note it was a unanimous decision to change the status of item 13F, research product properties.
Do we need a motion to deny or dismiss the objection with respect to Bowman Farms parcel ending 8815-2?
Thought we did.
All we did is defer ruling on the other two parcels where we have the information, but I don't think we took any action with respect to 88152 or any of the others.
You did amend to deny 88152
Okay.
and approve 5112-8 and 521-3, 5213-6.
Did we do anything with any of the other?
We did not do anything with the remainder of the parcels, so
Okay, so I think, do we need a motion then to
Dismiss.
or deny further proceedings on those objections because we didn't receive forms by the 11 a.m. deadline today?
Good point. Yes, we do.
That is my motion.
Second.
I have a motion and a second. All those in favor signify by saying aye.
Aye.
Opposed? Let the record show that the remaining parcels on item J of the agenda for Bowman Farms have been denied the right to continue appeal.
Matt, did you second that? Okay, thank you.
Her pen was catching fire, we were moving so fast. Yeah.
On agenda item number 14L, and this is James and Catherine Mackey, 5826 Dolly Drive, parcel number 0609-051-7305-2. And he is in the room with us today.
Thank you. Mr. Dolly, the first thing, oh, I'm sorry, Mr. Dolly. I'm looking at your address. Mr. Mackey, the first thing we're going to ask to have you sworn in. And please note for the record that the assessor staff has been previously sworn.
You could raise your right hand for me. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. Mackey, it looks like you would like your assessment reduced to $510,000 from the current value of $545,200. Is that correct?
Yes.
Okay. Before we start presenting evidence, I'm going to read this to you. Chapter 70 of the Wisconsin statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the total value under appeal. The Wisconsin Supreme Court has given the Board of Review standards of evidence to guide us in the consideration of your appeal. Those standards are: the best evidence of value is a recent arm's length sale of the subject property. Next, the sales of reasonably comparable property. Then all other approaches to value, income approach on income producing properties, and the cost approach on special purpose and unique properties where there's not an active market. At this time, please share any exhibits that you have in addition to those you may have submitted earlier.
Is this on, or do I push?
Oh, it's on.
It's on, okay. I do have printed out what I will read here if you want that.
Okay, that would be very helpful. Also, has there been any recent sale of your property?
No.
Did you attend the open book and review the property record card with the assessor or assessor staff?
Say that again, I'm sorry.
Open book, where you can discuss your
Oh,
assessment?
yes, I emailed, yes.
Through email?
Yeah.
Okay, thank you. To try and keep things on schedule, we're asking everybody to, and I see you have a summary report, to read that summary into the record for me.
Okay. When our assessed value went from 429.4 to 545.2, a 27% increase, that did get our attention. I had a couple of email exchanges with Nick voicing my disagreement, but saw I needed a second opinion. I hired Frank Polkamp of Polkamp and Associates, who was referred to me by Dane County Title. He performed a full assessment, and I scanned it and forwarded text portions to Tracy, as well as I have the rest of the document here if you need to see it. He came to a market range of 510 to 535. I'm asking for an adjustment to be made to 510, which is still an increase of 19%, but more in line with the market sale price for our duplex. My reasoning is this: this is a duplex in a neighborhood of mostly single-family homes. The two homes next to us were supposed to be duplexes, but the design was altered when the builder found that duplexes were not selling easily at the asking price. The home next door under our shared roof is assessed at $103,000 less than ours. The freestanding home next door to us on our west is only $7,000 more. It's newer and has 4 bedrooms compared to our 3, with a higher level of finish. We are concerned we would not find a buyer at the current assessed value of $545,200 because of these other limiting factors: $375 monthly condo fees an odd master bath for this finished level of home, one sink and kind of awkward. Small hall laundry, which is on the way to the garage. Odd lower bath, a large tub that's never used due to its location to the toilet. A buyer would certainly not be a family. It would most possibly be a retired person wanting first floor living. The upper and lower floors are great bonuses, but assigning so much added value to their square footage is inappropriate. So that's our opinion.
You realize that without having your appraiser here to present testimony, that we cannot consider his appraisal?
Oh, I didn't know that.
I'm sorry I have to be the bearer of bad news then, but it's sworn oral testimony, and Mr. Polkamp would have to be here so we could ask questions of him in his appraisal process.
Well, I do have a certified copy here. I don't know if that's any value to you.
Yeah, I'm sorry, it's not. The court record, the record is fairly clear. It has to be sworn oral testimony by the person who prepared the information.
Well, that's what I have, I guess.
Okay. Sorry to be the bearer of bad news. Thank you. We'll then defer to the assessor's staff for their presentation as to how they developed the assessment.
Thank you. Amy will be distributing the written information summarizing the basis for completing the 2020 assessment of the subject property. I will briefly summarize the written documents with oral testimony. On the first page of section 1 is a summary of my qualifications to complete the assessment. I am employed with the City of Fitchburg Assessing Office as a residential appraiser, and I have an Assessor 2 certification, which expires 2/28 of 21. I have worked with the City of Fitchburg Assessing Office as the residential appraiser since March of 2019, and prior I worked for the Department of Revenue's Equalization Bureau as a property assessment specialist. I have a bachelor's in finance and real estate from the University of Northern Iowa and a master's of business administration from Drake University. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of property as of January 1st, 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines that the property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could be ordinarily obtained therefore at a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment role, the estimated level of assessment is 100%. On the next page, you'll find a location map illustrating the subject property's location. The next few pages are then the property record card that contains specific data and quantitative and qualitative physical characteristics of the land and improvements for the subject site. On the first page, you will see that this is located in the Harlan Hills Condos neighborhood and neighborhood group of Condo Res 2. It is, the subject property is located in the city's northwest side. On the second page, you will see the building permit history, which it shows in 2020, the furnace was replaced at this property. The sales history shows the last valid sale was October 25th of 2006 at a purchase price of $488,500. The property was inspected in November of 2019. In the Harlan Hills condo neighborhood, we noticed that the previous assessments were previously inconsistent and inequitable, so we put it in our 2019 workload to do a walkthrough of all the properties in the Harlan Hills condo neighborhood, and we got into 29 out of the 43 condos there. I completed all of the walkthroughs as we wanted to make sure all the properties were viewed with the same eyes. There was a 2020 open book appointment through email correspondence. The land value, it is valued as a condo unit, and there are 2 adjustments to the land, negative 5% as it is on Dolly Drive and higher traffic, and there also is a negative 15% adjustment given it is a attached condo versus a detached condo. On the next page is information regarding the property. It shows that it is a 2-story contemporary condo. It is wood exterior. It was built in 2006. The total livable square footage, including the basement finish, is 3,812 square feet. It is a A-grade construction property, and all ratings for equipment, kitchen, bath, interior, and exterior are average. It's 3 bedrooms and 3.5 baths with a gas fireplace and 2 additional plumbing fixtures. On the 4th page, it does show some attachments, including a patio, open porch, screen porch, deck, garage, and additional second patio. The 5th page will then show the sketch of the property, including the layout of the basement finish. The next couple pages of the packet is the market valuation detail. This summarizes the assessment calculations as completed by our automatic valuation model. It again shows the original base land value in the Harlan Hills neighborhood of $100,000, but there is again the 5% reduction and 15% reduction for a total land value of this property of $80,000. After the values from our cost module, the replacement cost new is $580,200. Given the year built of 2006, there's depreciation of 19.83%, which then gives a total value of the improvements of $465,200. And the next page will show a map showing the location of the subject property and recent comparable arm's length sales within the Harlan Hills condo neighborhood. The next page is a sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. The first recent, or comparison number 1, is 5808 Dolly Drive. That sold in June of 2018 at $590,000. After the adjustments, the comparable value is $604,800. Comparison 2 is 48 Arbor Edge Way, which is a detached condo. That sold in November of 2019 for $745,000, and after adjustments, that gives a comparable value of $529,400. And then 5806 Dolly Drive, which is attached condo, and that sold in June of 2019 for $435,000. After adjustments, it gives a comparable value of $556,800. So the estimated fair market value assessment of the subject property is $545,200. And based on the comparable sales, it gives a comparable market value average of $564,800. So the report adjusts the sales prices for differences such as the lot, building attributes, age and condition, marked location, and detached structures, if any. The adjusted sales prices reasonably comparable properties indicate that the assessed value of $545,200 is a fair estimate of the market value of the subject property as of January 1st, 2020. In summary, then, there is not a recent arm's length sale of the subject property. Consistent with the Wisconsin Property Assessors Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for the differences between them and the subject property. Thank you, and that concludes my presentation.
Just a point of comparison that I'd like your help with. I'm looking at comp 1, and in looking at that, it looks like it's about 3,900 square feet total, first floor and finished lower level, where the comp is, or the subject is 42 plus 100 square feet. Is that correct?
It's
26 and 16.
Yep, so first floor square footage there, the subject is 1,657, the comparable is 1,660. Second floor square footage, the subject is 960 square feet, 769 square feet for the comparable one. Basement finish, the subject has 1,657 square feet, and the comparable has 1,484 square feet of, that's size of basement, but basement finish, 1,195 square feet for the subject and 1,237 square feet for the comparable. So overall, they're pretty similar in total square footage,
Okay,
finished square footage.
and it's right down the street.
Yep,
And in your investigation, it's an arm's length transaction.
yes. And that, also noted, that was a 2018 sale, and so on the second box, there is a time adjustment for that, the fact that it's a 2018 sale.
Opportunity for questions and discussion?
I have a question for Mr. Mackey. So do I understand from the paperwork that you purchased the home in 2006 for $488,500?
No, actually, we bought it during the recession at the foreclosed price, the one that's not a market sale.
Ah, okay.
Mr. Mackey, is your unit the larger of the two units in this duplex?
Yes, it is.
Well, this is the second property we've looked at on this street with similar characteristics and features. The first one was a smaller unit. This is a larger unit just down the street from the other one. I think in our earlier examination, we found that the assessor had reasonably comparable comparables. In this case, it's even more comparable with comp 1 in that the size footprint is almost, not exactly, but very, very close. And that time-adjusted sale certainly supports the indicated value provided by the assessor. And I'm sorry that your knowledge of bringing this appraiser with you wasn't available to you, or you didn't know about it, because we certainly would have considered, it looks to be a very decent appraisal put together, so you wound up paying for something that we can't use, and I'm sorry about that.
Yeah, I didn't know where that was, where the statement was.
So,
I thought I was bringing the, I was representing.
well, it's sworn oral testimony, and you can't talk to a report. So at this point, based on the evidence presented, I make a motion that we sustain the current assessed value at $545,200 based on the evidence as presented to the board today.
Second?
I have a motion and a second. All those in favor signify by saying aye.
Aye.
Opposed? Please let the record note that the assessed value on parcel 609-051-7305-2 at 2856 Dolly Drive is being sustained at the value established by the assessor at $545,200. Mr. Mackey, if you're not happy with our determination, the form that the clerk is going to give you has additional appeal rights on the back of it. So please, you may want to read that and consider it, since you've already spent the money on a professional appraisal, to see what your options are as to what you might want to do in the future.
Okay.
Agenda item 15 has a long list of parcels, which apparently refer to deferring action on the following ag and outlot objections. So we have objections A, B, C, D, E, F, and G has an extensive number of parcels. So as we look at this, Madam Clerk, have we received timely notices of objection from these properties?
We have an objection form for each parcel and outlot listed on, under item 15. If you'd like, I can read item 15 into the record.
Please do that.
Okay. 15A, Jones, 2266 South Sean Road, parcel 0609-234-05-03-4, and parcel 0609-234-800-2. 15B, Waterford Glen Homeowners Association, 2692 Fahey Glen, parcel number 0609-151-2775-2. 15C, Waterford Glen Homeowners Association, 2684 Fahey Glen, parcel 0609-151-2800-0. 15D, Ham Fam Lands LLC, outlet number 4, Quarry Vista infiltration area. Item number 2, Quarry Vista outlet 7. Item number 3, Quarry Vista outlet 10. D4, Quarry Vista outlet 11. D5, Quarry Vista outlet 13. 15E, Fitchburg Lands LLC, Sassafras, parcel 0609-112-6725-2. 15F, Fitchburg Lands LLC, T-Berry, parcel number 0609-112-6750-2. Item 15G, Fitchburg Lands LLC, Terra Vesa. Item 1 is just a Terra Vesa map in your packet. Item 2, Terra Vesa Outlet 1. Item 3, Terra Vesa Outlet 4. Item 4, Terra Vesa Outlet 6. Item 5, Terra Vesa Outlet 7. Item 6, Terra Vesa Outlet 8. Item 7, Terra Vesa Outlet 13. Item, 8? Oh, Terra Vesa Outlet 14. Item 9, Terra Vesa Outlet 15. And I'd like to point out that the agenda omitted Terra Vesa Outlet 16, which I do have an objection form for as well. G11, Terra Vesa Outlet 18. Number 12, Terra Vesa Outlet 19. Number 13, Terra Vesa Outlet 20. Number 14, Terra Vesa Outlet 22. Number 15, Terra Vesa Outlet 23. Number 16, Terra Vesa Outlet 24. Number 17, Terra Vesa Outlet 25. Number 18, Terra Vesa Outlet 26. Number 19, Terra Vesa Outlet 27. Number 20, Terra Vesa Outlet 28. Number 21, Terra Vesa Outlet 29. 22, Terra Vesa Outlet 30. Number 23, Terra Vesa Outlet 31. And number 24, Terra Vesa Outlet 32.
Thank you. So we have 25 items listed under 15G to consider, plus the others that were read into the record. And the forms you've indicated have been received timely.
That's correct.
Knowing that they've been timely received, even though we haven't seen them at this point for correctness and accuracy, we should be considering a deferring action to a following time of our board review meeting. So I'd ascertain a motion to defer all of these ag and outlot parcels and objections to our later date because they've met the statutory filing requirements.
Before we act on the motion, just to confirm with the assessor, none of these dealt with the income approach, and you haven't requested any of that information?
No, they're all strictly an outlot, alleyways, corner little pieces, so they're all outlots, vacant land, except for Mr. Jones's, the first A, 15A. That is a farm, 2 parcels, an improved well, both the parcels are actually improved agricultural parcels. But the rest, B through G, all of those are vacant lots.
And you didn't make any request of income and expense information relative to the Jones property?
No, we did not.
So I believe we're all set then. Okay. Then I would make a motion to defer action on all of the items the clerk read into the record under number 15 to a later date with proper notice to the respective property owners and objectors 48 hours in advance when that date is determined.
Second.
Motion and second. All those in favor signify by saying aye.
Aye.
Opposed? Please let the record note unanimous decision was cast. Back to our agenda for today's hearings. We're waiting for the Henshu, 5780 Claremont Court.
Are you Mr. Henshu? Yes, I am. Do you want to come on up to the table, please?
Welcome, Mr. Henshu. Before we start, the first thing we'd like to have done is I'll have the clerk swear you in.
You could raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Thank you.
For the record, please note that the assessor and the assessor staff has been sworn in previously. We're looking at a residential parcel under appeal. The current assessed value on the property is $504,700. The taxpayer's opinion of value is $475,000. The property owner is here personally to present evidence to us today. And before you do that, I'd like to read you the statement, as I've been reading to all of our residential appeal files. Wisconsin Chapter 70 of the statutes, Chapter 70 of the statutes gives the assessor the presumption of correctness. The Wisconsin Supreme Court has ruled that to overcome that presumption, you need to present sworn oral testimony proving that the assessor erred in determining the value under appeal, and that's the total value. The Supreme Court has given the Board of Review standards of evidence to guide us in the considering of your appeal. Those standards are, first, best evidence of value is a recent arm's length sale of the subject property. Next would be sales of reasonably comparable property, and then sales of all other approaches to value, which would include the income approach on income-producing properties and the cost approach on special purpose and unique properties where there's not an active market. At this time, please share any exhibits that you have, and we'll be reading into the record. Do you have any?
Yes, I did provide exhibits at the time. Do you need my hard copies as well?
If they're part of our packet, we do not. We have them electronically.
Okay.
Okay, questions for you before you begin? Has there been a recent sale of this property?
No, there has not.
Did you attend the open book and review the property record card for your property with the assessor or the assessor staff?
Yes, I did.
Thank you. To keep things on schedule, we're asking everybody to do it, present their evidence in a reasonable period of time. And 2 minutes before that time expires, I'll give you a warning so that you can make sure you got everything in that you wanted to include, okay?
Okay.
Please begin.
There's 2 issues that I have raised in the information that I've provided to you. Your assessor did do a comparison of other properties in the area, which was the main basis for the conclusion. I'll talk about that in a second because I think there were some assumptions that were made in that evaluation that I would think are open to interpretation. And then the second one, which wasn't in the statute that you read, but it's in the email that was provided to me by the assessor, indicated that the assessment should be, equitable as it relates to other properties that are in the same general area and in vicinity. And that's what, is the second half of the argument that I have. So I'll comment briefly. You have the information. First of all, as it relates to the comparable properties, there was, I believe, 6 of those, but the one that I felt was most relevant and should be analyzed was a property that was sold directly across the street from my property at 5780 Claremont Court. That one was excluded from the sample, and it was the most recent sale, and I believe would have been more representative of what the value of our property should be worth. So that was the one question I had, was in selection of the comparable properties. And then there's 2 things that were in the comps that were subjective, in my opinion, and both of those worked to the detriment of our property. One of them is all of the properties were built in either 1989 or 1990, in that range. Ours was built in 1990. Our property was given a value of 22 years effective age, and all the other properties were between 25 and 30 years. And I know many of those properties. I know the condition of them, and I don't understand why they would have been given an effective age that was much older than our property. And also the sales price adjustment. There was a 6% adjustment factor. Properties in Fitchburg may have increased by 6% in 2019. I don't believe properties in the $500,000 range increased by 6% in 2019. In fact, one of the comparable properties was listed at $575, and it sold at less than $510. So higher properties in the higher ranges are not increasing at the same level as general property. So if you take those adjustments out, it would adjust ours down. And then the second factor, to be equitable in relation to neighboring properties, I provided you with a spreadsheet using Zillow, which has a powerful database and compares properties to one another. When you take our assessment, compare it to comparable properties and their assessment, ours was in excess of 100% of the Zillow value, and the average properties in our neighborhood in the same range of sales value were at 96%, which is why I came up with the 475. So combination of the two, I think your assessor did, some good work, tried to do a good job in comparing, but I think there are some issues that weren't addressed that were to our detriment as it related to the assessed value. I mean, I know our neighbors' properties. I live in the neighborhood. I've been in their houses. Right next door to me, to the right of me, of our house, and to the left are homes that are larger, have more square footage. They've lived there for 30 years, just like we have. Their properties are assessed lower than ours. And so that relationship value does make sense. And therefore, based on the comps and how interpretation was used, and in comparison, using a denominator that is reasonable, that's what causes me to believe that we're over-assessed.
So if I were to summarize what you said, the key points would be, 1, that higher value homes aren't selling at the same percentage change that you might see on lower value homes where there's more active market. And secondly, you feel the depreciation the assessor applied to your home is not reasonable, reflective of the actual condition and age of your home. Is that correct?
In comparison to the others.
Okay. Anything else you'd like to add?
Not at this time. I think those are the two main items.
Okay, thank you. We'll then turn it over to the assessor and the assessor staff to present their evidence.
Thank you. Amy is distributing the written information summarizing the basis for completing the 2020 assessment of the subject property. I will briefly summarize the written documents with oral testimony. On the first page, section 1 is a summary of my qualifications to complete the assessment. I am employed with the City of Fitchburg Assessing Office as a residential appraiser. I have an Assessor 2 certification, which expires 2/28 of 2021. I've worked in the real estate industry for over 14 years and in the assessment industry for over 4 years. I have worked for the City of Fitchburg Assessing Office since March of 2019 and worked for the Department of Revenue's Equalization Bureau as a property assessment specialist for 3 years prior to this. I have a bachelor's in finance and real estate from the University of Northern Iowa and a master's of business administration from Drake University. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of the property as of January 1st, 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines that the property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained therefore at a private sale, when such sale conforms to the definition of a recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used to determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as the systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment rule, the estimated level of assessment is 100%. On the next page, you will find the location map illustrating the subject property's location. And the next few pages are the property record card that contains specific data on the quantitative and qualitative physical characteristics of the land and improvements for the subject site. On the first page, will note that the neighborhood the property is located in is in Seminole Ridge. And it is located on a cul-de-sac with city water and sewer. On the next page, you will see the building permits. It shows that there was a bathroom remodel for this property completed in October of 2017, and the hot water heater was replaced in May of 2019. There are no recent sales in this property, in the notes section, you will see that the last full inspection of this property was in October of 2017, and there was an open book appointment in August, and there was a change of this property. In our email conversation, he had noted that neighboring properties' kitchens are of higher quality than his. We had previously had the kitchen rated at good, given there was a remodel in 2006, but we did adjust that during open book to an average rating, which reduced the assessment by $8,600. And the land section below shows this is valued at a lot value, and there is a positive adjustment to the lot given the subject property is located on a cul-de-sac. The next page will highlight the details of the improvements to the property. It is a 2-story custom house with aluminum siding. There is a masonry adjustment, 460 square feet, It was built in 1990, and it is 4 bedrooms, 3.5 baths. The equipment ratings, or the equipment is average. Kitchen, again, I noted that we had adjusted that from good to average since it is an older kitchen remodel. The bathroom was remodeled in 2017, so that rating is good. There are 2 fireplaces, 5 additional plumbing fixtures. The first floor square footage is 1,733, second floor square footage of 1,210, and finished basement living area of 1,357 square feet. The grade of the property is B+, and the attachments, there is a garage, patio, and open porch. On the next page, you will see the sketch layout of the property. And the second floor, there is that opening in the middle of that, because there is, the staircase is, there's an opening in the entry that's open to second. So the next page of the packet is the market valuation detail. It summarizes the assessment calculations as completed by our automatic valuation model. The land, after adjusting that 5% based on it being on a cul-de-sac, the value of that is $89,300. The total improvement value, replacement cost new, is $565,726. The adjustments, depreciation is 26.57%. This was built in 1990, but there is an effective year built. It updates that to 1998. If there are improvements to a property, we adjust the effective age based on those improvements. And so given there was a kitchen remodel in 2006, we usually, for kitchen remodels, we add additional effective age to that and the bathroom remodel, so we increase the effective age by 8 years based on those remodels. So the physical depreciation is minus $150,000, which gives a total value, improvement value of the property of $415,400. So the next page of the document shows a map that shows the subject property and reasonably comparable arm's length sales. And following that is a list, the sales comparison report that validates the mass appraisal assessment. The report lists comparable sales that we determined from the best information available that they do represent recent arm's length sales. So normally we only include 3 comparables, but in our discussions with the property owner, we included an additional 3 that he had brought up in our discussions to provide those comparable values. So was on the wrong page. So the styles of these homes are custom and contemporary, and the first comparable, and the gross living areas, including basement finish, range between 3,168 and 5,531 square feet. The effective years of these houses range from 1989 to 1998. So comparison 1, located at 5739 Timberview Court, sold in June of 2019 for $460,000. After adjustments made for the differences, the comparable value is $520,800. Comparable 2 at 5764 North Hill Court, sold in March of 2019 for $476,000. After adjustments for differences, the comparable value is $526,100. Comparable 3 at 5800 Ivanhoe Circle, sold in August of 2019 for $475,000. After adjustments, the comparable value is $514,100. Comparable 4 at 5744 Timberview Court, sold in August of 2019 at $424,000. After adjustments, it gives a comparable value of $512,800. Comparable 5 at 2869 Forest Down, sold in August of 2019 at $517,000. After adjustments, the comparable value is $500,700. And comparison 6 that the owner had brought up previously at 2924 Forest Down, that is located across the street from his property, sold in August of 2019 at $387,500, and after adjustments gave a comparable value at $472,800. And we did want to note, when reviewing sales, we did mark this as a valid sale, but compared to most of the sales that we saw in the neighborhood and surrounding area, this was an outlier sale. There were adjustments of 52% to, when looking at comparables, we look at the percent gross adjustments, and this property had gross adjustments of 52% compared to the other adjustments for the comparable properties of respectively 19, 18, 27, 34, and 32%. So the adjusted sales price of reasonably comparable properties indicate the assessed value, fair market value of this property of $504,700 is a fair estimate of the market value compared to the comparable market value of $508,500. So in summary, there is not a recent arm's length sale of the subject property. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on volume 2 of the manual and 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for differences between them and the subject property. Thank you, and that concludes my presentation.
Thank you for your information. Questions of the property owner or the assessor as they presented their information that you might need answers to?
May I provide some comments further?
No questions? Go ahead.
So, two things I'd like to point out. The property that I questioned across the street that was not used as a comparable, I have what was provided to me by your assessors here. That property was not ever provided to me and is not in what was sent to me. Now, that being said, I just want to highlight a couple of things. I provided in my packet a spreadsheet of comparing assessments to the Zillow analysis, if you would so kindly go to that. And I'll give you an example of why I think the subjectivity in here has to be influencing it. So for example, 5764 North Hill Court in your packet, the comp value that was provided here is for $526,100. Its assessment for 2020 is $476,500. So this comp is 50 grand higher than the assessment for 2924, which is in your packet. 2924 Forest Down is $472,800 is the value that was I'm compared against. Its assessment is $427,600, and for 5,800 Ivanhoe Circle, which the comp is 514, it's assessed at 475. So why should I, even if my value is 504, which I'm not agreeing with, why should I be paying taxes at that level when all of these other comps are 50 to 75,000 less than mine? So if the comps, and you're supposed to be at 100% of value, which you're stating, then your assessment should be at those values, and they're not.
I have a question for the assessor.
Well, he's raised an issue.
Okay.
Does the assessor have an answer to that particular issue that's been raised?
So when I look at, well, one, we do mass appraisal. So we don't go automatically right to that sale price. We look at all of the sales that occurred, and you may have some outliers. In our opinion, the sale that Nick added in, comp 6, there's a lot more adjustments to that. And that sale, we don't consider that, we believe that's probably just an outlier. As far as 5764 North Hill Court, so that sale price was $476,000. So when we try to be at 100%, according to what he has here, it's saying that the 2020 assessment is $476,500. So it's just over their purchase price. Without having all of our other database, we don't know if maybe they made a change before or after. I don't know that because I don't know that information. This one is which one?
That's the.
Okay, and so 2924 Forest Down, like I said, we do not automatically go to the purchase price because we're doing mass appraisal. And in that case, that assessment is over their purchase price. Because in our opinion, that would be an outlier. It did not fit the trend of everything else. We do not exclude outliers, we look at them. And I don't know in our records if this person came in at all, but I don't recall talking with that property owner at all about that. So, maybe there was something about that sale we don't know about. And I don't know if it was estimated or not. So, and then this one, 2869 Forest Down. So again, that one sold for $517. According to the sheet, it's assessed at $531,600. And again, I don't know. Do you have anything in the file about that? Sometimes a property will come in over, again, because we're doing mass appraisal, or they could have remodeled the basement after, they could have added a deck after. I'd have to look in each individual file to look at that. Our goal is to have those assessed at as close to the sale price as possible, but we're still doing mass appraisal. And so based on where we talk about that, our sales comp is taking the sale prices and adjusting it for the differences between the properties. Those sales comparisons that Nick has, it's showing us on sales comp 1, that's telling us our comparability rating is 100%. That's saying that's a really good comp. So if you look at that, even comp 1 at 100, comp 2 is 99% with minimal adjustments of 18%. Comp 3 is 98% similar with a 27% adjustment. And when you flip it over to the back side, you can see that they're all the same grade properties on those three. The year builts are all very similar, 1989 to 1990, all two-story. All have first floors that are relatively the same, second floor stories that are very similar. Basement size of the raw basement, the actual basement. The first two have basement finish, where the third one is doing an adjustment for that. But each of those items is adjusting it up or downward based off of the differences between them. They're all, two of them are 3.5 bath. The third comp is 2.5 baths. The effective age, if we go back up to the age, comp 1, 2, and 3, they've all have a different effective age. And typically when we do that, like if a bathroom traditionally might have, if the bathrooms were remodeled, we would go from an average rating to a good rating. And then we change the effective age about 5 years. On kitchens, it's usually about a 10-year effective age change, and then average to good is kind of our process of looking at that. But each of those items, it depends. If it's only one bathroom, it might only be 2 or 3% effective age change versus the 5. So it kind of depends on each situation and that. But each of these sales is being adjusted to that, so that it's going to be different.
You had a question, Craig?
Yeah, I have a question about the effective ages of the comparable properties. So I heard that the subject property's comparable age, or I'm sorry, effective age, was changed. The actual age is 30. The sales comparison uses 22. The other properties, as you noted, are also 30 and 31 years old, but the homeowners pointed out that the effective ages, some of them are 31, 26, 30, 25, and 26. Because we're using effective ages for the comparison properties, what is that based on? Is that based on information in your database about whether kitchen or bath updates have been made that would impact that effective age?
So when we view a property, we would typically will go out for building permits for kitchen remodel, bath remodel. And when we go out and we see that they've changed that from the original kitchen to a completely remodeled kitchen or completely remodeled bathrooms, that's when we'll change those effective years. So those would be pulling out of our CAMA system from whenever someone last walked through them, and being these are sales, they should have been walked through. Or if we have to estimate, then we'll search the photos, we'll read the MLS, their descriptions. It says the kitchen's recently remodeled, and if we didn't have a note of being remodeled, we will estimate it and move that effective age along with those ratings on that. So this tells me that there's probably some type of kitchen or kitchen or bath remodel based on each of, like comp 1, 2, and 3. There's 5 years difference. So I'm estimating it's probably a bathroom, or it could be an older kitchen remodel that has changed over the years. I don't know without pulling the actual file folders and looking at each individual and what that cause is. The effective age could also be an addition. So there are various reasons we put effective age changes on. It's typically kitchen, bath remodels, or in addition to the house, a fire. If you have the original basement, in that case, we use a formula for that. Or we also use a formula for a large addition based on what's new, the percent new versus the percent old.
Okay, any other questions? I guess we're at the point then where we need to deliberate as to where we want to go with this appeal. As the information's been presented, I see that the property owner made a good statement that higher value homes tend to have a slower response in the market. But we've seen a number of these homes today, and we're seeing that the market in Fitchburg is pretty strong and active. Depending on how the home has been maintained, they seem to sell at a substantial price. Maybe not exactly what the owners are asking, but certainly within a reasonable range. And the sales that have been presented by the assessor today on this appeal and others that we've looked at today have strongly supported that determination on my part. The other element that's come up is effective age. And it sounds like the bathroom and kitchen upgrades that have been done in this house have, in the assessor's opinion, changed the effective age by approximately, I would say 5 to 8%. Just trying to pick a number that, for 30 years old, about 30% would be a ballpark. Yours is sitting at a number at 26%, a little over 26%, but so about 4 or 5%. 4 or 5% on 500,000 comes out pretty darn close to the difference we're talking about here and the determined between the assessed value and the value asked by the property owner. So it's part of the reality of the Wisconsin property tax system. You make a change, and unfortunately, it does have an impact on the taxes that you pay. So based on the evidence presented, I feel we should make a motion, I'd make a motion that we sustain the assessment at the value that's presented by the assessor, as has been supported and defended as the Wisconsin statutes require, showing that the market evidence supports the conclusion of the mass appraisal value that was established.
Can I add something before we vote? I actually have a different opinion on this one. Looking through the comparisons, in my opinion, or just looking at some of the effective age, for example, comparison 5 impacted the value 42,000. Comparison 6, it impacted at 37.7. And when you aggregate the impact of the effective age on the comparable market value, it's $21,250 difference. The concern I have is that it doesn't sound like we have concrete information to support those adjustments on each of the comparison sales. Now, the impact on some of the other ones isn't as significant. For example, on comparison 1, the impact is only 11.5, and that one has a higher comp score, but it just occurs to me that there are some significant numbers in here for the effective ages that is impacting the comparable market value. And, you know, when I start adding that up, it creates a significant swing. I don't know that the objector's value of 475, I don't think I can get all the way there, but in kind of playing with some different numbers, I did arrive at a different value than 5047. I don't know how far to take that, but can you tell me anything more about that? That's really what I'm struggling with, though, and I want to tell you that, so if you have more information, you can.
So what I'd like to say is, you know, those effective ages, it's based on the depreciation. And being these are all very similar in age, they would, you know, their original depreciation. But that effective age, when we do those, how do I say it? When you do a kitchen remodels in these type of homes are coming in $40,000, $60,000 for just a kitchen remodel. And then that's going to bump also that sale. So that might just be that cost. But that depreciation is, how do I want to explain this?
Well, let me ask you
It
this.
affects like your total market.
Has there
of that
been a
property.
kitchen remodel on comparison number 5?
That I'd have to pull each individual file. So we only typically change, that effective age has to do with some type of remodeling, typically on a property. And each of these we should have entered, so they should have only had an effective age change if there was some type of updates or remodeling done to those properties.
Right, and what I'm
Which would
saying
make
is,
them sell higher and bring that value in.
no, what I'm saying is the effective age is the same as the actual age on comparison number 5.
And that would mean more than likely there was not any type of remodeling done on those sales. So there'd be a greater adjustment to his property, which had past remodeling done to them.
Right, and what I was asking is, what information do we have that there was, and I know I'm asking you to state a negative or prove a negative here, but how do we know there wasn't a remodel? I mean, this is a 31-year-old home that just sold for in excess of $500,000. How do we know there wasn't a remodel, a significant remodel?
We would have reviewed the sales by doing full walkthroughs of those properties. These are all 2019 sales. So as long as the property owner allowed us in that property, we would have known if it had a remodel. On our record cards, there are past, because, you know, they did everything by paper in the past, and we're going, you know, we've been working towards improving. But let's see if I can find it in here. We typically have an old record, you know, a harder record card that, and it's hard to show it on here, but, and I can hand it around. We will make notes on this record card as to the kitchen, when it was remodeled. There'll be building permits in some cases that will tell us if it was remodeled. But on our old notes, it'll say Like in this one, kitchen, and it's crossed off, oak counter, oak contemporary cabinets, work island with wood trim around counters, vinyl floor, laminate counters with wood trim, dinette vinyl. Then in red, it says remodeled 07, same layout, off-white cottage-style cabinets, gourmet appliances, granite countertops, tile floor, work island, some glass doors.
Which property is this?
This is the subject.
No, and I understand
Surround
what
sound.
happened in the subject
But what
property.
I'm telling you is we would have this information for every property we go to.
And so there's no information about an upgrade, and I'm just using the kitchen because that's the big dollar one in comparisons 5 and comparison 6.
Whoever walked through it this year, if we got in, and I state that again, we use the best information, we would look at these older record cards to see what was there when we last viewed it versus what we see when we go through. So if we go into a kitchen and we see that the old note said laminate countertops and oak cabinets, and we go in and they're cherry cabinets and granite countertops, and there's notes that tell us what it looked like in the past and what it looks like today. And that's how we would know it has a kitchen remodel.
So to rephrase it, I think I hear you saying, if you had any record that stated that about comparison number 5, it would be reflected in the effective age.
Correct.
Craig, I'm curious as to your line of thinking here, because we've reviewed earlier that it isn't the comps that are the basis for the assessment, that it's a mass assessment that's applied, and the comps just show whether or not the assessment is supported. And if anything, if comparison number 5 had a kitchen remodel that the assessor's office was not aware of and had a recent sale of 517, that would just serve to still support the assessed value of the property. If anything, you know, it would make comp 5 an even more similar.
No, it would reduce the value, the comparable value by $42,000. So instead of a comparable value of $500,000, we have a comparable value of $458,000. Now, I'm taking that one element in isolation and assuming that the updates to that home are the same as the updates to the subject property so that we would have the same effective date. If we do the same thing with 2924, it would adjust the comparable value by $31,000. So my point is that we're putting a pretty big thumb on the scale here, assuming that there's been no remodels done inside a couple of these comparable properties, and it's affecting the, so if we're looking for support in these comparisons to the 504,000, if I adjust for the effective date, I'm coming up with a value that's more like 490 to 495,000 instead of the 508.
You're making an assumption.
I am.
And in our case, they should have all been walked through or estimated with the best information available.
And I'm
So in
concerned
my
that
opinion, our data is much more accurate than if you make an assumption
that's
in
a
those
fair point.
records.
I'm sorry.
I will disagree with what your assessors are saying in regards to your data being more accurate, because what was my kitchen before we remodeled? It was laminate and vinyl. The majority of homes in our neighborhood were granite and tile as they were built new. We upgraded, we love our kitchen, I'm not refuting that it is now granite and tile. If you go through the majority of homes in our neighborhood, they were that way from the beginning. So by us remodeling, I'm being penalized by saying, okay, I got a building permit and I upgraded to what is a general standard in our neighborhood, and you're putting me at 22 years and you're keeping them at 30. Their kitchen is every bit as good as our kitchen, but I upgraded.
We would have to look at all the properties because, you know, his grade on his property is a B+ grade. You know, comparable 2 is a B grade. 5 is a B+. Comparable 6 is a B- on here. Where's your first sheet?
Okay.
So, and comparable 1, 2, and 3 are all B+ grades. So those are more similar than comparable 5 or 6, which are going to have more adjustments. I don't know what other properties are. You could have an A- grade, which would be even higher, which
Okay.
would have the granite and everything.
Let's get back to basics. And we've talked about the 2 points, I think, more than we needed to. And at the bottom line is, what is the market for this property as of January 1st of 2020? And the assessor, using the resources she has available, has given us the mass appraisal indication with the adjustments made, hopefully consistently by the appraisal staff. The property owner did not really give us any comparable sales data to support his conclusion as to the $475,000 value. So we got to get back to the basics of what does the statutes require. The sales of comparable properties, reasonably comparable. Are the sales the assessor presented reasonable? Yes. Do they indicate that there could be some difference of opinion? Yes. Are we going to have to sit here and debate the difference of opinion to the penny? No. We're at a point where we make a decision, is the assessor right or is the assessor wrong? Based on what the taxpayer has presented to prove the assessor wrong, I say the assessor is correct. So let's get this to a motion, and let's get this resolved. I'm making a motion to sustain the assessor's value at $504,700. Do I have a second?
Seconded.
All those in favor, please signify by saying aye.
Aye.
Opposed?
Nay.
Please let the record note, 1 dissenting vote. As you can see, this is an issue that is a subject of personal opinion. It's a subjective approach. It's not a hard and fact crunch a number. And in this particular case, the consistency of the work the assessor is doing has to be considered correct unless proven otherwise. And I'm sorry, you made a good argument about 2 points, but it wasn't convincing enough to support the requirements of the law. So thank you for coming in today. Thank you. I've told other people as they got their notice of determination from the clerk. On the back of that notice is other appeal options that are available to you. If you feel that we have erred in our decision, please read it carefully, and there's options there for you to continue the appeal process if you so desire.
Item letter N, and he does have an exhibit that I'm going to hand out.
computer, and this is what I have. You sit down. If you're going to stand, please, we need to have to speak into the microphone.
Hopefully that's working.
Before we begin, Mr. Sorensen, I'm interested in understanding your appeal.
Thank you.
It looks like on here you've listed 21.92 acres of undeveloped land.
Yes, sir.
Is this a residential parcel, or what is it?
The city thinks it's residential. The city has zoned it as residential. I think it's wetlands, and I think it's always been wetlands.
Okay.
Up a bit here.
All right, we're not starting yet. I just wanted to get a clarification as to what we're talking about, okay? So you have one opinion and the city has a different opinion on classification.
Yes, the property value
Okay,
has gone up.
just a second, sir. We're not quite ready yet. Classification issues are a little bit different than valuation issues.
Mm-hmm.
And so I just wanted to make sure we're all on the same page as we start talking about what's going on and what you're looking at and what we're looking at as far as the information we need to ask of you. I don't see anything in your handout showing information as to the value of your property. I see some nice photographs of your property showing that it has standing water, it has some grassy areas, it has some, looks like a blacktop driveway and approach area to an improvement.
There's an attachment that I sent in that explains some of the details of why I disagree with the idea of the area around my house being classified as residential property and at the same time 100% wetlands.
Okay, so I don't see, well, I guess I'm not looking in the right spot. Just a second. I'm going to ask the assessor, what is the value of this parcel, land and improvements?
The total assessed value is $383,500. Do you want it broken out?
Yes, please.
Okay. So the total land value is $142,500, and the total improvement portion is $241,000.
Okay.
There are two classifications of land. So we have classified 2 acres of residential and 19.92 acres of undeveloped, which is, I believe, our swamp value.
Okay, well, we have a problem in that we hear appeals on the total value of the property, not just the land. So we cannot hear your appeal if you're just going to talk about the land, because there's nothing we can do for you on the land assessment.
The total value, I don't have a problem with the increase in the valuation on the house itself.
It's the total of the parcel. So
Yeah.
and that includes the improvements.
Yes.
So we cannot and will not break it apart to have you talk about the land separately. We need to have a total property valuation, one number, one parcel.
Provide one number in his objection as to what his opinion of the total assessed value is.
But he's talking classification. We can't rule on classification.
Right, the zoning.
Well, it's the G1 versus G4 distinction.
Yeah.
That's a distinction made by the assessor.
I disagree. I think this board has authority to rule on classification if the taxpayer, or I'm sorry, if the objector presents information that suggests that it's improperly classified.
But we also have to look at the total value. There's nothing here on residential, the residential parcel, part of the parcel.
Yeah, I mean, if.
We can look on classification on agricultural property.
So this is all zoned as rural, and the proposals it should be classified as undeveloped. I couldn't tell you the distinction between the two classifications. I'm hoping that maybe the assessor can, but I guess to the extent that I understand that the issue is with the value, yeah, I mean, I see the point that the only objection here is with respect to the land, but it isn't the valuation of the land, it's its classification. And the reason that's important is because the classification says if we change the classification, we use 50% of the market value instead of the full market value. Am I right about that?
If it's contiguous to qualifying agricultural land.
Well, and that's the question.
So I mean, I guess, so this is undeveloped classification is requested. It's assessed as residential. How would we go about making a determination whether it's rightly or wrongly classified?
So residential would be where where your land and where your buildings are would either be classified residential, commercial, or ag home site. So you would not have buildings on undeveloped land. Anything that you would have your building site on would need to have some class residential, commercial, or ag other, depending on whatever, that is. So any improvements would have to fall on that. This is an improved site. It has the area of his home, which I believe you live in. And so we would have to have a residential classification under that land.
So this is all one parcel?
Yes, it's all one
And
parcel.
so you can only have one classification on a particular parcel?
No, we have two classes. So we have the area broken out.
No. I mean, you can't have more than one classification issued with respect to one parcel. You couldn't have a parcel that is partially residential and partially undeveloped.
That's what this one is.
It is.
This is. So we have 2 acres of this whole site. So we have 2 acres of 21.928 acres. 2 of that is residential, and the other 19.92 acres is considered swamp because of the water and the wetlands there.
Can I ask why 2 acres is determined to be residential?
Because we measured out the area based on the air photo, which we would present to you, but based on the air photo of the home, the area that he is using for his home site is the 2 acres that are calculated for his site.
His house covers 2 acres? Or there's
Yep,
some
yep,
setback
no,
that's...
you can,
So
air photo will show what it is if we present. The rest of this is considered swampland.
Okay. Yep, I understand. So we can't, because the house sits on a 2-acre site, that's got to be residential. It can't be undeveloped because it is in fact developed.
It is developed, yes.
Okay.
It has a house on it that he is living in. And so that cannot be classified as swampland.
Okay.
Could the
And
property
that's
owner,
what I think is wrong, because the 2 acres just comes from nowhere. And at the same time, my land has been zoned 100% undevelopable as part of the wetlands.
Yeah, you
So I
stated,
can't build anything anywhere on my land.
you stated that if your house burned down and you needed to rebuild, you would have to build completely within the confines of your current footprint.
That's
And
correct.
not 1 foot over, or else that would be considered encroaching on the wetlands.
so here we are. We're at a point
Right.
where we have a question as to classification and valuation. And we have a parcel that's a mixed-class parcel, residential, in this case, swamp and waste. You can certainly have both values on the assessment roll. The problem becomes, I see no information. They're both market value classes, right? You haven't changed swamp and waste as a market value class.
Correct, correct.
So they're both market value classes of property. So if we're going to hear your appeal, we're going to hear your appeal on the residential parcel and 2 acres, the residential part of your parcel and 2 acres, and 19 acres of swamp and waste, which have been valued separately by the assessor, which you can then look at and determine what is the value of that swamp and waste. Now, you may say it's swamp and waste and has no value, but I've seen thousands of sales in southern Wisconsin in my career where that swamp and waste is sold for valued by the assessor as basically recreational land. We can't call it recreational land because the statutes don't provide for that, but that's basically what it is. So it's either used for hunting, fishing, depending on the access that it has, many other recreational uses. So we can certainly value the property and review it as a mixed class parcel, but we can't review one separately from the other, and I don't see any information on the residential property, the 2 acres it sits on, or any market value indication from you as to whether or not the swamp and waste is worth what the assessor is saying it's worth.
Well,
Do you have information as to the value of the 19 acres that you're calling as, whether the assessor's calling it swamp and waste?
I don't have a problem with that assessment of the wetlands.
You don't?
No. The thing that I think is inappropriate is, according to the maps, if you look on my page 5 of the handout, you see the mapping of the wetlands around my property, and Highway 14 goes north and south, and then there's...
If I can interject, if he's going to start any type of testimony, he needs to be sworn in.
Very true.
I think we should hear this case.
And Tracy, is there a copy we can have? Because we didn't get a copy of whatever he's referring to.
So to understand, you're saying the 2 acres in the home value is what you're objecting to?
Yes, it's the fact that there are 2 acres that are declared to be rural residential land that are also declared to be 100% wetlands. And that's what's happening on the map. If you look at page 4 in the map, you can see there's the wetlands are kind of mapped out. And then there's the yellow area. I don't know if you can tell where my plot is.
Sorry, he still needs to be
So
sworn.
is this a floodplain area?
Yes.
If you're going to point out anything on your handouts and you're going to take any of that into account, he needs to be sworn in.
Okay, let's swear him in.
Okay. Can you raise your right hand? Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you for coming. This is an unusual parcel.
It is very unusual.
It's an unusual situation. So you're telling us today that you have 21 acres of property that's basically considered to be a floodplain,
Yes.
even though currently you have been, at some point somebody was allowed to build a home on approximately 2 acres. It's
The 2 acres, I don't know where that comes from.
Well, it's the assessor's determination. It's above grade property, but it's all floodplain is what you're telling us.
Yes.
And so you're saying that because of it's in a floodplain, you cannot do anything with the property. And the fact that if your house was not there, you couldn't put it there today.
That's correct.
So when did this floodplain designation come into existence?
I'm not sure exactly. I've lived here for 32 years, so the important thing is on page 5, but I'd like to explain on page 4 that unusual 8-sided thing is my lot. It's 8 Farm Road, and then the section line extend, and that's the northern boundary of my lot. And there's like an 8-sided chopped up area in there.
Could you, I don't see what you're talking about, an 8-sided chopped up area, so could you hold up your map and point for us?
This is Haight Farm Road, and the section line right below the creek. Section line runs along the creek. My land is that kind of chopped up land underneath there.
Okay.
Originally, they drew the boundaries around the wetland. That's where my land came from. Actually, that's why it's chopped around. The Cohee lot is right below it. It's the 5-section lot. It's Roger Cohee's residential lot. And his land is actually quite a bit higher. My land is that multiple chopped up thing. And what's happened is the city tried to figure out what's wet, what's not, plotted it out, and basically what they're using is the Wisconsin wetland maps. But it appears that the yellow area is dry, all dry land, and the blue area is wetland. But that's not actually the case.
I think the yellow area is just the rural residential zoning.
Yes. And then there's a, what's called a wetland overlay. So even though my property is about 22 acres and zoned as rural residential land, 100% of it is covered by this 300-foot extension overlay that declares it all to be a 100% wetland. So it's like a double speak. It's wetland, it's not wetland, it's wetland. Because it's all wetland, it means that I can't have any construction anywhere on my property,
Well,
including the 2 acres.
here's what I see happening. First of all, you have a property that's basically a non-conforming use, that you couldn't rebuild it if 50% of it was damaged, or beyond 50% you couldn't repair. So it's the assessor's determination that that home and the area that you're using around that home is approximately 2 acres. Is that reasonable?
I don't think that's reasonable.
Why not? An acre is 200 by 200. How many acres? You have a driveway to get in there, you have a home site. How big a home site do you have?
Well, if you look at page 8, you can see the home site. And you see that the land pitches down to the left and to the right. So my home site is approximately 4 meters above the water level, and it pitches down in 3 directions. You can see my shop is already dropped 1 meter.
I asked you how big an area approximately. I see a lawn, I see a driveway, I see a shed, I see a house, I see trees.
Well, all around my house is pretty much pitched down to wetland.
This looks pretty flat to me. So how big is that area? You live there, we don't. You should certainly have an idea. How long does it take you to mow the grass?
Depends on the time of year. Sometimes I can't mow it at all because it's wet.
I mow a half an acre and it takes me 45 minutes to an hour, depending on how long it is. How long does it take you to mow the grass?
About an hour, depending, but I usually only mow parts of it because a lot of it tends to get really wet.
Okay, well, your answer is indefinitive, so I'm going to assume that the assessor's estimate is reasonable. And if that's the case, you're asking us to then look at what should your property be classified.
I would like
Let me finish. We have the house at 2 acres, and we have 19 acres of swamp and waste. That's basically what you're telling us it is swamp and waste. And the assessor has it classified that way. So I'm not sure what else you want.
If you look at page 13, you can see the area behind my house. There is an intermittent stream that flows through my backyard and drains about 600 acres of Fitchburg farmland, and it all floods out. So I think the maps are very deceptive because you can't see how much water there really is.
But it's swamp and waste. That's what it is.
It's mostly swamp. The area around my house is much less than 2 acres. I would estimate maybe a half an acre. It's on the top of a drumlin, pitches down on 3 sides, and you can see this is the area behind my house is 12, 13, and 14, you can see looking back to my house.
Okay. Thank you. I understand this is an unusual appeal, and that we're looking at something that is not typical and normal when we come to what the Board of Review would handle.
Thank you.
So I guess we're going to ask the assessor to give us her read on this and how the value was established, so we can try to make a determination, is the swamp and wasteland properly assessed? And is the residential value for the total home and land a reasonable value? So I'm going to defer to the assessor, and I'll let the record know that the assessor and her staff have been previously sworn.
Okay.
Please give us your read on this if you could.
Do you want me to do our normal? I have some additional info in the packet that I think would be beneficial to the board. Okay. So, thank you. Nick is distributing written information summarizing the basis for completing the 2020 assessment of the subject property. I will briefly summarize the written documents with oral testimony. So, sorry, my pages got all mixed up now, so let me see that one so I can state this in the right order for you. All right, so on the first page, this is all over. All right, so on the first page, I will briefly summarize the written documents with oral testimony. In section 1, I am Amy Mercer. I'm the City of Fitchburg's assessor. I have an Assessor 2 certification. I have over 20 years in the assessment industry. I worked 2.5 years with equalization for the Department of Revenue. I've worked with the City of Fitchburg, the City of Janesville, the City of Madison also. My degree is in landscape architecture. Section 2 states the purpose of the assessment and standards for establishing value. The purpose is to estimate the full value, often referred to as market value, of property as of January 1 of 2020. Part A outlines the standards for establishing value. State Statute 7032 outlines the property shall be valued in accord with the Wisconsin Property Assessment Manual and at the full value which could ordinarily be obtained, therefore a private sale, when such sales conform to the definition of recent arm's length sales. Part B contains a definition of market value, including criteria that a sale must satisfy if it is used in determining market value. Part C is information from the Wisconsin Property Assessment Manual that specifies that mass appraisal is the underlying principle that Wisconsin assessors should be using to value properties in their respective jurisdictions. That the purpose of mass appraisal is the equitable and efficient appraisal of all property in a jurisdiction for ad valorem tax purposes. It defines mass appraisal as a systematic appraisal of groups of properties as of a given date using standardized procedures and statistical testing. And the manual notes that although similar to single property appraisal or fee appraisals, there are notable differences between the two. And finally, because this is a full or market value assessment rule, the estimated level of assessment is 100%. So, let's see which way this goes. All right, so the next page in your packet will show an air photo of the property. Well, I'll get to that, I guess. So you can see that the home is on the front section, and you can see some grass area. The property owner contacted us during open book, and during that time frame, he talked to me about the water coming across the road and through a culvert that would be located on the northwest corner. He stated that there's a culvert that comes under the road there, pulling water across and through his property, running basically diagonally towards that back grass area behind the house and down into the creek area. So when he contacted me, I pulled up the air photos, I put on the layers of the floodplain, I put on the contour layers, so I added all of that in. Based on that, I measured the site around his house and his detached building on the other side of his home. And the area that came to was 2 acres. Previously, if you go to the next page, I believe. You can see the property record card. So on that first page of the property record card, if you look at 2019, we actually had 6 acres of residential and 15.928 acres of undeveloped. That 6 acres included that grass area where he talked to me about on the phone that said water came through and often floods that out. So because he stated that the majority of the time that area is underwater, I took and I minimalized the area around his home to include the areas based on what was level, based on the contours, and what appeared to be, what I want to say, the site. It's where he's using for his residential site. It's not affected by the swamp. And so we changed the acres from residential of 6 acres down to 2 acres, and the undeveloped area from 15.928 to 19.28. And that was an open book adjustment. All right, so he is in the rural residential area, built prior to 1984. The second page of the record card shows there is no recent sale history of the property and no recent building permits. Under the notes section, we did have an open book meeting where we discussed it on August 4th, and I just stated what where I changed those classifications around. If you go to the land below that, that's where it's separating out into the 2 classifications of residential and swamp. Then below that, he has an outbuilding. It is a farm utility pole building. We have it classified as 4-sided metal shed, approximately built 1970. The width, it's 30 by 40, so it's a 1,200 square foot shed. Grade C in average condition, and it has a concrete floor is what we have listed. The house we have is a 1-story ranch, stone-sided, built in 1952, 3 bedrooms, 3 other rooms, 1 full bath and 2 half baths. We have it listed as all in average condition. We have 2 masonry fireplaces. We have 3 additional fixtures. It has a full basement of 1931 and a first floor of 1931. The grade is a B-. It has an attached garage of 728 square feet, an open porch of 80 square feet, and a screen porch of 156 square feet. On the back side of the record card, that page, it has a sketch of the house, the attachments. The next page is the market valuation detail.
For just a second. I'm just going to ask the board, because the only thing that's before us today is on the classification of the 2 acres, am I wrong about that?
You have to contest the full assessment, so I believe we need to discuss the improvements along with the land values, would be my opinion.
Okay, and I actually think that is not the approach, and I'll make my suggestion and then we can decide whether to go on. So my understanding is that if you're challenging valuation, you can't pick and choose improvements versus land. I don't understand that the challenge before us is to valuation. He's saying the valuation is fine, but you take that valuation and divide it in half if we reclassify the property the way he wants us to reclassify it. So the only question before us is, do we have this 2 acres wrongly classified, or is it rightly classified based on?
And if you'll let me finish, I think you'll have your answer.
Okay, because I think that's, instead of going through the.
Well, we also have to instill that anything further is, if this goes further, that we've done this process appropriately also.
Okay.
So.
Please continue.
Okay.
We all realize this is an unusual situation,
Mhm.
and I can tell you the solution to it. but from my previous experience, I know what's going to happen, or should happen. So please continue. We need to have a complete record.
Okay, so the replacement cost new of the improvements was $371,458, less depreciation of $175,960, market adjustments, and then the total value for the improvements are $236,600. Of the home, and then of the detached building, that value comes to $4,400. The next map shows the subject property. So it's located on County Road MM, right at where intersection of Haight Farm Road comes into that. The comps on here are near here. Two are close, and one is much further away down near County Road M and County MM. We've included comparable properties. They're not, these are not top properties that you typically have a whole lot of comparables on, but we've included them for your information. The first comparable is 2723. It's kind of kitty corner from his property. Sale date was August of 19 at $401,000. The comparable value is $418,500. There's another property on County Highway M, 4980. That was sold in November of 19 for $283,500. When adjusted, it comes to $386,000. Comparison 3, 4870 Goodland Park Road. That sold in March of 19 for $297,500. The comparable, when that sale price is adjusted, it comes in at $438,200. I'd like to show further down in the comps some of these other it'll show the adjustments for the acres of the site, and being he has swamp, these other properties do not have another land classification on them. They're all residential. Okay, so then we've included a couple sheets out of the 2020 Agricultural Assessment Guide for Wisconsin property owners. It shows just some examples of how you would classify each area of a property. So I want to make sure I get to the right example that I wanted to think about. Yeah, so I wanted to, each of these kind of gives different scenarios, and we only included a couple because we don't want to print out the whole guide. But like figure 5 shows that you have each area, you have a 1 acre residential area, and then you would have and that's on page 18, sorry. There is part of that parcel is classified as class 2, 10.5 acres. Part of it is classified as residential, and that's 1 acre. And then you have an undeveloped area of 1 acre and an undeveloped area of 2 acres. So there's different types of undeveloped classifications. And they just describe that example as a horse boarding stable, horse pasture, riding areas, and corral. So figure 5 shows a house on a 30.5 acre parcel that was previously classified residential. The owner recently built a horse boarding stable and corrals for pasturing horses that are boarded at the facility. 8 acres of the property is devoted to pasturing the horses. 2.5 acres are devoted to boarding, training, and support of the operations. So it talks about agricultural use. Raising horses is considered an agricultural use under NAC's manual, established that provide fowl rearing, health maintenance, control, feeding, and harvesting are considered an agricultural use. And then it just describes why you would classify things the way that you would classify them on that. So Sorry, this one is really unique, so we're kind of going off kilter. It is a non-conforming use, as he stated. The way I understand it is we should be classifying those 2 acres as residential. He has a home on it. In my opinion, it should not be undeveloped because it has the house on it, and it would not qualify, in my opinion, under undeveloped. So, all right, so in summary, there is not a recent arm's length sale of the subject property. Consistent with the Wisconsin Property Assessment Manual, we prepared a mass appraisal assessment of the property using a valuation model based on Volume 2 of the manual in 2019 arm's length sales. That mass appraisal assessment is supported and validated utilizing recent arm's length sales of reasonably comparable properties, adjusted for differences between them and the subject property. Thank you. That concludes my presentation.
Thank you, Amy.
All right, so I have a question about, thank you for sharing this. I was actually reading part of this agricultural assessment guide at 10 o'clock last night, so that was yay rabbit hole. So I'm curious what your way of measuring the footprint of the homestead area, the house and adjacent building and driveway and everything, was based on aerial photos, and I'm guessing the driveway area was part of that?
Yes.
2 acres? And in some of these examples given, they have, undeveloped land is right of way for a strip of land that doesn't look like it's very deep. Is there any of this property in question that is a setback from the road or anything like that that's zoned as undeveloped land?
No, there is I'm trying to remember where it is in the manual, but there is a section that we had a conversation with Revenue about, and they stated that the road right-of-way would, in many of the rural properties, that their legal description will go maybe to the center line of the road. Even though we all drive on that road, it will go to the center line. If that road is adjacent to ag land, that's when we should be classifying it as road right-of-way. And I may not have included that picture, but there is actually an example. Yeah, there is an example of that. On page 16, under Figure 2, Example 2, they actually show where, in this case, it has an agricultural site, the house. So number Z is the other category, or Class 7, and that area there is 2 acres. They have their tillable right behind that, and that tillable, so they're only including the area up to that residential site, and only that front portion up until that triangle is considered their road right-of-way on that example.
Okay, is everybody thoroughly confused?
Then you understand.
I'm finally getting the picture. You want the 2 acres where your residential property is situated, valued the same as the 19 acres of swampland at $2,000 an acre. Is that correct?
Yes, because it's mapped and zoned as 100% wetlands.
Okay, that's not going to happen.
And I'm prevented from doing any construction or building or anything, so it can't be.
We understand you have restrictions. The restrictions are such that you have a situation that's somewhat unique, in that you have a property that you're living in, which has basically a non-conforming use if you can't do anything beyond what you're currently doing with the property because of the flood zone, floodplain mapping and situation. Unfortunately, we look at what the law provides. And the law provides that the assessor shall value that building site, in this case approximately 2 acres, at what they consider to be a reasonable value under those restrictions, knowing that those restrictions exist. In this particular example, the assessor felt that the restrictions, since you've lived there for 32 years, allowed you to continue to use that and sell the property under those restrictions as it's currently being used. So if the situation changes and there's significant damage to the property, that might change your situation as far as what the value of the property is that you could ask somebody to pay for it. So I've seen this several times where the property is of such where it has deed restrictions or other limitations, yet there's an existing structure that can be used for its current and primary purpose, in this case residential, and the land underneath it at some point is either going to divert back to a government agency, or it's going to be valued for next to nothing because there's no longer a 2-acre residential site, and it's going to be considered something that may be better for the county to own or for a public entity to own, like some of the conservation groups we have in Wisconsin, than for a private party to own it because it's going to protect the environment more so than just giving you satisfaction of having a place to live. The laws require the assessor to value the property uniformly, and they have by looking at your property and determining that a reasonable amount of acreage, as we think is reasonable, is around 2 acres. And they value that 2 acres under the current guidelines of the law, saying that 2 acres has a value of X. Added to that, they've added the 19 acres of swampland at $2,000 an acre, plus the value of your improvements. So I think we're in a situation where, yes, there's restrictions, but until you want to sell that property, those restrictions do not stop the assessor from valuing it comparably to other property in the city. So unfortunately, I think that's where we're going to be, that we're going to have an assessment that's reflective of the law, and the law says this is the way the assessor must do it, as she's pointed out from the assessment guide, and we cannot reduce the value, in my opinion. There's still 4 other members here to have their opinion, to $2,000 an acre for all 20-plus acres, because the law doesn't provide and allow us to do that. Certainly reasonable that you change 6 acres to 2 acres, but to change all 21.9 acres to swamp and waste at $2,000 an acre is not reasonable, in my opinion, to reflect the current market value of the property. Along with that, you have not presented us any specific information. If we had a specific official detailed floodplain map so we could see exactly, and those maps are available through public agencies, where the floodplain lies and how it affects the usability of the 2 acres where your home site is, that would have been extremely helpful. To try and guess that you have 1.5 acres or 2 acres or whatever you felt is reasonable without a survey or some accurate measurement makes it pretty difficult for us to try and conclude, is it reasonable, the value that she has based on the estimated acreage. Assessor did the best she could from the evidence of information available, and that was personal discussion with you, and you can see she considered what you said. She reduced it from 6 acres to 2 acres. She could have left it at 6, and she didn't have to do that. She felt you were reasonable in your request. So here we are. What do? We have no market information from you. We have a land classification issue, basically, that you feel the land is improperly classified because of the restrictions that it's under for swamp and waste from the, I don't know if it's DNR or Bureau of Land Management or who has the authority over that particular watershed. It could be the Wisconsin DNR, I'm not sure. But that has an impact on how you can use the land, no question. But it's going to happen after you basically can no longer live in that property. As long as you still can, you have the rights to use that property as you have been and can continue to until it's damaged to the point where you can't. And that also gives you the right to sell that property. So as a property owner, we have to look at your rights of ownership. And your rights of ownership are continuing even though there's an encumbrance on that land for the floodplain application. So until that happens, where you go down here to the lake where it's 900 acres when it used to be 32 acres, that's an imposition, and that property is going to be considered and adjusted because of that. When that happens to yours, I'm sure the assessor will be doing the same. And when that residential site is no longer usable, she'll do the same for you, or whoever's in the assessor's office, to make it reasonable to reflect your current available use of the property, as well as then to adjust the value accordingly. Does that make sense for you?
Yes, it does.
I
Thank you.
mean, I had the same family situation. My father-in-law owned property along the Wisconsin River. In this case, they gave DNR an easement, and that easement forever perpetuated the non-development of that property along, a quarter mile of the Wisconsin River. And why? Because it basically flooded half the time. It looked very similar to your property, and the part of the year you could walk on it. The rest of the year you couldn't, depending on how the water levels were. It was basically, a piece of worthless land. The assessor has your land that's in that category, probably the lowest assessed value she could put on it at $2,000 an acre. And I tell you, from my experience, that's pretty cheap. Because I've seen hunting land throughout the southern part of the state of Wisconsin sell for much more than that over my career. So at $2,000 an acre, I don't think there's any difference of opinion. That's probably the lowest price she'd put on it. And I know if you wanted to sell it to Dane County, you could probably ask 5 times that and get it, because they like to buy that swamp and waste. Because it protects the watershed, the public good, right? You're protecting the public good. And we're asking you to pay a small token at $2,000 an acre tax to protect the public good. So we should be thanking you for that. But when it comes to the house and the 2 acres, I think what the assessor's done is fair and equitable, and it's reasonable based on what the law requires her to do. So we can't put your 2 acres of residential back to swamp and waste, because it's not. Its actual primary use is what you're using it for. Access to your property. I'm sure you have as well and septic on the property, structure, and storage. That's what any residential property owner would hope to do with the property. It's exactly what you're doing. You're using it as intended, and until a time comes where you can't use it as intended, that's when you'd have a stronger argument to have that changed. So, based on our discussion, and it's been a lengthy one, and thank you everyone for dealing with this and sitting through it with me. At this point, as I said before, we have no specific evidence from the property owner as to the value of the residence in the 2 acres or the 19 acres of swamp and waste. The assessor has done, I think, an adequate job of detailing how she valued the property for us in comparable sales. And the only thing I didn't see in her information is, was there any kind of impact that she looked at for the 2 acres as far as the restrictions on your property, if and when that time comes. Hopefully that'll be long after you want to use it. You'll have somebody else who will use it and enjoy it and have the privacy that you have on that site. But I don't think we have enough information today from you to cross that threshold of the burden of proof to show that the assessor has done something wrong and that we should be adjusting your value. So with that said, I'm going to make a motion to the board to sustain the assessor's value on this property at the current value, recognizing that there's usable limitations on the property, but the value represents and recognizes most of those limitations as it currently stands on January 1st of 2020. And that's another key factor, is what was it on January 1st? So until there's greater restrictions on your use of the property, I think what the assessor has done is fair and equitable and should be sustained. So I'm going to make a motion that we sustain the 2020 assessment on this parcel at the current value as provided by the assessor at, and I don't have the exact number because my computer's $383,500. Hearing that motion, I'd ask for a second.
Second?
Any discussion? Hearing none, I'll call a vote. All those in favor signify by saying aye.
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 Opposed? Please let the record indicate a unanimous decision. And Mr. Sorensen, thank you for your patience with us. It's an unusual issue. As you can see, it's not something that typically comes before the board. And it's certainly something that, as we look at it, it creates lots of questions in our mind as to what's the proper approach to handle this property. So thank you for your patience with us. And as I pointed out to every other property owner who's come in here today, the clerk is going to prepare and give you a determination. And on the back of that determination, if you're not happy with our decision, there are additional appeal rights that you can use to continue the appeal process of the assessment. So thank you very much for coming in today.
Thank you, and I would like to see you take measurements and determine, what you think would be a fair area of land to be zoned residential for your house, and talk with the assessor's office about that before next year, because I think that would be helpful. If 2 acres isn't the right amount, then what is?
Thank you. Thank you for your work, Amy.
Interesting case, thank you. Our agenda for today.
You said you wanted us to take a look at our calendars. Thank you.
That's correct. That would be the next thing to talk about, is the possibility of another meeting date, and we need to have that on the record before we close the meeting to our, we're not going to adjourn permanently, but we're going to adjourn to a later date. I guess I'm wondering what days of the week work best for most people.
There's no particular day of the week, but later in October is better for me, but probably not better for the city clerk, so. I also want to allow sufficient time to get some of the paperwork in for some of these properties for our next meeting date. Trying to have another meeting next week, I think, would be premature.
It would depend on what you're, you could hear all of the outlots and the ag parcel earlier. The commercial is what we would prefer additional time, because if we do need to subpoena, which I'm pretty sure some of the properties will need to subpoena information, for us just to get the subpoenas out, it may be Wednesday is what we were hoping, is to get through that by Wednesday of next week. And then we would have to give them, I believe we discussed like requesting 10 days for them to review things, and then give us, a week to review what they give us back. So, that would be looking at 3 weeks out for the commercial, but there's a lot on here, a lot. So the ag properties would, between the ag parcels and those outlots, that would be a lot to go through anyways in a day. So I would think you would need to be looking at least 2 days of coming back, so you could do the egg early and then put out the commercial, like 3 weeks or so.
I hear you saying if we do the ag parcels first.
You could, the last ones that we discussed.
Right, item 15
Yep.
on our agenda.
All of the outlots and the ag, that's kind of how we group them on here, so that you could kind of think through them all at one time. The outlots, they're all unimproved, so those will go quickly. But that in itself would be a half day to a day, depending on how you approach the outlots in each subdivision. So if you hear it as one case or separate cases, I'm not sure how you will decide that.
So if we did that, we'd be back, and if you needed subpoenas, we'd be here so we could help you with that as well?
Yes, yep.
Oh, you're thinking next week?
Oh, please.
With this COVID situation, my calendar is pretty much cleared, except for a family matter, and I'm not sure when that's going to take place.
I have the opposite problem, but we shouldn't base the schedule solely on my schedule, but next week would be very difficult for me. I could possibly do a day the following week.
And also, depending on what everybody is, a quorum is 3, so, it wouldn't have to be the exact same numbers that are here today, because these will be different cases you'll be hearing.
Right.
So who's here for the commercial day might be different than who's here for the ag.
We can share the load.
Yep, share the load. You can split half days, however we can expedite the process. I would recommend we expedite the process.
Well, I'd like to get at least part of it done as quick as possible.
Notice is 48 hours, correct? So if we set it for sometime next week, it would need to be, I mean, notice would be going out on Monday, so it couldn't be any earlier than Wednesday or Thursday of next week, correct?
Probably have to be Thursday because if notice goes out first thing Monday morning, excuse me, all the notices. Sorry.
And notices can be given email. They don't need to necessarily be mailed, which would save a timeline
make it
too. So don't take the mail into account.
No.
We all know how the mail is working. So.
No, so I guess what I'm hearing is the earliest would be end of next week, Thursday or Friday, and I would not be available then. I don't know if any other members of the board would be available then.
I know at our previous meeting, when you were determining this date, Alton Krim had recommended Fridays because they work for him. Unfortunately, this Friday ended up not working for him.
Irony.
So that's an option too. We could do the 25th, and then if you wanted to stick to that theme of Fridays, and Amy, you were thinking of 3 weeks, then that would take us into the 9th of October for commercial. So we do possibly the 25th for the ag and the outlots, and then the 9th for commercial. They're based on Elton's past comment at the previous meeting for Fridays.
Would it be helpful if we started at 1 o'clock in the afternoon on Friday instead of 9 o'clock in the morning? And there's nothing saying we have to quit at 5 o'clock if we had.
And it's my understanding that the outlets should only take about 15 minutes apiece. Is usually the allotted time, so.
Yeah, and you potentially could group some of those depending on, which ones. Terravesa, it's one whole thing. But yeah, we have no improvements to discuss. It's just the outlot value on each one.
Okay.
So what was it? So the waiver?
Friday the 25th at 1 o'clock work for most of you?
Yeah, I won't be able to attend, but October 9th for the commercial, but I have a prior commitment next Friday.
Same here.
How about Thursday?
That would work. I'm pretty flexible otherwise.
Yeah, me too.
Can I step in, Jeremy from Fact TV?
Yeah.
There are stuff booked in here, unfortunately, in the later part of Thursday, so you'd have to be done by 3. We're kind of struggling with all the meetings being in here with COVID, so
Right. I would think.
trying to watch all the dates for you.
Yeah, I would think on Thursday, the 24th, if it's just the outlots, you guys would be done by 3, but if you started at 9 rather than at 1.
Thursday the 24th at 9 o'clock?
Richard, how about you?
Rooms available?
I got nothing to do.
No,
Does that give the clerk enough time to get the notices prepared and mailed?
Yes. Yep. I would just.
We have to remember there's an election coming up, and that's
Right.
what it takes a little time too.
That's why the earlier the better, because once we get into the heart of October is in-person absentee voting. And
Could you guys do 10 a.m. on the 24th? So you got CETA in here in the morning. Go figure.
Oh, so 9 a.m. wouldn't work either.
We could do 10 a.m. Yeah, they tend to run over, so
Okay.
the room would free up. It's supposed to be done at 9, but I think you'd want to give a cushion to that group because they, again, tend to go over. So it'd be the 24th at 10, between 10 and 3, essentially.
Works for me.
I can do that.
Yeah, I'm good. I'm an alternate, so if everybody shows up, I'll just go home.
And also
I won't
check,
be here, no worries.
also check your calendars for October 9th. And if we can, we'll work that in to start the commercial appeals.
I should be able to do October 9th.
Yeah, that works for me, as far as I know.
And since we now have a vice chair, if I can't make it, we've got something.
Yeah, and then October 9th, will that be 9 AM again, just so that we can have a full day to try to get through as many commercial properties?
Well, we have a long list of commercial properties, so yeah, probably the sooner the better.
And, I'm sorry, I forget your name because you don't have a name tag up. Friendly
Oh,
AV.
Jeremy.
Oh,
person.
Jeremy, sorry, Jeremy FacTV. Yep, that day is wide open.
Okay. Well, it's not anymore.
We'll call it booked.
And then if it looks like October 9th isn't going to work for whatever reason, we can reschedule via email. But
So if you can have a reasonable idea of the number of subpoenas you might need by the 24th, that would be very helpful.
Yep, yep. We should be able to have those ready. And I know, like Amy said, you know, as long as the chair could come in and sign them without that. So she talked about having, hopefully by Wednesday, so we'll talk through everything, get those ready.
Okay?
They could be signed then, and then we will work on an aggressive schedule to get it all done.
What is the, what's the deadline for them to return information requested by the subpoena?
Well, last year it was much longer, but Attorney Seibel, she said that's not typical. She said typically it's 10 days is all you would give someone, and then you typically give the assessor about a week. So that would be right at that time frame for that, right, Nick? You got your phone out again? He's got a calendar on him, I don't.
Okay. So you have those going out next Wednesday.
Yep, if they went out next Wednesday or Thursday, you know, if we could have the board sign them right away, probably Thursday if we're meeting already Thursday. So that would give us that time to allow to review those, signed, and they can be noticed. Amy would take care of that on the 24th. And if you gave them the 10 days,
it's 10 days, not 10 business days, right?
that's what she said, it's usually 10 days.
Okay.
She didn't say 10 business days, she told me 10 days.
So then they have to get their stuff back on the 5th.
Yep, and then we would have, you know, we would just look at what they subpoenaed that week and push, if, you know, if the 9th works for everyone, you know, the 9th or the 16th, whichever would work for you.
Or the 16th, sure.
Please make sure it's clear that it's days, not business days, so that there's no
Yeah.
question that somebody comes and
Okay.
says, oh,
Right.
you didn't say 10 calendar days instead of 10 business days.
Oh, Amy will have that specified. The
Yeah.
only
Good.
thing would be then is, if I don't know right now, are people available the 16th instead of the 9th?
The 16th would be better for me.
I would be available either day.
That should work for me too, as far as I know right now.
Okay, do we need to decide, do you need to decide the 9th and the 16th now, or just at the next meeting?
At the next meeting, people can check their calendars, and I guess I'd ask that we have the room tentatively booked for those 2 dates, so that we don't get bumped out because we didn't put our name on the schedule. And it might be that we'll be here both days for the commercial properties, because there are quite a few of them.
Yes, and we believe many of the properties are all with the same attorney, and typically they ask for waivers right to circuit court. So it could be a very quick process, and only a couple that you would hear. Other ones, it, you know, might all get waived right into circuit court.
So I think we should have these hearings at Reinhardt's building, so that way we don't have to eat up city property, you know, and use up room space, and then Reinhardt can host us. No, I'm kidding.
Okay,
We have a nice building, what?
we've completed our daily agenda. Thank you very much for putting in a long day with me. At this point then, we will close today's meeting and we will reconvene at 10 o'clock on the 24th of this month in this room. And if there's any challenges or changes with that, please let us know as soon as we can so that we can adjust our schedules accordingly.
All right, I move to end the meeting.
We have a motion to end today's meeting. Do I have a second?
Second.
Motion and a second. All in favor signify by saying aye.
Aye.
Let's go.